ನಮ್ಮ ಡೇಟ್ ಹೋಗಿಲ್ಲ. ನಮ್ಮ ಮೊನ್ನೆ ಡೇಟ್ ಹಾಕಿದ್ರೆ ಡೇಟ್ ಇಲ್ಲ ಅಂತ ಬರ್ತಿದ್ದೀನಿ ನಾನು. ಡೇಟ್ ಹಾಕಿಲ್ಲ.
ಮೇಡಮ್ ವಿತ್ಡ್ರಾವಲ್ ನಾಳೆಗೆ ಬೇಕು. ಹಾಕಿದ್ದೀನಿ ಮೇಲೆ ಬರುತ್ತೆ. ಆಯ್ತು, ಹಾಕಿದ್ದೀನಿ, ಆಲ್ರೆಡಿ ಹಾಕಿದ್ದೀವಿ. ಹಾಂ, ನಾಳೆಗೆ ಮೇಡಮ್.
ಮೇಡಮ್
ಕಳಿಸಿ
ಮೇಡಮ್
Only 230 matters. Yes.
My lord, yesterday restoration order was passed, my lord. My lord, he is not restoring, even though my counterpart have informed him telephonically. He insists for a copy. We have tried to show him YouTube also. He is not accepting. You will make a copy or internet will borrow.
You will get it by afternoon.
My lord,
If what order? Again 2:30 only you want. By the time they will type the order. It happened in the afternoon, right? In the evening.
operative portion of the final order, one internet.
Final order itself will be done by afternoon. Yes.
List
May
number
I just
one.
give the number?
Yes.
For the sake
Send
of
it to the
number.
chamber.
Li-
Yes.
List number, serial number 46. Serial is in station, out of station, 1 week.
No mentionings. I said only 230 matters. Yes, call the list. All other mentioning slips to the court. Why? Huh? When was the writ petition filed? If office objections are complied, then only it will come. Even if I don't tell also, it will come.
Tomorrow office ex parte order has been for the public office. There was great ex parte order has been passed.
It's 230.
My lord, list 239, my lord.
Give the memo to the court officer, telling the urgency. And if I feel this is urgent, I will take it up. If I do not feel that it is urgent, I will write on the memo that you will know. So don't waste the court's time.
That's list number 2, serial number 15. I given a detailed memo. Thereafter, it is
What is urgency? That is not the urgency at all.
they are the previous order is passed for 2 days. Already supported after 4 days. And then from the event, because there is a Supreme Court order.
Now, that has come up in the list. Let it come. I will see. Let's see.
My lord, one matter for being spoken to, my lord. Your lordship has
Why do you want to mention it? Please tell me.
My lord.
Why do you want to mention it? I'm specifically saying give the memos to the court officer.
Please.
Call the list. We'll see.
For the petitioner, I appear for the petitioner, my lord.
This is not the order. The order impugned dated 10/11/2025 is set aside. The trial court shall not proceed with the execution. In the light of the fact that the order of the decree transfer petition by the RERA has been recalled by order dated 17/11/2025, the petitioner shall file an appropriate application for the executing court to close the execution proceedings as the order itself has been recalled. Accordingly, writ petitions are allowed.
Much obliged.
The order dated 3/6/2021 passed by the additional civil judge in the MFC, Ramnagara is set aside and the matter is remanded back to the trial court. The trial court shall consider the same in accordance with law within a period of 4 weeks from the date of receipt of the copy of the order. Accordingly, writ petition is allowed.
Please.
Please, sir.
Yes.
This matter was specifically posted so that it could be disposed of.
Yes.
Please, sir. Plaintiff's writ petition, man.
Yes.
Challenging the order passed by the learned trial judge on IA number 3 as well as my lord IA number 1. 2 MAs were filed and both came to be dismissed. My lord, may I pass on the genealogy of the my lord of the parties?
What is the suit for?
Suit for declaration.
Partition.
Sorry, suit for partition and separate possession, as well as for declaration that my lord compromise entered into between another branch within their family member is not binding on the plaintiff.
And what is the injunction sought?
Not to alienate.
Not to alienate the property.
Alienate.
So before this, we'll just see the appellate court's order and then we'll go to
Madam, I will just show the genealogy. Madam.
Yes.
ನಮ್ದಿಲ್ಲ ಇದೆಯಲ್ಲ. ಹಾ ಇಲ್ಲ ಇಲ್ಲ. ನೋಡಿ, one Moodalaya is the propositors. Branch of Venkatappa are the plaintiffs. Venkatappa are the plaintiffs.
Yes.
Timmaya and my lord, Timmaya is no more. His, my lord, his family members, his sons and daughters are the defendants.
They have entered into a compromise earlier.
The branch of Timmaya, my lord, the sons and daughters.
So now you say, no, now you want that that it is
Now,
not
my lord,
binding
the properties, my lord, it's a Inam land belonging to the family. The Timmaya files an application under the, my lord, under section 5 of Inam's Abolition Act. That application, in the very application, he mentions that it is Pitrarjita. May I just bring to
No,
your
that's why
lord?
what we do is, we'll first go to the order passed in the
Please,
May.
please.
Then you can make your submission so that the court will understand it in a better way.
Please.
Yes.
Then, my lord, 30678, page 11, page 35.
Yes.
Or the page 30, so that facts, my lord, I can.
No, I think you can come to page para 14.
14. I have considered the facts of this case and materials on record in the light of the said principles of law. The plaintiffs claim that one late Moodalaya had two sons by name Venkatappa and Timmai. The plaintiffs have also claimed that plaintiffs are the legal heirs of late Venkatappa, while the defendants are the legal heirs of Timmaya. The plaintiffs have also claimed that suit schedule properties are joint family properties of said Venkatappa and Timmaya, and there was no partition between Venkatappa and Timmaya in respect of the suit property. It is also claimed that when the plaintiffs approach the defendants for share in the suit schedule properties, the defendants have not given any share therein, but are trying to change the nature of the suit schedule properties and to alienate the suit properties to different persons, maybe. On the other hand, the defendants have not disputed the relationship between themselves and plaintiffs. However, the defendants have seriously disputed the fact that suit schedule properties are joint family properties. It is specifically contended by the defendants that suit schedule properties are self-acquired properties of late Timmai. It is further contended that Moodalaya had not possessed any agriculture or non-agriculture land in his name, and that Moodalaya was poor agriculture labor having no source of income for its livelihood. It is further contended that plaintiffs have filed this false suit for partition and separate possession only to harass the defendants. Though the plaintiffs have no right, title or interest over the suit property, in fact, Moodalaya had given 30 guntas of land in Hanumantasagara village to his brother Venkatappa, and the plaintiffs have already laid sites therein and sold the sites to others. The trial court.
Yes.
Para 15. Para 15.
Yes. I'm at para 17.
Para
17.
23.
17.
17. Please. In fact, if facts and circumstances of this are considered in the light of the above said principles of law, it is clear that defendants have produced copies of the registered sale deeds, which prima facie show that late Timmaya purchased the suit schedule properties on different dates during the period from 1931 to 66. Even his wife purchased some of the properties during the said period. These documents prima facie prove at this stage that suit schedule properties are the self-acquired properties of late Timmaya and his wife Srimati Hanumakka. On the other hand, plaintiffs have not produced any documents to show that khata of any of the suit properties stands in the name of late Moodalaya or in the name of Venkatappa at any point of time. Further, the plaintiffs have also not produced any documents to show that late Venkatappa or late Timmaya inherited any of the suit properties from his father Moodalaya. Even though there is a presumption that every Hindu family is joint, such presumption cannot be extended to any property as joint family property as held by the Honorable Supreme Court in the above said decision. The property which is purchased and stood in the name of late Timmaya or late Hanumakka cannot be said to be joint family property. unless plaintiffs prove that such properties were acquired out of joint family nucleus or income. Since there has been no property standing in the name of Moodlaya, there is no question of existence of joint family as such. There is no further question of acquisition of suit schedule properties out of income of joint family property. Therefore, the defendants have prima facie prove at this stage that suit schedule properties are self-acquired properties of late Timmaya and late Hanmakka, while the plaintiffs have prima facie failed to prove the suit schedule properties are joint family property. Even it is a prima facie clear that 30 guntas has been gifted to late Timmaya. However, these observations made this court by this order regarding nature of are not final, but only tentative to adjudicate this appeal. When the defendants have prima facie prove that suit schedule properties are self-acquired property, and when the plaintiffs have prima facie failed to prove that suit schedule properties are joint family property, it cannot be said that there is a prima facie case in favor of plaintiff. Therefore, the trial court has rightly concluded that plaintiffs have failed to make out a prima facie case with regard to IA number 3. Further, in view of dictum so and so, when the property failed to prima facie case to go for a trial, question of considering balance of irreparable loss and injury does not arise. Therefore, trial court has rightly held that point number 2 and 3 do not survive for consideration. When it is a prima facie clear that late Timmaya and his legal heirs defendants are absolute owners of suit schedule properties and that suit properties are self-acquired property,
I see.
then, my lord, we have produced, we sought to produce.
No, it is a case of the defendants that this Timmaya has purchased the properties by way of a registered sale deed.
Please.
It is, you are relying on some endorsement of the Inam abolition, the authorities under the
Please.
Inam abolition act.
Please.
Where is the question?
My lord, unfortunately, my lord, we did not have those documents. The application filed by Timmaya, my lord, for grant of the land, and also, my lord, the proceedings held before the special deputy commission. Those documents we sought to produce before the lower appellate court by filing an application under Order 41, Rule 27, Para 20.
That I've seen. I've read that also.
Two, three documents we have produced. In the application, may I draw your lordship?
No, what I want to know is, if it is an Inam land, it's a granted land, where is the question of sale?
But if it is granted to one member of the family, he says it is a Pitrarjita. That means ancestral property.
No, that is your case. The court records a finding that there is a sale deed. Where is the question of sale
But
deed? Where
all
will the sale deed
properties
will
under
come?
Section 5 of the Inam's Abolition Act are vested in the state government.
No, that I understand. Sale deed from whom he has
Sale
purchased.
deeds, my lord, it is purchased out of joint family income.
That has to be established.
That is a matter which has to be gone into. My lord, as of
And
now,
all this are way back in the year 1956, 57, 60.
59, my lord, but there are documents we could not lay our hands. There are documents for my satisfaction. I will just show your lordship. My lord,
No, before that, you show the document, the sale deed that the court is referring to. That is more important than this document.
Sale deeds.
Sale deed.
Sale deeds we have not produced.
Yes, you have it. Where is it? Give that.
They have not.
Well, they have not supplied to us. Today, my lord, it is.
We should have served the documents to the other side.
Then I will have to.
No, anyhow, these documents are not new.
These were not produced.
No, before the trial court it is produced. Trial court makes a reference to that. That is why I am asking. There is a reference to the trial court order about the sale deed. So that's why the court has negatived your contention with regard to the grant and all.
But in view of Section 5 of the, my lord, Inam's Abolition Act, all sale deeds, my lord, will
That's a separate proceeding.
by operation of law. Now,
That
my
we
lord,
can't
it has,
consider all that at an interlocutory stage. That will be done after a full-fledged trial.
but all rights were Inamdar, my lord, including those, my lord, which shall vest in the state government.
No. All those aspects have to be considered in a different proceedings. Now, they are asserting their title by way of basing on a sale deed, which is of the year 1956 or 57. So, basing on that, according to them, it is the property of Timaya, and Timaya's children are entitled for that. According to you, it is a grant, Inam grant in the name of the family. Is your case?
And he, in his very application, he says it is ancestral properties.
But where is the sale deed? I'm asking.
So after sale, Lord, after
Act is 1956.
after 1956, my lord, the prescribed date.
It's a different aspect. I understand that.
Now,
all the property was
my
with
case is based on the, my lord, application filed by him.
Now, all this, you're basing your claim on a 1956 proceedings in the year 20. When is the suit filed?
Suit is filed, my lord, in 2020.
So it will
Madam,
be decided
Madam,
eventually.
Madam, for my satisfaction, I'll just show 2-3 documents.
You have to show me about this sale deed. He has
Sale deed.
purchased from whom? That I want to know.
Sale deed, my lord, he 1931, my lord, and onwards he and his wife have purchased out of joint family income.
That is the aspect which has to be decided, which has to be proved by you.
Now, my lord,
in
if
the course of the
my lord,
trial.
law is well settled that when it is granted to one member of the family, it inures to the benefit of other family members. Therefore, my lord, we have being the members of the another branch, we filed a suit for partition and separate possession. During the pendency of the suit, my lord, to preserve and protect the property, we sought for an unharmful order, not to alienate or not to change the nature of the land. If they are in possession, my lord, we are not interfering with their possession. Now, my lord, if the third party rights are created, my lord, then it becomes very difficult, my lord.
His brother is also given statement.
My lord, in the application, the English translation. Lord, Pitra, he says, my lord, ancestral. One. Then, my lord, he says, in very application, joint cultivation. In the very application, he says, it's a joint cultivation. And
1956 Inam abolition proceedings. 1936 sale deed.
Sale deed. For the very same lands, he files an application under the Inam Abolition Act. If he has not filed any application, my lord, then it would have been his self-acquired property. Now, nature of the properties, my lord, have changed.
It's been how many years? It's almost from the date of purchase. It is 100 years. Almost 100 years.
One report of the assistant commissioner, revenue inspector, which is in English, may I just draw your lordship's kind attention.
Page number.
Page 131, my lord.
Yes. Yes.
Report. These are the survey numbers which have been, my lord, purchased by him and his wife out of joint family income. The first 7 survey numbers, serial number so and so, both stand in the name of petitioner. They are his ancestral properties, and he is in possession and enjoyment of these lands. Therefore, he may be registered as occupants of Section 4 under Inam Abolition Act. So, therefore, my lord, the consent was given by the, my lord, predecessor in title of the petitioner to grant this land in his name. So, nature of the properties, whether it is a joint family property, whether it is a self-acquired properties, have to be gone in. But in the meanwhile, they enter into a compromise with themselves, between themselves, and, my lord, got a collusive decree. Therefore, my lord, we have sought for partition and separate possession, and also, my lord, we have sought for declaration. Declaration that those decrees are not binding. Those documents, my lord, we could not produce before the.
Come to page 133. 133. Read it, 133.
This is the 130. Relationship to them. Given
all these the Enam abolition Milord Act came in 1994 Act. But earlier to that, Timmaya has purchased certain properties and his wife has purchased, Hanumaka has purchased certain properties. But after the Enam abolition Act came into force, lands are vested with the state. They have to file an application, either a tenant or a landlord or whoever is the, that is the
This
law.
is your application.
This is the order.
Yes.
This is the report, this is the report.
The order sheet of order sheet. And it is cited with the next case.
Application is 119.
But all the documents, clearly page number 132 onwards make any read.
No, it says Timmaya claimed 2 acres 17 guntas and Veerappa has claimed 1 acre 17 guntas.
But only except that there is nothing else on record to show that the continuation.
So in that case, the trial court believing your sale deeds of 1936 in the light of the subsequent documents is not correct.
This fact is factually against the entire documents on record and the subsequent orders passed with the land in.
Then where are the subsequent orders?
So that is in page number 134.
130?
34. 134.
What it says?
Occupancy rights of in Hanumantana Sagara Dasanpur in Mangala. Petitioner is in this case is a permanent tenant as defined in the Mysore Enam Abolition Act. The definition of the permanent tenant Enam Abolition Act is wider than the Mysore Revenue Code. In this case, all the conditions necessary to waive payment of premium later
Efficiency
to the Act by the Mysore Act of 1959 are present, and hence the premium is waived. Hence, all the lands mentioned in the
No,
registered.
this order is in continuation of the earlier order.
Yes. Which one?
The earlier one which you read it 132.
The entire case is that they are the joint family members and acquired the property and joint family property. Both the brothers are at equal right. Is their entire case before the trial?
It is not there. It is what the document speaks. It is what the document speaks.
Sale deeds is the presumption. 1931 sale deeds. They are not 1931 when we purchased the property.
Then why were you saying that? Why this is what the application find? Page 131. The first 7 as numbers stand in the name of the petitioner.
Yes,
they are his ancestral properties and he is in possession.
Ancestral properties means father,
Sign ಮಾಡಿ
father,
memo.
father is their ancestor.
Memo
These
sign
are
ಮಾಡಿ.
these are presumption.
Sign
But ancestor is the
No, if that is the case, when an application is filed stating that brother is entitled for this much of extent, in fact, Timmaya 2 acres 17 and Veerappa it's for 1 acre 17 guntas.
no, your lordship application when we see the application they produced before.
Yes.
119.
Annexure 119.
Yes.
But all single number in the type the Kannada language.
Yes.
123 is the type copy.
Hmm.
If you read Milord is the first one is survey number 20/1. Timmaya will Mudlappa. That is Timmaya Milord is similar to Telugu language.
Then Venkatappa is there at serial number 7.
This only the survey number 7 they are claiming. Except survey nothing are the record to show that they have a right to the property. Even otherwise these properties they himself has admitted that these properties have been in the name of Timmaya in 1931-32 and thereafter Hanumaka is the wife, is the female property acquired by the, because it is not at all their pleadings in the trial court to show that in the entire plain governments out of joint family nucleus these properties have been purchased. There is no pleading.
In
Which
your,
are joint family
these
properties.
documents are part of record.
But these documents is only taking into consideration of this court cannot come to conclusion these are the joint family properties.
No, at the same time, court cannot come to the conclusion basing on earlier document
Because
and without considering the subsequent
the
proceedings.
Abolition Act is a separate enactment.
Correct.
And the benefit of endured goes to the joint family. That is under the Karnataka Land Revenue Act is different aspect and Enam Abolition Act is different.
Your own,
In the Enam Abolition Act,
your own statements are recorded.
so it is not the own statement.
Let there be a detailed inquiry on this.
For that only my submission before this honorable court is that the trial court Milord is trial court order make any look at.
What did it say?
Trial court order clearly indicates that the properties have been third party rights have been created and the entire maximum.
When were the properties sold?
This property sold in 2011-12-13. and a compromise decree was entered on 2011. Pursuant to that, some transactions have been layout has been formed and their purchasers in possession. That is the findings given by those are not parties before the court.
Where is the,
They are taken before the
where is the
court.
trial court order?
The trial court order may kindly look at page number 51. The reasoning part will not at page 55. Para 13. Hold on, the claim of the plaintiff is the suitable properties acquired by Mudalai is a grandfather and he has two children who are Venkappa and Timaya. Further, it is seen the Venkappa and dependents one to our branch of Timaya. There is no partition between so and so. And on the other hand, dependents who have filed return statement have not disputed the relationship between the plaintiff and Mudalai. But however, it is the contention suitable properties as certificate properties of Timaya. They have also taken a contention plaintiff has entered into compromise in OS 384 of 2011 by virtue of the compromise plaintiff cannot claim share. As per the above discussion, it is clear there is no dispute with regard to relationship.
ನಾವು alienation ಮಾಡೋದಿಲ್ಲಲ್ಲ.
They are the family members of joint family for the
Where is the plaint? I've seen that. Where is the plaint?
plaint lot kindly look at page number plaint is started at
59.
page,
59.
59.
59.
59.
Please kindly look at the paragraph 4 onwards. The plaintiff submits the plaintiff grandfather Mudalai had acquired the suitable properties by way of inheritance and succession. Where for this concern, various inheritance properties is not placed. Therefore, trial court held that 1931 statement is there. 54, 55, 59 statements are there. And self-acquisition, Mudalai name was entered in the index of lands and records of rights. The copy of the index of lands after the death of Mudalai, Venkappa and Timaya only legally succeed to civil property.
No, what has been stated in the plaint and what is the submission that is made before this court is completely like it's contrary.
Not-
Your plaint, you assert the title saying that more, what is his name? Modalaya.
That is the even that is the case of
Say that Modalaya,
Pitrarjita. That
that
means
revenue records are in his name. Where the records are in his name?
1960.
No records are in his name.
revenue records of Mudlaya's name is also one.
It is not there.
Mudlaya's name is
It is-
not found.
Your case is the plaintiff submits that the plaintiff's grandfather, Modalaya, had acquired the property by way of inheritance, succession and self-acquisition. Modalaya name was entered there. Now, this is contrary to the, what is pleaded before the court and what the documents are speaking. So without any basis, you have filed a suit first. Now you are developing the case after filing the suit.
We got the documents and subsequent that all the
Basing on which document you say that Modalaya had acquired the
my lord,
property
the revenue
by way of inheritance?
but the documents for which my lord occupancy rights were granted, but we have not produced before the trial court. We have produced, my lord, before the lower appellate court all those documents. Let the, my lord, court below consider it afresh, my lord. Let the court below, my lord, consider afresh.
Not a case. Please come.
My lord, may I submit one citation, my lord? If it is granted to one person,
Which is not applicable to the facts of this case. And that too, a person who comes to the court in the year 2020 without even saying that what is happening to these properties, whether they are enjoying the properties jointly, if they are enjoying what is nothing. Properties completely, the nature of the property is changed, layouts are formed. You are not aware of any of the things.
what there was some, it was layout, my lord, we have all produced the sale deed. Still it is, some of them are wake land. Let there not,
What are you
only thing is,
doing?
my lord,
What are you doing from the last?
only thing is, may I pray, my
100
lord? Let there not be any further alienation, my lord. Status quo may be maintained.
You are not a
This order is operating since 2024. My lord. This honorable court granted the interim order in the year January, if I am correct, January 24. It has been,
What are the reasons recorded by the court for granting an interim order in this case? Let us see.
please.
What is the reason why the court has granted interim order? Simple, till the next date of hearing, respondents are restrained from alienating the property. No reasons are recorded. When both the courts have granted such
Madam,
a
before-
elaborate order,
But before the lower appellate court, we have produced number of documents.
I have seen, I will record reasons why it is, why it can't be considered at this
Not,
stage.
may I make a respectful submission, alternate submission. Let the, my lord, lower appellate court consider, my lord, our application. Court says, my lord, the documents, we are not entitled to, my lord, to produce, or it is not, it's
Now I
not.
will consider those documents and pass an order. Now I will only consider this.
But application, it has been stated as Pitrarjita. Then, my lord, statement, it has been stated, my lord. Now, whatever rights are having, my lord, my rights will be seriously affected, my lord.
Not court, the court shall not come to the rescue of a litigant who comes to the court after 70 years and 100 years and always wants to, set everything at naught. That is not possible.
Now, as it
We
is,
can't
my lord,
ever
there
say-
is no change in the, my lord.
Let them do. If you're entitled, you're entitled. For that case, forever. No, see, 2024 writ petition is filed. 2026, you're enjoying an interim order in spite of two orders passed by, elaborate orders passed by the courts.
But the
It
court
is one
below
stroke.
has not, in one of the case, in other writ petition, 52 applies, therefore, my lord, we are not entitled.
Now, as far as this is concerned, I'll pass an order. The next one will.
50, same, both are same, my lord. One is IA for injunction, not to change the nature. Another is, my lord, on similar lines, both are same.
Then
Not to alienate and not to change the nature. Contentions are same.
the petition,
Therefore, madam, may I pass on this?
let's take the judgments also.
Could you ever go?
Yes.
These are all the citations, my lord, which, and if one occupancy rights is granted to one male member or one member of the family, it inures to the benefit. And in a suit for declaration and to preserve the property, my lord,
Which paragraph in first judgment?
Hmm? First, granted, my lord, to the eldest son, held.
Paragraph, which paragraph?
Held, paragraph.
This is the,
This, there are 15, my lord.
Yes. Then the next judgment,
Next judgment, paragraph 3.
that is the Purushottam
Purushottam. Adu ಏನು?
Nemani. That is very similar.
Very similar on the same lines.
all on the same line.
Only one judgment is to preserve the property.
Which case?
That is the sixth.
Sixth one,
Page number?
by Kumari Sunita.
Page number? You have given page numbers to this.
In that case, my lord, so that, my lord, till the trial is over, my lord, property may have to be preserved so as to, my lord, if third party rights are again created, it will lead to, my lord, multiplicity of proceedings. That is the sum and sum. Therefore, my lord,
1 minute, let me complete this. Which paragraph?
that we will give, my lord. Your lords may proceed.
Which judgment at least? What is the other? In which case?
But your lords may,
Yes.
judgment of one learned friend may be considered.
The first statement regarding the panel number 14,
Number 1857.
What is the ratio?
9
Yes, what is the ratio?
956. Page number 56 on tail. 56 is the 50, 57.
Not to interfere. Both the courts concurrent findings given by the.
Yes, next.
Next judgment, my lord, is at 2003, para 18.
Yes. Para?
Para number 18. With regard to the status of legal principles with regard to presumption of land.
That is
Page 20.
joint
Para
penalty.
18.
It is a burden lies on them to prove.
Yes, that is who is consulted to prove that which are the properties are joint family property. The
This is
person
the
asserting to
injunctions.
prove that,
Yes, yes, this is also set in law. Yes, next 2010.
Next, my lord, is at 2000, the last judgment, my lord, at page para 60.
This is regarding,
This was with regard to the injunction, my lord, is concerned. Both the
52.
courts concurrently, my lord, and para 16 is well said at page 26. In order to obtain an order of injunction, party proceeds to grant an injunction as to prove that he has made out a
Status quo to preserve ಅಂತ ಹೇಳಿ ಅದೇ ಇದೆ. ಇದೆಲ್ಲಿದೆ?
Yes, yes,
That
yes.
is Jalpat case.
Yes, which paragraph?
Page 64, my lord.
Page 64.
Section 52, my lord.
After a point, the page numbers are not given. Which judgment is that?
Just 52, my lord, suit for partition.
No, no, which case?
Kumari Sunita versus Manju.
2025 6 ILRA.
2025 ILRA 69. Head note itself. Parties have been directed to maintain status quo.
Which court is this?
Allahabad High Court.
Allahabad High Court.
That is
That's all.
Paragraph number?
52.
E9.
No, for this proposition, no Supreme Court judgment is available.
Okay, just now he brought, his junior brought in. Sorry, my lord.
Paragraph number?
9.
9.
Yes,
E9.
E9.
please come. What are those two IAs?
One is
One
not,
is not to alienate, another
Not to alienate and not to change the nature of the
Change the
property.
nature.
IA number 2, one is alienate.
not to alienate. First petition is my lord, not to change the nature of
Nature.
land. And
I understand. I'm asking generally about IA. IA 3,
yes,
not to change the nature of the petition.
alternate submission is one opportunity may be given before the law.
But I'm not convinced with this. The WCM, a common order in WP number 30678 and also WP number 30243 of 2024. These two writ petitions are arising out of a order passed in MA number, give the numbers, MA number 71 of 2022 and MA number? That I've already said, the other number,
71.
71 and 77. 71 and 77 of 2020. 70 and 71 of 2022, dated 13th August 2024 by the District and Session Judge and Special Judge, Bangalore Rural District. By which the Appellate Court has confirmed the orders that are passed in I number 1 and 2 and OS number in OS number 177 of 2020, dated, what is the date of the order in the
16 September 2022, page
16 September 2022? 16 September 2022.
And another order is 2 September 2022.
Huh?
Another order, my lord, on 2nd September 2022.
16 September and 2nd September 2022. The plaintiff before this, the petitioner before this court is the plaintiff in the suit. He has filed, where is the plaint?
Page 59.
59.
He has filed the suit.
Paragraph 6, page
Seeking the relief of declaration that the plaintiff is entitled for 1/12 within brackets half share in the sue scheduled property by meets and bounds, and to declare that the compromise decree that is dated OS number 384 of 2011 passed by the first additional senior civil judge Bangalore Rural District and compromise decree passed in OS number 191 of 2012 is fraudulent, collusive, and not binding on the plaintiff. It is the specific case of the plaintiff before the trial court that the grandfather of the plaintiff by name Modalaya had two sons by name Venkatappa and Timmaya. The plaintiff is son of Venkatappa. Timmaya had 4 sons and 3 daughters. The first defendant is wife of the first son of Venkatapaya. The defendants number 3 and 4 are son of are the children of another daughter. And defendant number 13 is the daughter of sons of one of the daughters of Timmaya. And defendant number 13 is daughter of granddaughter. Defendant number 5 to 10 are the legal heirs of Govindappa, that is one of the son. And defendant number 13 to 16 are the legal heirs of Ramaya, that is another son. The defendant number 11, 12, 17 and late Kodama are children of Timmaya. It is stated that the defendant number 18 to 21 are the subsequent purchasers, but not the family members. It is this case that the grandfather, Modalaya, had acquired the suit properties by way of inheritance, succession, and self-acquisition. His name was entered in the index of the land record of rights and the RTC extracts. After the death of Modalaya, Venkatappa and Timmaya are only the legal heirs succeeding to the scheduled property by way of inheritance, succession. The Modalaya has not executed any mode of registered, unregistered instruments in favor of any of his sons. He died leaving behind the properties to his sons. And the sons have acquired the right and title to the property. And they have cultivated the properties personally without any partition. And they have been in joint possession and enjoyment of the property. It is the case that after the death of Modalaya, the revenue entries transferred in the name of Timmaya with consent of Venkatappa, by reason that Timmaya had knowledge with regard to the payment of revenue and maintaining the revenue records in respect of the properties. It is stated that after the death of Timmaya, all the properties transferred in the name of his wife and children without the knowledge of the plaintiff. One property has been transferred the mutation in favor of the plaintiff, bearing survey number 7, measuring 30 guntas, but the plaintiff has no knowledge about the mutation proceedings. And also, the plaintiff states about how collusively the decree is obtained by the compromise decree is obtained by the members of the family. And it is the case that the properties are the Hindu undivided joint family properties. And as such, they are entitled for a share in the said properties. In the said suit, 2 applications are filed. I number 1 is not to alienate the property, and I number 2 is not to change the physical features of the property. That came to be dismissed by the trial court by orders dated that 2 orders I have said, September 2 orders, by orders dated so and so, wherein the court has observed that that there is no dispute with respect to relationship between the parties, and it cannot be inferred that they are the members of the joint family. And for that reason, at this stage, it cannot be decided that the scheduled properties of the joint family properties or self-expressed properties of individual in whose name Kata or sale deed is standing. And for that reason, the same requires recording of evidence. But however, it is pertinent to note that until joint family properties are partitioned by metes and bounds, no co-partner or individual member of joint family cannot claim exclusive possession over any property, and it is fundamental rule of law that no injunction can be granted against co-partner so as to exclude him from enjoying the portion of the property in his possession, unless it is shown that said person is attempting to dispossess the possession of another co-partner or he is interfering with possession of another co-partner, which is clearly obstruction to such co-partner for peaceful enjoyment of the property. And regarding the case on hand, it is clear that the defendants are in possession over the same. Further, the sale deeds produced by the defendants goes to show that some of the properties are sold in favor of third parties and they are in possession of the same, and they are not parties to the suit. And accordingly, the court has come to the conclusion that the petitioners are not entitled for the relief. The plaintiff petitioner is not entitled for the relief as sought for, and accordingly dismiss the applications aggrieved thereby. Two appeals are filed, that is MA number 70 and 71, which are also dismissed by confirming the order of the trial court by order dated 13th August 2024. Before the appellate court, the petitioner has filed an application under Order 41 Rule 27, and he has placed on record the documents. They are an endorsement dated 12/12/2023, copy of the sale agreement dated 28/6/2023, copy of the order sheet in case number 12 of 1959, and copy of the Inam abolition application by way of additional documents. The appellate court has observed that the late Timmaya has purchased the properties on different dates during the period from 1931 to 1966. Even his wife purchased some of the suit properties during the said period. These documents prima facie prove that the suit scheduled properties are the self-acquired properties of late Timmaya and his wife Srimati Hanumakka. On the other hand, the plaintiffs have not produced any document to show that Khata of any suit property stands in the name of late Modalaya or in the name of late Venkatappa at any point of time. Further, they have not produced any document to show that late Venkatappa or late Timmaya inherited any of the suit properties from his father. The court also observed that though there is a presumption that every Hindu family is joint, such presumption cannot be extended to any property as joint family property. The court has further held that the defendants at this stage of prima facie proved that the properties are self-acquired properties of late Timmaya and late Hanumakka, while the plaintiffs have prima facie failed to prove the suit properties or the joint family properties. In that, hence, court has held that there is balance of the prima facie case and there is balance of convenience and irreparable loss in favor of the defendant. Then coming to the application that's filed under Order 41 Rule 27, the court has observed that the documents, that is the endorsement dated 12/12/2023, the agreement of sale dated 28/6/2023, they're all after filing of the suit. When the plaintiffs have failed to make out a prima facie case, there is no question of consideration of irreparable loss and hardship. Then coming to the order sheet in case number 12 of 1959 and copy of the Inam abolition application, these documents show that late Modalaya submitted an application for regrant of some of the suit properties under the Inam Abolition Act. It is Timmaya, so that in the order it shows Timmaya submitted an application for regrant of some of the properties under the Inam Abolition Act, and Special Tehsildar for abolition of inams granted the said lands in favor of late Timmaya. These documents have been produced by appellants to show that Timmaya has given statement before the said authority. The suit properties or his ancestral properties. The appellants have sought to adduce these documents by way of additional evidence in the appeal to prove that the properties are the ancestral joint properties, and as such they are entitled to share in the said properties by way of partition and separate portion. The court observed that these documents are of the year 1959, and it is not the case of the appellant that they are not within the knowledge of the said documents at the time of filing of the suit. And the court observed that this could have been produced before the court. No proper explanation has been given to the appellant in this appeal for non-production of the documents. And the court held that there are no sufficient grounds to allow the said two documents by way of additional evidence. Even otherwise, if said two documents are permitted to be adduced by additional evidence, the said two documents are not helpful to the petitioner, appellants, to the plaintiffs. As the defendants have produced copies of the registered sale deed to show that late Timmaya had purchased the properties. Therefore, as the Timmaya has not inherited the suit property from his father, but the said properties are the self-acquired properties. Therefore, the court has dismissed the appeals and affirmed the order passed by the trial court. Agreed thereby, the petitioner is before this court. When this matter came up before a coordinate bench of this court, on 9/12/2024, the court has issued emergent notice, and an order was passed that till the next date of hearing, the respondents are restrained from alienating or encumbering or transferring any portion of the suit properties. That interim order passed on 9/12/2024 is extended from time to time and is continuing till date. Learned senior counsel representing the learned counsel, appearing on behalf of the learned counsel for the petitioner, submits that the property, the grant in the name of Timmaya is the application is made in the name of, as it is stated that it is an ancestral property, and in the name of the joint family, such a grant is given to Timmaya. In that case, it cannot be considered as a self-acquired property or a property belonging to Timmaya, but it is a property belonging to the joint family. When they have filed an application under Order 41 Rule 27 before the trial court, before the appellate court has failed to consider the said record placed before the court pertaining to the proceedings before the Inam abolition, the Tehsildar. It is submitted that on the face of it, the proceedings that are placed by the plaintiff shows that it is for the benefit of the joint family. In that case, unless and until the suit is decided and the rights of the parties are determined, if the properties are alienated or any third party rights are created, it would lead to multiplicity of proceedings. And to preserve the property, it is all the more necessary that the court ought to have passed the interim order as sought for, the interim injunction that is as sought for by the petitioner. It is submitted that the appellate court had failed to consider the documents that are placed before the court. That's the sum and substance. The senior counsel has relied on the judgments passed by the apex court in KV Sudarshan versus Ramakrishna and another, reported in 2008, 13 SCR 465, page, it's para number 16.
Yes.
He relied on para number 15. Then the next is 2000 judgment of the Allahabad High Court in Kumari Sunita versus Manju and others, reported in 2025 6 ILRA 69. He relied on paragraph number 68.
6E.
Huh?
6E. 6E, madam.
6E.
Yes.
He relied on paragraph number 6E. Relying on these judgments, it is submitted that the court ought to have allowed these applications, and the appellate, both the courts have failed to consider the case of the petitioner plaintiff in its proper perspective and in the light of the settled law. Next. When counsel appearing for the respondent defendant submits that both the courts have concurrently held that the petitioner, the plaintiff, could not make out a prima facie case. There is no balance of convenience in his favor, and no irreparable loss would be caused if the injunction is not granted. When the two courts have concurrently held, and this court, while exercising the jurisdiction under 227, cannot interfere with the same, it is submitted that the sale deeds are executed from the years 2011.
Salaries below 1931. Subsequent salaries
2011. The family has sold the properties from the year 2011. Now the third party rights are created, layout is formed, and in the layouts there are already constructions have come out.
Some portion of properties,
Huh?
some portion of survey number.
In some of the properties, already the constructions have come. It is submitted that when the defendants are placed before the court, the documents to show that Timmaya and his wife has inherited the properties, and subsequently, as that is the properties belonging to Timmaya, late Timmaya, his family has entered into a compromise, and basing on the compromise is already acted upon long compromise decree of the year
2011, same year, same 6 months, that was compromised.
2011 in 2000 compromises of the year 2011. It is submitted that now the suit is filed in the year 2020. Land Council submits that according to them they are in joint possession of the property, and the looking at the nature of the property and the compromise and the sale deeds that have the sale deeds that are executed clearly shows that there was never the plaintiffs and defendants were never in joint possession of the property. Now at this stage, basing on the said pleadings, if the interim injunction is granted, in fact, it would cause a lot of hardship to the defendants and to the other persons in who are in possession of the property. And the trial court and the appellate court had rightly appreciated the case and rightly refused to grant injunction. Land Council has relied on the judgment of the apex court in case of Vander Limited and other versus Antox India Private Limited, reported in 1990s SCC online SC 490, and he has relied on the judgment of the apex court in case of DS Lakshmaya. Now in this, as far as the judgment is, so extract that paragraph. It is stated that the appellate court shall not interfere with the exercise of discretion of the court of first instance and substitute its own discretion except where the discretion has been shown to have been exercised arbitrarily or capriciously or purposely. Then he has relied on another judgment of the apex court in case of DS Lakshmaya and others versus L. Balasubramanian, reported in 2003 10 SCC 310. He relied on paragraph number 18. Extract paragraph number 18. Relying on this judgment, it is submitted that there is no presumption that a property being a joint family property only on account of existence of the joint Hindu family. The one who asserts that it is a joint family property has to prove the same. He has relied on another judgment of the Supreme Court in case of Kashinath Samsthan and other versus Srimad Sudhindra Tirtha Swami and another, reported in 2010 1 SCC 689. He relied on paragraph number 16. He relied on this judgment to the effect that that in order to obtain injunction, what are the parameters for the grant of injunction? Relying on these judgments, it is submitted that the writ petition has to be dismissed. It is further before that, it is submitted that the petitioner is enjoying an interim order from 2024. And from the last 2 years, the petitioner is having a benefit of an interim order without any basis. Next part. Having heard the counsels on either side, whereas having the senior counsel for the petitioner and the counsel for the respondent, there is the material on record. The suit is filed seeking partition and also a declaration that the compromise decree entered into between the defendants is not binding on the plaintiff. In the plaintiff, it is a specific government that the one Modalaya, who is the grandfather of the plaintiffs and the defendants, is the owner of the property. His name is mutated in the revenue records, and later the defendant's father, Timmaya, late Timmaya, has made an application before the Tehsildar under the Revenue, under the Inam Abolition Act for a grant, and it is granted for the purpose of the joint family. And in those circumstances, it becomes the self-acquired property, it becomes the joint family property, hence they are entitled for partition. And they have also placed certain documents in the appeal to show about the proceedings of the Tehsildar. The appellate court has observed that these documents ought to have been placed before the court, before the trial court itself, and also gives a finding that even if those documents are considered, the petitioners are not, the plaintiff is not entitled for any for injunction, as he has failed to make out a prima facie case. While considering an application under Order 39, Rule 1 and 2, the court will not conduct a roving inquiry or a mini trial and give any findings with regard to the nature of the property and other things. Whatever the observations of the court are prima facie observations for the specific purpose of determining the dispute between the parties. The pleadings are Modalaya name is reflected in the revenue records, and the property, the grant that is in favor of Timmaya is for the benefit of.
Thereafter, amendment was made. The properties was acquired under the Inam Abolition Act. That order was referenced, and the amendment was allowed by the trial court.
That later amendment.
Yes, later
it is submitted that later they have made an amendment to the pleadings, stating that by way of a grant by the Inam Abolition under the Inam Abolition Act, the property is a joint family property. Even at this stage, this court is not inclined to go into these aspects. Inam abolition proceedings of the year 1956. Right from that time, even till now, the name of Timmaya, in all the revenue records, the name of Timmaya's name found place in all the revenue records. According to the defendants, they have been in exclusive possession of the property. According to the plaintiffs, both of them are in joint possession of the property. If that is the case, if the properties that are sold right from the year 2011, several transactions have taken place, several structures have come on in part of the as it got converted into a layout, several structures have come. Then what was the plaintiff doing right from 2011 is not known. Anyhow, he has come before the court in the year 2020 seeking assertion of his right. In those circumstances, merely basing on the Inam abolition proceedings, that prima facie he has established a case that it is a joint family property. Can the court grant an order of injunction restraining the parties from alienating or changing the nature of the suit scheduled properties? There is no there is no pleading or nothing is forthcoming, what was the plaintiff doing right from all these years? When even without even going to the other years, at least from 2011, when the sales have taken place and the third party rights have accrued, they have kept quiet and come to the court in the year 2020. The aspect, whether it is a self-acquired property or a joint family property, basing on the said one document placed before the court, it is difficult for the court at this juncture to come to a specific prima facie finding. The trial court and the appellate court, basing on the sale deeds and the subsequent sale deeds and the subsequent documents, that is the revenue records and other things, has rightly come to the conclusion that the plaintiff is not entitled for any injunction as sought for. The land counsel appearing for the petitioner has relied, representing the land counsel for the petitioner, has relied on certain judgments with regard to the Inam Abolition Act and also about preserving the property. There is no dispute about the said proposition. Every precedent has to be applied to the facts and circumstances of this case. In this case, in the considered opinion of the plaintiff has failed to prove the balance of convenience and irreparable loss, for the reason who has kept quiet when the third party rights have accrued from a long time, and looking at the initial pleadings and the amended pleadings, all the more strengthens the case of the defendant with regard to the requirements of granting an injunction. In that view of the matter, before that, as rightly, the land counsel has relied on the judgments which are referred to supra, and as rightly, and those judgments will apply to the facts of the case, and when both the courts have concurrently have held that the petitioner plaintiff is not entitled for injunction, and this court, unless comes to a specific conclusion that the discretion that is exercised by the court is perverse and not a judicial discretion, cannot interfere with the same. In that view of the matter, this court do not find any reasons to interfere with the orders passed by the courts below. Accordingly, the petition so and so is dismissed. It is made clear that this court has not made any observations on the merits of the matter, and it is only for the purpose of deciding the interlocutory applications. Any of the observations made by this court shall not be construed as an expression of the court. Then, with regard to the Order 41, Rule 27, the applications that are the documents that are filed before the court will not preclude the plaintiffs from making an appropriate application before the court to place those documents on record. All pending applications are closed.
Correct.
Yes, next. All applications are closed in the light of this.
Petitioner,
Yes.
Lord, I'm an objector in an execution proceedings. When the delivery warrant issued and when on the basis of delivery warrant, the decree holder tried to evict me from my property, I made a claim under section 47 before the executing court. After recording it, the executive court dismisses my application. I filed an appeal in the file because there was warrant is already in force. I sought for a stay. This particular decree holder was not on KV. He appears to have been watching the proceedings. Entered appearance before the appellate court and sought for time to file objection. That time was also granted. On the next date, he produced a certain document, and I insisted for stay because it is a first appeal. I am having a remedy of first appeal. I insisted on stay of the execution of the delivery warrant. The learned appellate judge, my lord, has said that I should give an opportunity for him to file objection. Against that order, my lord, I am before this court. Before proceeding further, my lord, on the merit, let the appellate court decide the case. Till then, the stay may kindly be continued. Appeal is still pending.
I'll ask the court to decide it within a reason. How much time? 1 month? 1 month?
Oh.
Huh? We'll say 1 month. The present writ petition is filed. Questioning the order dated 24/4/2025, passed by the senior civil judge Harias, sitting at Honali in RA number 34 of 2025. It is the petitioner herein is an objector. He has filed an application under section 47
Yes,
or order 21 rule
rule.
97.
2197.
Order 21 rule 97 as an objector, stating that he is in possession of the property, and now by virtue of this judgment and decree they are going to dispossess the petitioner. That came to be dismissed by the executing court. Against that, he has filed RA number 34 of 2025, and also he has sought for an interim order seeking stay of execution.
Please.
That came to be dismissed by the court.
No,
That
not
came to
dismissed.
be,
Postponed.
the court has issued, instead of considering the application that is filed seeking stay, has issued notice to the respondents. Agreed thereby, the petitioner has come.
Court has granted time for filing objections. Because they have already appeared.
Granted time for filing objections. Agreed thereby, the petitioner is before this court. And counsel for the petitioner submits that when an application is filed seeking an order as it is necessary, the facts of the case, as the execution petition is filed. And if the order is executed, the appeal itself will become infructuous. And these aspects were not considered by the court. When this matter came up for preliminary hearing, this court has directed the petitioner. Take out hand summons you have taken?
How handsome was also decided.
No, the
Hand summons was ordered, I have taken the hand.
taken hand summons and the counsel appearing for the respondent appeared. It is submitted that when the court has given permission to the respondent to file objection, they have already filed their objection.
No, they have not filed objection. They have appeared.
Huh? No. Now by this time you have filed. It is submitted that when the court has granted time for filing objection, there is not an order, and that against that he cannot come before this court filing the writ petition. Please, for having the counsels on this side, what is the material on the against an order passed by the trial court dismissing an application or 21 rule 97, when the petitioner has approached the appellate court ought to have considered the application that is filed as it is the case of the appellant petitioner herein that they're going to execute the decree, and the court has given time for filing objection. However, considering the fact that the respondent is also ready to go ahead with the proceedings, and that he will not precipitate till the orders are passed by the court. This court deems it appropriate to. It's an interlock. It's only IA.
Pardon?
It's only IA. Then we'll ask it within 1 week to decide. IA is not a.
That's what they may continue. Appeal may be disposed of.
Considering the same, this court has passed the following order. The writ petition is disposed of, directing the trial court to consider the IA within a period of 10 days from the date of receipt of the copy of the order, and till such time the respondent shall not precipitate the execution.
Please.
No, it's the
This matter came up yesterday.
yesterday and day before.
Then why? Yesterday your colleague has asked for time and she will get instructions today. Huh? And then I'll first grant interim order. Conveniently, you can come and file your, because it is too much. not necessary. Please argue your matter. When I'm giving time to the respondents, 2 times the matter has come up. Yesterday your colleague comes, I specifically told her she should come up with the instructions. Again, as if like nothing has happened, you come and ask for time. You argue.
Please, Lord, I am not the lessee in respect of the premises. Lord, in
Come
2019,
to the first prayer. What is the prayer?
prayer, Lord, at page 28, the sought for their demand notices to be quashed. Now, what they're doing is, Lord, they're issuing 2 bills. Lord, one bill, they say you pay whatever is due per the month you pay. Other bill they send, they say there is a due of the erstwhile occupier. His amount is still pending. If you feel you're liable, you pay that amount. If not, you pay the second bill. This they continuously send these bills, Lord. This dispute arises a very short issue, Lord. There is a
For a lessee.
I am a lessee. Now, Lord, this dues of the year, my lease deed is subsequent. July 2019, not for 1 month, there is supply of power made not by one to Vijaya Steels by one Baruka Power. In that regard, Lord, there is a dispute which is now presently pending before APTEL as to Lord, whether BESCOM is entitled for that amount or not Baruka is entitled for that amount. Now, Lord, this Vijaya Steels is already under liquidation and there's already not an IBC proceedings and there's an order passed not by the IBC, the NCLT, with regard approving the resolution plan. Lord, there are multiple other disputes. I will not trouble the court with that. Now, Lord, their only case is that amount which is payable, about 2 crores odd, you have to give it from the amount that you have to pay to us. I'll just show you the translated copy of their demand notice if my lords would turn to.
Oh, what will happen to those dues?
But that is between them, Lord.
Who?
No, between Lord Vijaya Steels, Lord, is the one who is supposed to pay this.
Who has lent you, who has given you this property?
This property is given by Vikas Alloy, who is a subsequent purchaser. Not this company.
How that issue
Please
has to
not.
be decided? Who has to, ultimately, if the person who has given the property on lease is the one who has purchased the property from the earlier person.
Yes.
And in respect of the premises, there is some amount due.
No, Lord, it is not in that case. Lord, what has happened is whether Lord Vijaya Steels is liable to pay to Baruka or to BESCOM, that issue is pending before APTEL. Because Lord, the supply is for a period of 1 month. That's true, not in the year 2019.
Where is that?
Lord, if my lords would turn to Lord the order of APTEL, can I request my lords to please turn to page Lord 142.
Yes.
Lord, can I request my lords to turn to the page 163, my lord, where the APTEL considers this issue.
160?
163,
Hmm.
para 5.
Hmm.
But this is the interim relief. We have carefully considered rival submission of the parties and also taken note of the provisions under various enactments such as Electricity Act, so and so. The main dispute is the matter regarding supply of electricity from mini hydel project to third parties in addition to supply of power to sister concerns of the generating company. We note that initially permission of the state government was admittedly for captive power generation and later on during 1992 the appellant was permitted by the government of Karnataka to sell the electricity generated not only to within the group of the applicant but also to others who may be nominated by the applicant. According to agreement dated so and so came to be executed between appellant KAB, whereby wheeling of electricity was allowed to enable the applicant to supply power through KAB system to both, namely industries of Baruka Group and to nominees described as users nominated by the applicant.
To page 142. Baruka
140?
Power Corporation Limited.
Please not.
Baruka Power
Yes,
Corporation
yes.
Limited is the petitioner.
Yes, my lord.
Respondents are Bangalore Electricity,
Yes.
Karnataka Power,
True.
Government of Karnataka.
So there's a dispute between them as to whether, my lord, the power could be supplied or not. And this amount that they're asking me now is of the period July 2019 with respect to this very supply. Now, my lord, this order was challenged before the Honorable Supreme Court.
No, where from the court can understand that you're somewhere connected to this dispute?
Lord, I don't think there's any dispute with regard to it because there are other rounds of litigation before this Honorable Court also. Can I show that order as well?
From this order, I don't understand that. From
Very
this
well, very
order-
well, very well. But can I also request Lord to please turn to not the order, but at page 185.
Yes. Metals and Steels Private Limited, that is you.
Yes, Lord.
Hmm.
I was one of the petitioners. Then at page 186, Vijaya Steels was one of the petitioner. There's another writ petition that was filed by them. But you will also turn to page 187.
Yes.
The petitioners are aggrieved by the demand raised by Bescom for the dues payable as of July 2019 by Vijaya Steels and the demand for recovery of 50% of such demand that is payable subsequent to the interim orders granted by this court in so and so. Bescom has raised the demand on 7/8/2019, which is impugned in WP number so and so, in the circumstance that can be stated in concise thus. Baruka Power Limited, which was permitted to generate electricity for captive consumption, has entered into transactions over a period with Mrs. Vijaya Steel to supply electricity. The state government had interdicted such sale that has resulted in the proceedings before the appellate authority for electricity in appeal number 366 of 2019. The appellate tribunal, by its interim order dated 19/12/2019, stayed the orders of the Karnataka Electricity Regulatory Commission in so and so, which has enabled Baruka to wheel its energy to Vijaya Steel. This interim order was called in question before the Honorable Supreme Court in so and so, which stands disposed of with the order dated 2/5/2023, restoring the KERC's order, and consequently there cannot be any wheeling of surplus electricity to Vijaya Steels. The Honorable Supreme Court has also called upon the appellate tribunal to dispose of the appeal without being influenced by the observations contained in the interim order dated so and so. Bescom has raised the impugned demand dated 7/8/2019 on Vijaya Steel for the consumption charges payable as of July 2019 for wheeling of surplus energy by Baruka. Mrs. Vijaya Steel has transferred its assets to Mrs. Wicket Alloys, and Mrs. Wicket Alloys has filed the petition.
Come to para 7.
7 lots, please. These submissions are considered, and what remains salient is neither Vijaya Steels nor MS Steels dispute the demand impugned in WP number so and so, and it's also not disputed that even if the provisions of the Electricity Act were to have precedence over the provisions of IBC, MESCOM can have recourse under section 52 of the IBC to bring the concerned assets to recover its dues. Significantly, this court must observe that it is also indisputable Bescom hold certain surplus which is agreed to be adjusted from the bills by the present consumer, Mrs. So and so. In light of the effort, this court is of the opinion Bescom must, in tandem with the statement made before this court in WP number so and so, allow adjustment bar set off from surplus against the impugned demand while allowing the deduction from the bills, providing for the corresponding liability to pay interest, that is interest payable by Bescom on the surplus held and interest payable by Vijaya Steel, MS Steels on the amount let in due or impugned demand, with liberty to the concerned authority to await statutory remedy in the event there is a dispute about the manner in which the adjustment is provided, as it would be within the domain of dwelling dispute.
What is the other remedy available to the petitioner?
But I have not no other remedy.
No, before the authorities, with regard to the building, they'll have some mechanism in the department.
Lord, there are, I think in this, the disposal Lord, of the petition was to the effect that Lord, this amount to be adjusted, not excess amount of 2 crores that is there, that is to be adjusted towards my bills.
Every time this cannot go on. Whenever they raise a bill, you can't come to the.
Lord, can I just request, Lord, please see Lord, their demand. For a moment, Lord, see the demand. I'll just show Lord, the translated copy, which is at page 224.
No. Even assuming
Well,
that.
if I may submit, they already have an alternative remedy to approach CGRC, Consumer Grievance Redressal Forum. They can approach them and submit whatever the submissions they can make, instead of directly approaching the court in
Every time there is a demand, there is a petition, there is an order. It can't go on like that. There should be some finality to this. So
True, Lord.
this is what, according to you, consequently, they will say till such time, till your go before the authority, till such time your grievance is redressed by them. Let them not give effect to all this. And whatever the admitted consumptions, your consumption charges, you continue to pay.
Not consumption charges, not I'll pay. There's no dispute at all.
And with regard to all this, let whatever is a mechanism that is there under the statute or with the respondents, you avail that. Now, all these exercise High Court will not do.
Not if not the earlier round of litigation, but the court has also observed with regard to IBC proceedings. Not I just pointed one not judgment of the apex court. Vijaya Steels has already undergone liquidation or not IBC proceedings. Lord's permit, not I'll just pass on not the order.
Ask me one simple question: can't the authority under their whatever is available in place, the mechanism, can't they look into? Why should the High Court do it?
But the High Court has not entertained this matter earlier and passed an order. Now that order, my lord, again being not flouted.
Entertaining by a writ petition by the High Court will not give.
But my
That is
problem
not a
will be this.
precedent.
But I'll point out this. My problem will be this. But there is a transfer of the meter in my name.
Asking you,
Please.
what is the imminent threat or the difficulty you're facing?
But my immediate threat or difficulty will be not on the base of this. Not they should not discard my power supply or do anything of that nature.
So that's what I'll direct is, you continue to pay your existing charges. With regard to these bills for which you're raising a complaint, go before Consumer Redressal Commission. CGR, and let them decide it. Till such time, let them not give effect to this.
My lords, if I may, nowhere in the notice we have precipitated that we would disconnect the power connection. Nowhere it is mentioned. So even if they go before CGRF, until then we will not disconnect the power.
Yes, Mr.
Just give me. But can I make one submission, Lord? Lord, by virtue of the provisions of the IBC, Lord, if Vijay Steel's Lord is already Lord subject matter of Lord IBC proceedings and resolution plan has been approved Lord by
We'll
NCA.
invite an order from them, then you can avail your remedy. Why should we decide all that? Now, as of now, there is no threat to you. They're not going to disconnect the power supply. I'm also making it a part of the order. And you go there. Why you want it to be decided here? Yes.
Because somebody else's liability is fastened on my head.
That's what. Now there is no threat to you. You pay your regular consumption charges. You wait for you go before them. You make out a case or what is your grievance? Tell them they will invite an order. Then you have a remedy. Not that once they pass an order that's end of it. Once they pass an order, all facts will be clear. And all these submissions will always be left to you to agitate before any of the forums.
Lord, sir, aware, Lord, alternate remedy will not be a bar, Lord. Yes,
And
on the
why
face
should
of it, Lord, if I'm able to convince my lords that the NCLT order.
If that proposition has to be applied in the manner you are submitting, then nobody should go anywhere. Everybody should come to the High Court.
Not everybody.
Should be decided in the High Court itself. Now, about all this exercise, why should we waste our time? If I understand there is some immediate threat to you, and the High Court is the only, then I can understand. No, there is no threat to you, and I'm also giving you an order in that regard. So, what is the difficulty? Please come.
Please.
The present writ petition is filed. Sing the following prayer. Then counsel for the petitioner submits that.
Lord, I'm sorry, Lord, my instructions are, Lord, I have asked for additional power. For asking for additional power, they are saying that unless I pay this amount, they will not give me additional power. Lords may say, Lord, that this will not come in the way of supply of additional power.
What is your prayer? That's what, there will be something behind it. It won't be as simple
No,
as
my
it
prayer is not for quashing of these demands.
That's it.
True. Lord, unless.
That is, what is your prayer? Why should we go beyond that? Yes, the writ petition is filed. Sing the following prayer. Then counsel for the petitioner submits that. The The petitioner occupied the premises as a tenant under the registered sale deed dated 5/2/2021.
Leased it.
5/2/2020.
Leased.
5/2/2021.
Leased deed is what? Not sale deed. Leased.
Has the petitioner occupied the premises as a tenant by virtue of a lease deed dated 5/2/2021. And the electrical installation meter, which was in the name of Vikat Alloys Private Limited, was transferred to in the name of the petitioner. Earlier, on 15/2/2023, when the respondent issued a demand notice seeking for payment of an amount of rupees for, it is 1 crore, 14,54,129. Petition has filed WP number 8827 has approached this court by filing WP number 8827 of 2023 that came to be disposed of on 3/11/2023. directing the respondent to adjust set off the surplus relatable to the concerned RR installation towards the impugned demand and the corresponding interest liability, and further directing the respondents to provide for such adjustment set off in the bill for the period up to 31/12/2023.
What is the order passed by this fellow?
Now it is a grievance of the petitioner that the respondents issued demand notices dated 13/3/2025, 7/4/2025, 14/5/2025, 12/6/2025, 15/7/2025, 13/8, 16/9, 15/10, and 11/11/2025, seeking payment of rupees 2,77,18,630 plus a simple interest of 1% from March 2024 till the date of payment for the power purchased by Vijaya Steels Limited. It is submitted that the dispute relating to the Vijaya Steels is under liquidation and no?
No, it is. There is an order passed not approving the resolution process. Liquidation may be different.
There is the order approving the resolution process, not necessarily resolution process, and the dispute with regard to who has to pay the amount, whether it has to be paid to the BESCOM or it has to be paid to
Tumlord Buruka.
Baroka, is the issue that is pending before the APTEL. Before the APTEL. In those circumstances, the respondents cannot demand the petitioner, who is a subsequent lessee, to pay the amount due earlier, even before the petitioner has occupied the premises. It is submitted that, in fact, the petitioner has made a request for additional power supply, and as in the light of the pending demand, the respondents are not even considering the same, which made the petitioner to come before the court. Land counsel appearing for respondents.
Both the respondents.
Respondent 1 and 2 submits that the remedy available to the petitioner is before the CGRF, that is
Consumer Grievance Redressal Forum.
That is before the Consumer Grievance Redressal Forum. Instead of availing the said opportunity, the remedy, the petitioner has come before the court. It is submitted. It is the submission of the land counsel for the respondent that even in the demand notice, they have not stated anything with regard to disconnection of the power supply, and without availing the alternative remedy and without any cause of action, the petitioner has come before the court. Next one, having heard the counsel's findings aside, what is the material non record? The dispute between the parties is with regard to the amounts due from the earlier tenant.
From Vijaya Steels.
From Vijaya Steels, in respect of which the resolution plan is admitted, and the dispute also with regard to whether the amount has to be paid to the BESCOM or to Baruka Power.
Yes.
Baruka Power
Corporation Limited.
Power Corporation is the dispute that is pending. It is a grievance of the petitioner that pending the said dispute, and when the petitioner is paying the consumption charges regularly without any fail, they are keeping on issuing the notices without considering the said dispute between the parties. As rightly submitted by the land counsel for the respondent, when there is a mechanism in place, that is a consumer grievance redressal forum, petitioner has to approach the CGRF for redressal of his grievance if they are not able to deal with the same, and if any order is passed, the petitioner has a remedy to petitioner has an appropriate remedy against the said order. This court, exercising the jurisdiction under Article 226, cannot go into all these aspects when the CJRF would be able to adjudicate these disputes in a more effective manner, as the entire material will be available for them. In those circumstances, this court is not inclined to go into the merits of the matter. However, it is made clear that till the grievance of the petitioner is redressed, the respondents shall not raised, the respondent shall not take any coercive steps. And if any application of the petitioner seeking additional power supply shall be considered independently, notwithstanding the fact that these amounts are due. Accordingly, this court is passing the following order. The writ petition is disposed of, giving liberty to the petitioner to go before so and so. Number two, the respondent shall not disconnect the power supply till the CGRF adjudicates the dispute raised by the petitioner. The petitioner shall go before CGRF within a period of 1 week from the date of receipt of the copy of the order. Number four, the petitioner's request for addition shall be considered, notwithstanding the pending dispute.
Please, give me
Yes.
a request for 15 days, not instead of 1 week. Great.
Much obliged.
That this is that 450 acres sale agreement, my lord, which I argued last time. Lord, I have only two submissions, my lord, to make. Your lordships may kindly see, my lord, order 6, rule 6. In a suit for specific performance, what all to be stated, my lord, order 6, rule 6.
Yes.
Any condition precedent, the performance or occurrence of which is intended to be contested, shall be distinctly specified in his pleading by the plaintiff or the defendant, as the case may be, and subject thereto an averment of the performance or occurrence of all conditions precedent necessary for the case of the plaintiff or the defendant shall be implied in his pleading. My lord, in a suit for specific performance, my lord, basically, if a sale agreement is sought to be performed, lord, through a decree of the court. Now, my lord, if the sale agreement has certain conditions to be fulfilled before the execution of the sale deed, and the vendors fail to do those conditions, my lord, then the suit is gone before the court. The suit should also mention and seek for a prayer, besides issuance of sale deed, the performance of those conditions. Then only, my lord, it can be specifically enforced. Otherwise, my lord, a continuing nature of contract which the court cannot supervise, there is a direct bar.
According to you, you have filed a petition application under order 7 rule 11.
7 rule 11.
What are the grounds as stated
These
by you?
precisely this was the ground. Your lordships may kindly have, my lord, my application 7 rule 11, which is at page number, my lord, 86. Page number 86, my lord.
Yes.
The affidavit your lordships could kindly have at page number 87.
Yes.
Now, paragraph number 3
Yes,
on
sir.
page number 88.
Yes, sir.
However, I submit that the plaintiffs have suppressed material facts and misrepresented the true state of affairs regarding.
You're reading paragraph number?
I am reading, my lord, at page number 88, paragraph number 3.
Yes.
However, I submit that the plaintiffs have, my lord, before that, I have extracted, my lord, at paragraph number 2, what is the prayer. This is the only prayer. Your lordships may kindly have, my lord, page number 87 for a moment. The last paragraph, my lord, on page number 87, paragraph 2. I most humbly submit that the plaintiffs have filed this suit seeking specific reliefs which have enumerated in the plaint. A, that is prayer A. Plaintiffs had filed judgment and decree directing the defendants to execute a sale deed in favor of the plaintiffs concerning the suit schedule properties as per the agreement of sale dated 14/9/2009. Additionally, plaintiffs have requested an order of injunction to restrain the defendants, their agent representatives, or any person claiming through under them for alienating the suit schedule properties. Lastly, they seek for an award of costs, etc. This is what's sought under the plaint. Now, my lord, your lordships may kindly have the plaint for a moment, my lord. I will show to your lordships what exactly is their plaint. My lord, there are two plaints. One was unamended, and after the amendment, my lord, I will go by the amended plaint. Your lordships would kindly have it at page number 128. I will only read, my lord, 2 paragraphs of this plaint. The cause title, my lord, is very lengthy because, my lord, it has as many as 130 defendants.
Where do you get this?
I mean, your lordships would kindly get the plaint, amended plaint at page number, my lord, the 128, annexure B1. This is amended pliant.
Hmm.
My lord, the cost title is longish. Cost title is, my lord, is longer than the pleadings. Your lordships may kindly have, my lord, page number 147.
Hmm.
Paragraph number 3 delineates what all the properties that were sought to be purchased under the sale agreement, which spills over to, my lord, page number 148. Altogether, my lord, it's about more than 400 acres, which is not in dispute. Then, your lordships may kindly have, my lords would kindly have page number 150. Paragraph number 10 states,
Yeah.
the plaintiff submits that in respect of item number 2 of the scheduled properties, the occupancy rights was granted to S. Balareddy in RC number so and so by the Special Deputy Commissioner for Inam's abolition, Bangalore, in favor of Balareddy, and he was in possession and enjoyment of the properties mentioned in the schedule. Thus, it will be seen from the said S. Balareddy acquired the scheduled properties through occupancy rights granted by the Special Deputy Commissioner, and in this connection, the Special Deputy Commissioner issued an endorsement confirming S. Palareddy was the Khadim tenant of the scheduled properties. The orders passed by the Special Deputy Commissioner is not questioned by any person nor set aside by the superior authorities. As such, the occupancy rights granted in favor of S. Palareddy became final. After his demise, his legal heirs have succeeded to the estate of the deceased. Then, my lord, paragraph number 12 is important. The plaintiff respectfully submits that subsequent to the defendants entered into the sale agreement, they have also executed a general power of attorney in favor of the plaintiffs to look after and maintain and manage the scheduled properties on the ground that they are the residents of Andhra Pradesh and they are unable to look after and maintain the affairs of suit scheduled properties. Therefore,
Yes.
Therefore, the defendants have executed power of attorney in favor of the plaintiffs. Then paragraph number 13, my lord. The plaintiffs respectfully submits that the subsequent to the defendants entered into the sale agreement, first defendant has received advance amount of 2 lakhs on 10/11/2009 and second defendant has received 2 lakhs towards the further advance and endorsed the amount received by them. In addition to that, the defendants have approached the plaintiffs in the first week of April 2010 and requested to pay another 3 lakhs to meet their urgent need of money. The plaintiffs have conceded the request made by the defendants and have paid a sum of rupees 3 lakhs by way of cash by the first plaintiff. Even on 4/4/2010, the defendants have received sum of 3 lakhs. My lord, this is 400 and odd acres of land. My lord, is being sold for a sum of rupees.
That is all on the.
Yes, my lord, I am not on that. Then your lordship sees
No,
what
no,
exactly
you
is
can
the
please-
reason.
No, you can please straight away come to the point. Under order 7 to 11, A to F.
Yes.
Under which provision this suit has to be rejected.
Precisely, my lord, 7D, my lord, if the suit is barred by law. Now, my lord,
According to you, how it is barred by?
it is barred, my lord, on 2 counts. The plaint, if it does not mention, my lord, what is the requirement of 6 rule 6, which is condition precedent to be mentioned in the plaint. My lord, in this background, may I just, my lord, the cost of repetition, read, my lord, 6 rule 6 forever.
Yes.
Order 6 rule 6, my lord, which is very important. My lord, because order 6 rule 6 says which suit,
So
what should be.
non-compliance of that requirement is barred by law.
In fact, my lord, if the suit for specific performance does not say.
The CCC is a procedural.
Yes, my lord, substantive and procedural, both. Now, if the suit for specific performance does not say what it should be pleaded, it should go, my lord. Now, I am, my lord, being a bit generous, my lord. If this plaint did not have the qualifying aspects which needed to be there in a suit for specific performance, let it be rejected and order 7 rule 13, they can come back.
No, any judgment in that regard saying that if this is not fulfilled, that will fall within
There
order
are,
7 to 11.
your lordships may kindly bear with me for a 1 day, my lord. I'll produce the judgments.
Yes, this is matter on Tuesday.
I believe, my lord, there is a judgment which my learned friend is assisting me. Then, my lord, your lordship may kindly have it tomorrow or any other nearest day.
Tuesday will have it.
to Tuesday. Greatly obliged.
Yes.
I'm so grateful.
Yes.
Petitioner in the first.
Yes, you're there.
Please,
They appear in all the matters.
please, please.
It's coming up for E group.
B group.
Please.
This was heard by me.
Lords.
This is heard by me.
No, my
No,
lords.
my lords, no.
Interim order was by the coordinator.
Huh?
Interim order was by the coordinator.
So there are
Three writ petitions
three writ petitions.
challenging the same
No,
order.
I mean, service of notices are completed.
Please,
Lords,
my lords.
in my matter,
Only plaintiff, that I'm for the plaintiff.
You said that notice not required to others?
No, my lords,
Sir, they
because
are not.
they appear for the
7.3,
No, in 7?
7.3, my lords.
No, in 7,
7, I appear for the petitioner, my lords.
tagged on so and so.
For
Then
first
what
respondent-
about the other respondents in your
Other
case?
respondents, they will appear.
My lords, respondent number 2, my lords, I have taken notice on last day.
Hmm.
My lords, I'm filing wakalat during the course of the day, my lords, I have my wakalat.
What about other respondents? Only one.
Other respondents in respect of respondent number 1, they appear.
I'm
Plaintiff
there.
Come to, please come to the cost title.
Please, my lords, page number 4, my lords.
Yes. So,
Respondent number 1 is.
1 and 2, then it is done. 2, you are,
Two, they appear.
I
this
have
is already
taken-
recorded on the last
Yes,
occasion.
I've taken
Then
notice.
give the next case.
Next is my writ petition, my lords. Respondent is on K-wave. Respondent number 2 to 5 is my.
I
learned
appear.
friend.
Let me look at the cost title and then understand. Where is the cost title in next one?
Page 3, my lords.
So, for the first respondent, you appear.
Yes.
Second
Respondent number
respondent,
2, so 7.
I
my
accept
learned
notice, my
friend.
lords.
you appear.
Please, my lords.
That's, that is also,
Yes.
is on record.
Please.
Then what about the third one?
7.3 also, my lord, the cost title it does not reflect. My lords, my learned friend takes notice for respondent number 2 to 7.
1 minute. So, in other matters, you're taking notice for this Chandan.
Yes, he is the plaintiff. Yes.
So, Mr. So-and-so, Mr. P. N. Harish is already there.
Yes, there
He
is
has
already in order.
given-
One respondent number 2 to 7, my learned friend, his name is not shown.
S.V. Prakash.
Sri
name.
Prakash.
Yes, we can.
Oh, you. are.
Please, my lords.
For 2 to 7,
2 to 7.
Mr.
S.V. Prakash.
H.C. Prakash submits that he has instructions to file, S.V. Prakash.
Please.
Submits that his instructions to file wakalat. Yes. Now, what are these writ petitions?
My lords. Madi.
Yes. First writ petition, WP
I
10236.
appear for the petitioner, my lords.
Ah.
We are the original defendants, my lords. The respondent instituted a suit for declaration and possession against us, my lords, claiming that his father was the owner of the suit A and B scheduled properties, and I started interference in the suit B scheduled
What
properties.
is IA?
My lords, first IA is for IA number 3 is for amendment of plaint, and IA number 4 is for impleading the proposed respondent, who is respondent number 2 in my petition, my lords, as seventh defendant into the plaint, my lords.
Both are allowed.
Please, my lords, both IAs came to be allowed.
Then third one,
Both, only 2 IAs.
No, there are only 2 IAs. I am for the impleading applicant. I have challenged my impleadment. Let's
that is which one?
7.1 and 7.2.
No, 7.1
And
is
7.
your writ petition.
7.1 and 7.2 are my writ petition. I have challenged 7.1, Malat, I have challenged my impleadment. 7.2, I have challenged the subsequent amendment. Let's with respect to, since they have impleaded me, Malats, with respect to that, they have filed an IA seeking amendment of plaint, Malat, that also I have challenged. That is why there are 2 writ petitions.
No, why should you challenge that?
It's because they are impleading me, Malats.
No, once this goes,
Yes.
it's a consequential
Yes, yes.
order.
That's because since there are 2 orders.
Because no,
separate
we
orders.
will not be going into the merits of
Yes,
order 6 rule 17 in your case.
Separate, yes.
So once we'll hear this 7.1, then what about this first one?
First one, I have challenged both the impugned orders, my lords.
They have-
Implement and also the amendment application.
They are the original.
Then first we'll
defendants.
hear
Yes.
this writ petition so that all the writ petitions can be disposed of. 10236. Yes, argue.
My lords. He instituted a suit for declaration and recovery of possession, my lords, annulling the judgments and decree
When was
passed.
the suit? Suit is of the year?
Suit is of the year 24, my lords. Plaint is at page number 21, annexure A, my
Come
lords.
to this order 6 rule 17 affidavit.
Please, my
Is
lords.
it?
Page number
37, my lords. Please, my lords. May I read, my lords?
Let's read.
Third para, my lords. I have referred to two suits for bare injunction in OS number 420 of 2010 filed by the father of defendants 126 against me on the file of the first additional civil judge and JMFC Shimoga with respect to eastern 35 guntas in survey number 114/1 of A schedule, and another suit OS number 419/2010 filed by P. Kannappa on the file of the second additional civil judge and JMFC Shimoga with respect to western 35 guntas of survey number 114/1 by defendant number 7 P. Kannappa of my plaint A schedule property on the some same set of fabricated material documents. I have referred appeals in RA number so and so and RA number so and so respectively against the judgment and decree passed in the above suits before the first additional senior civil judge Shimoga and principal senior civil judge. The appeal was
Amendment is only to implead 7 defendant.
Please, my lords.
And
That's
to
the only.
delete,
And one more thing, my
delete
lords.
some paragraphs which are not maintained because
But you have to say in your affidavit.
He wanted to annul the prayer number 2, my
Let us
lords.
see the amendment itself.
Please.
Because in the affidavit, it is nothing is stated.
Please, my lords. Page number 36, my lords. 35, start from 35. My lords.
It is about the proceedings.
Please, my lords.
As far as that, you need not have any problem for that.
In respect of deleting the prayer,
That at para number 6, page
Please,
4,
ma'am.
you
I
can't
am-
have any grievance. Next, para 7.
para 11, my lords, para 11,
para 7 also.
What is that he wants to delete? Then at para 7, page 5,
That-
to delete portion starting with the said decision and decisions rendered in appeals are all not sustainable and are passed without considering and appreciating the elements of this also you can't be aggrieved. Then at
It was
para
a
number
wrong-
11.
That was a mistake it is stated. I cannot do that because.
Yes.
para
Then
11, at para 11, page 6, reliefs to include. my
third
lords.
line till its end. You have problem with this.
At para 11, page number 6, I have a problem.
What is that?
My lords, he wanted to add for possession of western portion so and so as detailed above by evicting the 7th defendant and his agents therefrom. Relief F, my lords, for permanent injunction restraining the defendants, their agents and servants from trespassing upon, interfering with or damaging in any manner the A schedule land and the improvements thereon, my lords. He wanted to claim relief against the proposed defendant, my lords, by way of this amendment, my lords. It will change the nature of suits, my lord, because initially,
Now, he is a plaintiff.
please,
After filing of the suit,
Please.
certain things have taken place. According to him, the 7th defendant has come into possession of the property.
please, no, my lords. One thing, my lords. Actually, his claim against me is the eastern portion of Schedule A property, my lords.
You are,
I'm the defendant 126. We are in possession of the eastern portion of Schedule A property, and our possession is protected by judgment and decree of this honorable court, my lords. The proposed 7th defendant, my lords, is in the western portion of suit A schedule property, and his suit came to be dismissed and it was upheld by this honorable court, my lords. While during pendency of the present suit, that RSA came to be, the RSA filed by the proposed 7th defendant came to be dismissed, and that's why he wanted to implead in that suit and he wanted to claim relief against him, my lords.
Blood. The suit is a comprehensive suit for declaration and possession.
declaration and injunction in respect of a particular
No,
property.
possession, my lord. It's for sought for possession.
Possession in respect of a no, you have an independent cause of action against that defendant.
That is-
File an independent suit.
Blood. The purpose of amendment is to avoid the multiplicity of the proceeding.
Multiplicity of proceedings in
Yes.
respect of a particular subject matter.
Yes.
It
This
doesn't
is also
mean that
subject
the
matter.
plaintiff is one.
Please.
All problems he has in the entire, he has 101 properties. So all properties he will include and he
No,
will
no,
say
my lord. With
multiplicity.
respect to same property, it's
No,
with
that's-
respect to A schedule property only. I am claiming ownership against the A schedule property. I am saying that the original defendants are in the western portion are in occupation. After the dismissal of the RSA, I want to include the 7th defendant saying that he is in the western portion of the very same property. Same property, my lord. I am not changing the,
Let's look at that implete petition.
please.
Where is that affidavit?
David, my lords. Page number 40, my lords.
Let's read that.
Same. May I read, my lords? Third paragraph. I have also stated that the 7th defendant also had filed OS number so and so on the file of the so and so for bare permanent injunction
For my
against me.
western 0.35 guntas of plaintiff scheduled property.
Yes, scheduled property only.
Yes,
I
what
know.
he
It's a
claims.
different,
That's
different
right.
cause of action, my lords. He is third person to my suit, my lords. Though he was a master of his suit, he can't implement a third person to my suit and claim relief against him, my lords.
You can't
And
have
one
any
more thing, my lords, the matter is posted for
What
evidence.
do you say?
May I just give you a few dates and events, so that it reads. Let's 2010, the original defendants. 2010, in the year 2010, the original defendants for the petitioners here filed a suit for bare injunction against the respondent in OS number 420 of 2010.
420 of
2010. That came to be decreed on 15/9/2015. That was challenged in the RA number 137 by 2015 by the present respondents. That also came to be dismissed on 5/12/2022. For that he filed a suit against the defendants for a comprehensive relief of declaration and possession.
That's a present suit.
That is
Yes,
the present
please.
suit. Yes. What happened? I filed a suit against the respondent in OS number 419 of 2000.
That's your suit for
My
injunction.
Injunction. That came to be decreed on 17/10/2015. With respect to different scheduled property, that is nowhere connected with the present scheduled property. That is survey number 180, survey number 114 is the present suit. That I have they challenged it before the first appellate court in RA number 10 of 2016. That came to be allowed. Subsequently, I challenged that first appellate court order before this honorable court in RSA number 506 of 2018. On 23/9/2024, that came to be dismissed. That is his cause of action. Now, during the pendency of the suit, that suit was pending. This RSA came to be dismissed against the present respondent, came to be dismissed against me. That is what he is claiming. Dismissal of RSA gives him a cause of action to implead me with respect to different portion of the property in the present suit.
It is not
Cause of
different
action,
extent.
that is what he says,
His scheduled property, that is what he's saying. Come to
No.
this page 40.
In RSA, before this honorable court, when I filed
No,
a suit,
forget about that.
no, he says, he says my property and his properties are different. He comes and
Come to page 40 first. Let's see that. What did he
kindly
say?
see, para 3,
No, para 2 you read. I have also stated that. Page 40.
Page 40, I'll read. Please, I have also stated that 7 defendants also had filed a OS number 419 of 2010 on the file of first so and so for bare permanent injunction against me for my western 35 guntas of plain A scheduled property on the basis of false and fabricated documents. The Honorable Court granted an ad interim temporary injunction land and later made it absolute and further said that the suit was decreed, restraining me from continuing possession of my land. I preferred an appeal against judgment and decree passed in RA number so and so on file of so and so. The said appeal was allowed on merit and on contest holding that the documents I challenged were false and fabricated. By dismissing the suit with cause passed in OS, but the proposed defendant P. Kannappa, that is me, preferred RSA number so and so on the file of Honorable High Court of Karnataka. The said appeal is dismissed on so and so, confirming the order passed in RA number. Next paragraph,
I've seen that.
Now, next paragraph, now I have sought for declaration of my title, permanent injunction, etc. in suit measuring so and so in survey number 114/1 of so and so village. Falsely 35 gunta, western part of 35 guntas was falsely claimed by third defendant. He's trying to add a different property. He's trying to add a different property by way of an amendment and seeking to implead me with a different cause of action.
If he files a separate suit against you.
Pardon?
If he files a separate suit against you.
Please, if he files a separate suit against
So
me, I have to contest.
So what is a prejudice to you?
This is not permissible in view of Order 1 Rule 3. He cannot implead me. He cannot join me as a defendant. It's a different cause of action. He has to institute a separate suit. That is my claim. Plus, he cannot implead me in the present suit because the properties are different. The cause of action is different.
That is where the problem is. According to you, plain taste scheduled property is the property. That we cannot now.
No,
we
it is
can
not
only
my property. I have no relation whatsoever.
We can only go by what the pleadings. According to him, it is a plain taste scheduled property.
He comes in before this honorable court in the second appeal says that I have survey number 180 which is claimed by me. Is different from survey number 114. He comes and says western portion of survey number 114 is same as me. Is claimed by me is what he says. He takes two contradictory stand before this honorable court.
No, that the court will consider now at this stage. What is the material before the court to come to all these conclusions?
RSA, the dismissal of RSA against me gives him a different cause of action. He cannot implead me. That is what Order 1 Rule 3. For a moment, Order 1 Rule 3 if your lordship look into. It says it is a joinder of different cause of action. He cannot implead me with respect to different properties. It is a new cause of action for
That
him.
is what you have to tell me now. Where is it a different property? According to him, it is the same
Let's may I
property
just pass
as
on the
stated
RSA
in the
judgment.
affidavit.
May I pass on the RSA judgment, where he comes and says, my lord, the properties of me, that's claimed by 7 defendant and by the respondents is
pass.
different.
Yes. Yes, next. Pasu. Yes, next.
For the petitioner, Your Lordship. Let's, 1 week's time may kindly be granted, Your Lordship, because the petitioner here has filed a transpose application before the trial court that is up for hearing.
This matter in the month of September. Yes, next time.
Please.
My lords, I may be permitted to appear online. I am for the petitioner, my lords.
Yes.
My lords, the suit for specific performance was decreed. To execute the suit for specific performance, get the sale deed, I filed an execution petition. Commissioner was appointed. Commissioner fee was paid, balance sale consideration also deposited in the court. Then commissioner filed a report on 12/6/2024 stating that it requires the durust of survey number 181. Then for that purpose, proceedings are pending before the Tahsildar. On 10/11/2025, EP was closed as I am not interested as per the impugned order.
You have not?
Not interested in the matter. Page 34. Page
Case
34.
called out at 11 a.m. Representation kept by 3 p.m. DHR absent, counsel absent, no representation. Sufficient opportunity, DHR counsel failed to take necessary adjournments were given to the DHR. Therefore, court is opinion that is not. What has happened from 2024 till now?
Now it is pending before I am showing Bharat. It is pending before the Tahsildar. All the checklists have been created. I will take a
No,
lordship.
forever it will be. No, forever it will be pending before him.
No,
what you should do?
Yes, madam. Now, unless Tahsildar bifurcates my 2 acres of land, I cannot have a sale deed, my lord. My part, nothing is pending.
No, if Sahsildar is not doing, you have no other remedy. You will just keep quiet. If
No,
he
my lord,
does it
they are
after
going. They have done, my lord. They have done lot of things. It's a huge survey number, my lord. I will take your lordship to that. Just one survey number. It's
then why
having
you have not appeared? Why you have not appeared before the court?
because we are thinking await report for that purpose. We are not there because, my lord, if that is dismissed, I am not having a remedy, my lord. My 12 years is over, my lord.
No, in that case, you should be more careful to appear before the court.
Yes, madam.
Instead of just.
Yes, madam.
When is this order passed?
This order passed on 10/11/2025, my lord.
Why it took this much of time for you to come before the court?
No, immediately I filed, my lord. But it did not come. I filed on 24/1, January only filed, my lord.
When did you comply with the office objections? Office objections are complied on 8/7/2026.
Yes. There is no interim order was sought. Therefore,
Not interim order. Why should the court come to the rescue of these kind of litigants?
Yes.
Because under 220, just file a writ petition for the sake of it, file it and keep it.
Let
it come after 1 year and tell the trial court that the matter is pending before the High Court.
No, my lord. Trial court is not pending, my lord.
Notice to the respondent. Notice to the respondents.
Much obliged.
Kindly adjourn matter for 1
This is matter in the month of September. Yes, next. Yes, same order.
Petitioner.
Yes.
Lord, the name of the second defendant in the trial court was left out in the judgment, but it was reflected in the decree. But while filing the RA appeal, Lord, the cause title of the judgment was carried and the name of the second defendant was not shown. But on coming to know of that, Lord, we filed an application to implead the second defendant who has been left out in the cause title. That application is rejected on the ground that it is belatedly filed. Kindly see the.
It was RA filed. RA was filed in 2021.
20. Yes.
No, it is, how can you call it a mistake? 2021 to 2026, you were pursuing the matter without impleading the defendant.
The second defendant, not first defendant was contesting, who is the brother of the second defendant, was impleaded later because he filed a.
Ultimately, whatever that is there in the decree, that
Yes.
you have to do it.
Lord, even in the judgment, my lord, there was
According to
a
decree, his name is there.
decree, there is a name. Decree, kindly see page 53, my lord.
Why you felt that it is necessary now? When you are continuing from 5 years, you should have completed it.
No, my lord, now what had happened is, my lord, during the pendency of the appeal,
So now he is not part of it. He has to contest these proceedings. So now we have to put the clock back to 2021. And all 5 years, what has happened now, it has to again.
no, my lord, only the appeal was pending and records were called for. And
Present stage.
for final hearing only. For final hearing.
No, final hearing means what? Nothing has happened. Suit is a continuation of, appeal is a continuation of the
No,
suit.
after filing the appeal, notice was issued and records were called for. Both the parties appeared and matter is pending for final hearing.
You can't call it a mistake.
It's a mistake on the both parts, my lord. Even the council's
Can't be a
mistake.
A party to a proceedings.
If your lordship sees the judgment for a moment at page
First of all,
27.
filing a judgment, accepting a judgment which is contrary to the decree, the court shouldn't have numbered it on the first place.
It should have been noted at the first instance.
And even till like, now what should happen? Now the judgment, you should see clarification in the judgment. So there is a typographical mistake. That should be corrected by the trial court.
152 application to be
You
filed.
file it till now.
They have not filed it. So they filed an application to implead him in this case.
These are the respondents.
But I have for stay, my lord. The appeal is taken up, my lord.
It has to be done. Then only the party will be careful. The petition is permitted to take out hand summons on the counsel appearing for the respondent before the appellate court and shall file a memo to that effect by 3rd of August. If the memo is filed, list the matter on 4th. Yes.
Please.
But I seek for a passover, my lord. Kindly have it at 2:30.
Passovers will not be called anymore.
Let's kindly have it at 2:30, my lord. Senior is arguing before court for 4 months.
Let him. Yes, 14.
These two writ petitions, my lord, emanate from the same proceedings on two different IAs. The first writ petition pertains to rejection of an application for amendment. And the second one is application rejection of seeking for appointment of a commissioner at an earlier stage, a few months ago.
What is the suit for?
Suit was for declaration of title and also for permanent injunction.
Suit is filed which year?
Suit is filed in 2000. I've just come. Suit is of now. One minute. I will just give the number. 583.
So the year 2015.
2015, my lord. It's almost 11 years now. Yes. Now I'm also told that the case is at the back end of the proceedings. That's the position.
You're the plaintiff or the defendant?
Now I'm the plaintiff before the court.
What is the amendment that you're seeking?
Amendment is sought for by inadvertence instead of, in addition to the number of the suit schedule property, 85/1. He also said resurvey number 101. That's a mistake done. I just wanted to delete that number. The other things would remain.
What is the stage of the proceedings now?
Stage of the proceedings. I'm told that it is at the stage of the fact and the arguments on the main matter. That's the whole difficulty.
After the evidence during the cross-examination.
Evidence is complete. And the documents and the deletion would not in any way change the cause of action at all.
Come to the order impugned. Page number.
Page number 21, my lord. It's in Kannada. May I read?
Okay. How can you read the order which is in Kannada? You have to file a translated copy. This is matter. When can you file?
A week's time, my lord. No, I just wanted to make a mention at the 10th.
This is matter on 29th of July. The petitioner shall file the translated copies of the impugned order as well the applications that are filed in support of the IAS, both matters, 14 and 15.
Yes.
Call 16.
Obli.
Yes.
This is one more, the last matter connected with the previous matter, my lord, where my lord was indulged this commission's report. ADLR was appointed and had to be appointed. Connected matter, my lord, the third matter.
No, in this also commission is appointed.
Please, the same order is placed on the record.
When counsel appearing for the petitioner submits that in the connected matter, this court has already, in WP number 19547 of 2026, this court has passed an order dated 2/7/2026, whereby the court had stayed all the further proceedings. Hence, considering the same, in this case also, look at it, there shall be stay of all further proceedings pursuant to the order dated so and so. Notice to the respondents, in addition, in all the matters, notice to the respondents, in addition, they shall take out hand summons and file a memo to that, on the council, and shall file a memo to that effect by 30th of July, or else a stay granted with this court's transfer. Yes.
No, I'm appealing for the petitioner, my lords.
Yes.
Both respondents BESCOM. Both respondents are BESCOM.
BESCOM. Oh, this is a KEB matter. I'll take it tomorrow.
The similar matters were disposed of pertaining to challenging the showcase today.
Similar matter. Every case has its own facts. There is no similar.
Yes, 4 matters were already
I
disposed
will
of.
take it up tomorrow, Mr. Balraj.
Please,
The so and so. Where is that list?
Can I make one submission, my lords?
Yes.
Similar 4 matters were disposed of just 3 days back notes pertaining to the showcase notice. My lordship has granted 1 week's time to find our reply.
Let the council come on record. Then I'll pass the same order. That will I do it tomorrow.
Please.
What is this? Swamini Ganesh Mohanambal is directed to take notice. Petition serve the copy of the red petition. Print the name list tomorrow in the first list. Yes, 18. Correspondent 1 and 2. Yes, 18.
Beg to appear for
yes.
The defendant's petition. The company is already a party. Company is represented by managing director. These are 2 independent, only separate directors. The suit is against the company because the plaintiff says he was employed by the company and now there are some salaries which the company is not paid. Now in that suit, whether these 2 are proper parties. For this court has already taken a view that unless and until there is no direct allegation and any liability in the individual capacity of the directors need not be.
What
Our
is the order
application
impugned?
Lord, application under order 1 rule 10 is been dismissed. Kindly see the impugned order, page 13. Lord, it starts at page 11.
We'll see from the reasoning part.
Lord, the reasoning portion, para 8.
Yes.
In the present case, the plaintiff governments disclosed that D2 is connected with the employment of the plaintiff and the alleged non-payment of salary. The plaintiff has specifically pleaded that said defendant was concerned with the management and disbursement of salary. These governments prima facie indicate his presence is required to adjudicate. This is the only reason. Lord, our High Court has taken a view.
No, first let us understand.
Please, let's see the prayer.
Come to the cause title.
Please.
Subhash, the defendant is
Lord,
Power
suit
Resource
cause
Private
title.
Limited and others.
Please.
For whom he has implemented the
I am
marriage.
now Lord 2, D2 and D3. Lord, plaintiff is at page 15.
Yes.
Now the plaintiff has filed against this D1, who is a company. Company is represented by the managing director. He has also filed. D2 and D3 are other directors. In their personal capacity, he has made them parties. No governments against. No prayer. Kindly see the prayer portion. Below 1 sentence, I want to say para 2.
Page number.
Next page 16. The plaintiff, no, Lordship's got that. Page 16, para 2, plaintiff I'm reading. The plaintiff under the letter of appointment dated 1/4/2012 issued by defendant number 1.
No, you're referring to para number?
Para 2 of the suit. It starts at page 15. I'm requesting the court's attention to page
there is a
16.
reference at page 16.
Page 16.
Para 16.
Yeah. Para
16 of the plaint. The defendant number 2 and 3 who are acting for and on
Yes,
behalf
my lord, that's what we are all doing, decision day-to-day affairs of the company. That's what our High Court has taken a view. Day-to-day affairs, directors, unless and until there is a.
Let us say a counsel, representing the counsel for the respondents of its staff. The court has allowed an application under Order 1 Rule 10, simply by pleading the petitioners herein as defendants number 2 and 3. It is submitted that the suit is filed against the company and the company is represented by the managing director, It is submitted that now the other directors need not be made parties to the suit in their individual capacity. She relied on an order passed by a coordinate bench of this court.
Copy.
Take that.
But I rely upon this decision, BA Contracts. Not, so directly I'll take my lords.
BE Contracts Private Limited versus Mrs. Varun Enterprises. And relying on this judgment, it is submitted that they are not the proper and necessary, neither proper nor the necessary parties to the suit. Considering the same, they shall be stay of all for this proceeding pursuant to the order dated so and so. Notice to the respondents and the hand summons of the counsel. Memo shall be filed by 30th or else a stay granted by this court stands vacated.
The lordship has granted me stay of. Lord, may I make one indulgence? Serial number 30, if your lordship would permit. 36 is the petition by the other director. D4, same order, verbatim same, two separate orders. It had come together, your lordship will recollect.
List along, same suit.
Same suit, the petition is filed by D2. This petition is by D3, that is by D.
31 it is submitted that it is connected.
36, writ petition number.
36 is connected with this writ petition.
21630.
Tag on with this.
Please, my lord. And same order in that also. Lordship.
Proceedings are stayed.
Yes, ma'am.
So.
It makes a difference. Oblige.
Yes, please.
I appear for the petitioner, Malats. The second defendant's writ petition, Malats, suit for partition, Malats, and the gift deed in favor of the executed by petition number 1 in favor of petitioners 2 to 5. 4 is not binding on the plaintiff is a prayer made in the suit, Malats. After the framing of issues, Malats, the second defendant first defendant legal representatives filed written statement, come counterclaim, Malats. Counterclaim is again the same gift deed is not binding, Malats. So the relief claimed in the counterclaim is against the co-defendant, that is second defendant, Manats. Now I file a written application seeking leave of the honorable court to permit me to file written statement, Manats. That application is dismissed, Manats.
When was which year? What is the delay in filing the written statement?
There is 1 year delay in filing written statement. That application itself is not taken on record. It is not decided on merits. It just says Order 8 Rule 6A says only the plaintiff can file counterclaim. But the relief sought in the counterclaim is against me, Malats. My lords are aware, Malats, in a suit for partition, Malats, plaintiffs are defendants and defendants are plaintiffs, Malats. When a co-defendant is making a counterclaim against the co-defendant, Malats,
the petitioners of his when the defendant number 1 has taken a contrary plea against the interest of defendant number 2, the defendant wants to file his written statement. The same was not entertained by the court by order impugned. Hence, the defendant number 2 is before this court considering the same. There shall be stay of all for the proceedings pursuant to the order dated so and so. Same notice and in addition hand summons.
May request the dispensation of notice to the plaintiff and the other respondents. Only defendant number 1.
Why plaintiff is not required?
Well, it's because plaintiff. I'll take notice to plaintiff. That's proceedings may kindly be stayed. Please.
What's the plaintiff's writ petition against the non-consideration of an ad interim order? Page 41 is the order, my lords.
No, I think this is the only season for this writ petition.
Lords, what happens if the courts do not exercise their discretion? It becomes very difficult, my lords.
All the Bangalore court is passing these orders.
This kind of orders is being passed. Other courts, we are not facing this problem. Page 41, your lords may kindly see paragraph number 3. That is the order. Very interesting.
It also says that principles of natural justice.
No, here it says, in order to grant an ad interim ex parte order, I need to hear the other side.
Which court is this? Yes, CJ. They are getting all novel ideas.
I know, my lords.
Come, the present petition is filed, agreed with the order, dated, what is the date of the order?
Lords, the date of order is 14/10, sorry, 24.
28/6.
28/6/2026.
28/6/2026, whereby the court
25 alva.
has failed to consider an IA,
25.
I number 1 filed under order 39 rule 1 and 2, seeking ad interim injunction. The court ad interim injunction, hence the petition is, plaintiff is before this court. Then the senior counsel, appearing on the counsel for the petition, submits that. The court, while issuing suit summons, observes that that the case requires consideration. At this stage, it is not a fit case to grant ad interim order, and before passing any ad interim ex parte temporary injunction order, hearing of defendant's side is necessary, and summons were issued, and the returnable by 14/10/2026. It is submitted that when an application is filed seeking ad interim injunction, if there are no merits in the petition, the court has to pass a reasoned order, but the court cannot adjourn the matter by issuing suit summons to the respondents. He has relied upon the coordinate bench of judgment of so and so. In the light of the same, this court is passing the following order. The writ petition is disposed of, directing the trial court to consider IA number 1 within a period of 1 week from the date of receipt of the copy of the order. Notwithstanding the fact that the suit summons were not served, the petitioner can seek for advancement of the matter.
Great, my lords.
I appear for the petition of my lords.
Yes.
My lords, in this we have instituted a suit for permanent injunction, seeking to refrain the defendant number 1, which is a municipality corporation, from refraining to dispossess us from the suit scheduled property or from disconnecting the electricity connection that has been provided to us. While the suit is pending, my lords, defendant number 2, which is the Tehsildar, has filed an application under section 20 of the Land Grabbing Prohibition Act. Under that, seeking to transfer the suit to the land grabbing court. My lords, the said application came to be allowed by way of the impugned order, challenging which we have come before your lordships. My lords, there's 2 glaring infirmities within this impugned order. One, my lords, it records that the petitioner, my lords, petitioner over here has runs a STD booth on the roadside of a municipality road. We have by permissive possession over the property in which we are running our shop. Now, my lords, we have over a decade we have been complying with paying the ground rents and taken all necessary permits. But towards the end, my lords, we have faced some financial constraints and we were unable to make ground rent payment. Therefore, my lords, the officials of the municipality has come forth.
Come to para 10, then you can make your submission.
Please, my lords.
Para 10 of the impugned order.
Please. On perusal of the plaint application objection materials on record in the present suit, the dispute relates to government land as admitted by the plaintiff himself. The plaintiff is claiming a relief of permanent injunction restraining the first defendant, their men, servant, agents, or any person claiming under them not to dispossess the plaintiff from a scheduled property or to disconnect electricity connections bearing RR number 82678 provided to his shop. Admittedly, a scheduled property is a government property. Apart from the sketch and RTC of the survey number 397/1A2 furnished by defendant number 2 also clearly shows that a scheduled property belongs to government. Well, we are not disputing the fact that this is a government property. Yes, ma'am. Well, if I may kindly bring your lordship's attention to paragraph number 14 of the impugned order. In the present case, as admitted by the plaintiff himself, the plaintiff has in permissive possession of a suit A scheduled property since 1996, and now the plaintiff is seeking permanent injunction, which is a matter of trial.
Lord, the impugned order is of 2020.
Anybody who is in possession of the government property, then he is a land grabber.
Lord, admittedly, my lord, this is impugned order is of the year 2023, my lord. Proceedings are pending before land grabbing court. We draw your lordship's attention to.
But it is transferred to land grab.
It is already transferred.
What are you doing from 13th September 2023?
Please, my lords, in the land grabbing court, we has essentially recorded that the petitioner herein has expired, and it is only when notice is sent to the legal respondent.
You don't question that order of 2023. You proceed before you the proceedings were going on before the land grabbing court.
We have never appeared. We have never received a notice.
You did question it, and why should we interfere now?
My lords, we were never brought to notice about the proceedings that is happening in land grabbing court. Essentially, my lords, one more aspect comes.
Essential, you please tell the court, an order is passed in 2023, you were a
Yes.
party to it. Why you have not
My
questioned
lords,
it?
there is a confusion that again arises in the operative portion of the impugned order. The learned trial judge has proceeded to reject the plaint and at the same time transfer the suit and in the section 20.
So either ways it is against you. You have to question it.
Please, my lords.
What were you doing from the last 3 years?
My lords,
Because there is no limitation under 220. Whenever you want, you can come and file the writ petition. Why should we entertain it?
my lords, now a question arises. If
Nothing arises. You have to first prima facie. Why you have not questioned it? For that you have to give an answer to that. At least you should have stated so. Why you are coming, questioning an order of 2023 now, being a party to the proceedings?
my lords, it's only when we got the notice about the land grabbing proceeding that's taken place, we realized that there's
The
a
order,
proceeding
you
happening
cannot
in the
say
land
that is-
grabbing.
That is notice to you.
Please, my lords, we have sought for quashing of the order as well as, my
You
lords,
could have
consequently the
done it
LGC
long back, 3
proceedings.
years back. Why you have not said? Or why you have not done? Anything in your petition about this? Why you
My
have
lords,
not come
the
before
very
the
fact
court?
that we are not aware of the land grabbing proceedings taken place is the reason why we hadn't
Can't
approached at that
submit
point.
that. You are aware of this order.
Please, my lords.
Land grabbing proceedings is consequential to this order.
Please, my lords.
When you don't question it, the proceedings will go on before the land grabbing court.
My lords, the one question that now arises is when there is a rejection of plaint that has essentially taken place, whether that this construes as
Court has to go to the next question, you have to pass through the first hurdle. Is that? There is no satisfactory answer from you. File your objections.
Please.
Smarter in the month of September.
Take notice for
HA takes notice on
for
behalf of,
respondent number 2 only, madam.
who are the other respondents?
One is Chief Officer of Municipal Council, 3 is MESCOM, my lord.
PESCOM, Mr. Devraj is directed to take notice. Number 1, who appears?
There would be panel council, my lord. Let them take out,
Somebody.
I'll verify and I'll.
Tell the court officer, so and so takes notice. List in the month of September. All the respondents shall file their objections. Yes, next.
grateful.
Yes, I appear for the petitioner.
Lords, I appear for respond number 1. I am defendant number 1 before the trial court. I saw the cause list and I have come before this court. I may be permitted to take notice, my lords. Matter may be had next week.
No,
But
no. First of all, let me hear him. If it's a case for interim order, I'll grant. If it is not a case, then I'll issue notice.
As
Or if
such-
if I want to dismiss it, you don't know.
my lords, the next date of hearing before the trial court is 19th August.
Let me hear the matter. Yes.
My lord, the petitioner herein is the plaintiff, filed a suit for relief of declaration as to declare the descheduled property as a common road or passage for ingress and egress of suit schedule A property. The facts of the case is, my lord, one, Iranagaya is the
The plaintiff or the defendant?
plaintiff before the trial.
What is IA?
Not IA, my lord. After filing the suit, they filed a written statement contending that suit is not properly valued. On the basis of their written statement, the court has passed an order. The suit should be, they have sought for a relief of declaration and the valuation should be made on the basis of the market value of the suit scheduled property. That is not an issue, my lord. My contention before the trial court is, my lord, I am seeking right of the common passage over the sale deed dated 25/3/2004, which my brother sold in favor of one Guru Rajan Naidu. In that sale deed,
According to you, you have to pay the court fees under which provision?
I have valued under section 30 of the Karnataka Court Fee and Suit Valuation Act because it is a easementary right.
Come to your plaint.
Please, my lord. Prayer is at page 26, my lord. Declare the suit schedule D property as common road or passage which is part and parcel of suit schedule C property for ingress and egress to suit schedule A property for permanent injunction restraining the defendants from interfering with
Now
the
come to the order, I seen.
My lord, kindly take my lord, page 88, my lord, para 3,
88.
88. The defendants contended that valuation made by the plaintiff is incorrect and the suit ought to have been valued on the market value of the suit scheduled property. A careful reading of the plaint discloses that plaintiff is not merely asserting an easement right of way over the property of another, The principal relief sought is a declaration that suit scheduled property itself is a common road or passage. The declaration sought is therefore with respect to the immovable property. The consequential relief of injunction is
Yes.
Firstly, my lord, I filed an application to vacate the temporary injunction. We had a temporary injunction in state.
That is an independent.
I made a submission that prima facie case includes maintainability of the suit before the trial court.
That will be considered. As far as the court fee is concerned, this order on the face of it is not correct.
No, my lord, his cousin had filed a similar suit. He had valued the property at 50 lakh rupees. My lord. I have filed along with my written statement. I don't have the papers, my lord. Matter may be highly explained.
This is matter on Tuesday.
it will be taken up in the Tuesday, it will be Wednesday, my lord.
Wednesday in the first list.
Much-
So and so, print his name, so and so submits the DS instructions to file wakalat.
For the petitioner, my lords.
Papers are served.
Yes, I have served, but it did not reflect their name by mistake.
Matter may be
My
taken up next week, my lords.
No, that's the reason that it has to be adjourned. Caveator's name.
A
In the
short
name of-
date may be given.
In the name of so and so, it is submitted, he has filed the caveat, and this is name is not reflected in the court. Tuesday we'll have.
Yes, ma'am. It's no objection that they are on caveat. We have served it also.
Served papers are served.
Yes.
Registry is
My
directed
lords,
to
I
print the
appear
name.
for R2, my lords.
Matter on Tuesday.
On 10th of July, we filed our wakalat, but the name's not reflecting the cause list, my lords.
You represent who?
Notice
R2,
is
my
not
lords.
issued.
Respondent number 2.
Notice is how.
Not if notice is not issued unless they are on
But we've
caveat.
already filed. No, we actually the caveat was
You
filed.
file wakalat when the court has not even issued notice.
No, my lords, caveat was filed, my lords. That's why
Come to
we
the
had
court
already
on the
filed
day.
wakalat.
You have not filed caveat, you have filed wakalat. That's why your wakalat is not reflected here. Come to the court on a day when the matter is coming. Yes,
Great. My lords, the date may be fixed.
Tuesday.
Great.
In the first list.
Great.
And for the petition, my lords. It is a similar matter, my lords. The vehicle which was not registered, even though it has been purchased in the year 2000.
List along with, what is the number batch?
105611.
Yes.
I have given.
561.
What is the number?
Yes.
Lordships, and for the caveat here, there's no caveat, my lords. His caveat has expired. No, his caveat has expired. I'll just point out, I'm not asking for much, my lords. I have suffered an arbitral award for 1.3 lakhs. My lord may note that. It's a very, very small issue. The arbitrator by mistake, my lords, has imposed 15% per month. So effectively 180% or 160% per year. They have filed a memo of calculations before the execution court and the section 34 court claiming 3.5 crores for a 1.38 lakh claim. I'm only seeking this, my lords. I filed a section 34 that is pending consideration. My lords, till such time, let me be given a stay. It's been 6 months since my section 34 has been filed. It's not been considered. My stay application is not considered.
Considered. We will not pass any order here.
Let them not precipitate the execution.
Please come. What are you questioning here?
Yes.
That non-consideration of your application.
That's right.
That we'll ask the court to consider.
Please. Your lordships, I have just one submission on the prayer portion, my lords. I just have the prayer printout. The first prayer they are
So
asking.
understand, I'm not passing any orders. I'm not considering it.
Yes, ma'am.
His grievance is his application for stay is not considered.
Yes.
I'll ask the trial court to consider it.
Just one submission, my lords. It's posted for hearing today. We have sought for Passover in the commercial courts. If my learned friend can come to the commercial court, we'll argue the matter right now, my lords. Right? Yes. My lords may pass that order. The difficulty is, I'll point out. 3.3 crores is a memo of calculations.
But it is.
No,
That
let me,
stay application
I
is
understand,
heard.
I understand. My lords is aware, in most arbitration section 34s, there is a 50% deposit. Usually it's a general standard. Now, I understand, my lords, on 1.3 lakhs, 50% I understand. On 3.3 crores owing to an order, my lords, where 15% per month is ordered.
That you have to argue before.
I understand. My lords, all I'm saying is this. My lords, may just for a moment see the memo of calculations. If it's fair, my lords, I understand.
I do not believe in passing those kind of orders when the matter is pending before the
Please.
court. Let the court decide it.
Please. Let them not precipitate the execution.
We
my
will
lords.
not. That is in a matter amounts to granting an order.
No, there's a connected matter also.
No,
Field
as
number
far as-
28.
no, first of all, in 25, I'll ask the court to consider the
Please.
application
Expeditious.
within a period of how much time?
1 week, my lords, we're ready.
Yes.
All pending applications, my lords. Because one IA is for continuation of delay.
You have not come to the court. He has come to the court. We'll ask only his, as far as his relief is concerned. The petition is filed, the writ petition is filed, seeking the following prayers. Learned counsel appearing for the petitioner submits that when the, on an amount of rupees, the one lakh
1,38,000.
8,000, the award of the arbitrator along with interest would come to
As of today, my lords, as per their calculation, 3.3 crores
3.3 crores.
in a span of 1 year.
In a span of 1 year. The petitioner has filed an application under, section 34.
My lords, 2 years, my lords. It's 2024 award, my lords.
It is in November of 2024.
You're not understanding. I'm not passing anything on. It's all his contention. He has every right to submit whatever he wants.
By you. Let his contentions not prejudice the.
No.
Let there be a observation.
Submits that when he has filed an application seeking stay of execution of the award, the court, that is IA number
2 minutes.
IA number 2, the court has not considered the same. Hence, he has come before the court. Learned counsel has submitted on the merits of the matter that there may be a direction to the respondent not to precipitate the execution. Learned counsel with the respondents who is on caveat has also submitted on the merits of the matter and submits that the writ petition is not maintainable.
Yes.
Heard the.
No caveat. There's no caveat.
According to the petitioner, respondent, he is on caveat. According to the learned counsel of the petitioner, his caveat expired.
No, it's certainly not.
Having
14th July at 5 minutes.
Having heard you have to understand what is happening.
I apologize.
Having heard the learned counsels on either side, there was a material non-record. The whole grievance of the petitioner is that his I number 2 is not considered by the court. If in the considered opinion of this court, if the trial court is directed to consider the application, it would serve the ends of justice. And this court, in this process, cannot pass any interim order affecting the rights of the parties. In that view of the matter, this court is passing the following order. The writ petition is disposed of, directing the trial court to expeditiously decide IA number 2 within a period of, but not later than, as expeditiously as possible, but not later than a week from the date of receipt of the copy of the order. All the contentions are left open to the parties.
Grateful.
Yes.
28 is also.
28 is similar.
That's the execution petition we had challenged, my lords. The order's there. Because what has happened is it's already posted for orders.
Because execution court is bound by the order that you get in 38, 30.
Precisely. I am stuck, my lords. It's a race between two.
In the light of the orders passed in WP number 21258 of 2026, this court do not incline to pass any orders in WP number 21355 of 2026. It is left to the parties to avail that's it. Accordingly disposed of. Next.
Grateful.
Next. One more matter.
My lords, I appeal for the petition in this matter, my lords. This is on IA common order passed on IA number 234.
What are those two? The other day you were.
Yeah, yes, my lords. So this is another IA.
Submitting that, it is submitted by the counsel the petitioner that this court. Then that day I said post along with it.
There is no notice issued, therefore office has posted
this court. What is the number? Give the
number, my lords. 19930.
This court submits that. There are 3 IAs. In respect of 2 IAs, already 2 writ petitions are filed, and this court has granted stay by order dated so and so. And this is the 3rd writ petition. List this matter along with so and so. Already suit is stayed. No separate order is required in this.
There is already a stay, my lords.
Yes.
And not permitted to take no such service. Yes.
In this also, whatever in that, permitted to take court hands. Yes, 27.
Lord, trial court, my lord, has not granted me an ex parte order and issued emergent notice.
Where is that?
My lord, the order, my lord, is 3/3/2025.
Number?
Lord, Lord, that is at page 223. Lord, what has happened, my lord, is I purchased this property in 2007.
I am not passing any orders in these kind of matters. I am only asking the trial court to decide it within 1 week, notwithstanding the fact that the summons are not served. I am not interfering, not even in one matter I have interfered.
my difficulty is this, my lord. I have taken notice.
Difficulties now will be considered by the court within 1 week, whether notices or summons are served or not. Your purpose will be served. Where is this order?
But 225 now. 223, 223.
2, 3. That's IA number 1 and 2. Issue
Yes.
notice to the defendants returnable by 12/6. It must have come. When is
No,
it
my lord.
posted now?
Lord, now it is posted in next month, but my lord, they are dodging service. What they have done, my lord, is I purchased it in 2007. I run a school. My lord, I have produced photographs also. I have permission from the government running a school. They file a collusive suit. This property purchase is after taking government's permission under 109, all that process. They file a parallel suit, plot, collusive suit between the family members, get a decree. Now they are trying to execute the decree, my lord, and then they have given some request to the ADLR.
The petition is before this court, questioning the order dated 3/3/2025, 2026, passed by the senior civil judge, the principal senior civil judge, Bangalore Rural, in OS number 405 of 2025, wherein the court has issued two summons on IA number 1 and 2. It is submitted that in the light of the urgency, when an ad interim injunction is sought, the court, instead of considering the same on the merits of the matter, issued two summons. The senior counsel has relied on a judgment of the coordinate bench of this court. Extract that. In the light of the contentions of the learned senior counsel, and also considering the judgment of the coordinate bench of this court is passing the following order. The writ petition is disposed of, directing the trial court to consider IA number 1 and 2 within a period of 1 week from the date of receipt of the copy of the order, notwithstanding the fact that the two summons are not served on the defendants.
Good.
Your lordship.
Till now,
Your lordship.
24, notice may be added.
24. In 24, notice to the respondents post along
No,
with.
my lord. 2 and 4 I will take
24
notice.
state.
2 and 3 I will take
2
notice.
and 3, HCGP takes notice.
1
The
and
other
4
one-
Mukund Prasad, my lord. Mukund Prasad, 1 and 4.
That's for 1.
1 and 4.
1 and 4. Then
Please.
who are left?
2 and 3,
No
1
one
to
has
4,
left.
only 4 respondents.
This is
are
a done.
No, notice has to 1 and 4 as the central government, my lord. Mukund Prasad has filed wakalat.
This is what I'm saying.
Yes.
1 and 4,
Yes.
2 and 3, he takes.
Yes, that's.
So what is left?
No, nobody.
So and so takes notice.
ಮಧ್ಯಾಹ್ನ ಫಸ್ಟ್ ಇಷ್ಟ ಸೆಕೆಂಡ್
Madam, it is to continue.
ಅಲ್ಪನೆ ಬೋಧಿಕ
ನಮೋ ಕಳಿಸಿದ್ದೆ
ಎಲ್ಲಿ ಇಲ್ಲ ಅವನು ರೆಕಾರ್ಡ್ ಬರೆಯೋದು ನಾನು ನನ್ನ ಸೆಕೆಂಡ್ ಹಾಕಿದ್ರು ಅವ್ರು ಯಾರೋ ರಜೆ ಇದ್ರು ಅಂತ ಸರಿ ಆಯ್ತು ಬಿಡಪ್ಪ ಬರ್ಕಂತೀನಿ ಅದಕ್ಕೆ ಯಾಕೆ ನಾವು ಹಾ ಇಲ್ಲ ಇಲ್ಲ ನನ್ನನ್ನು ಹಾಕಿದ್ದಾರೆ ನಾನೇ ಬರೀತೀನಿ ಅಂತ ಮತ್ ಬರ್ಕೋ ಮತ್ ನನಗೆ ಯಾಕೆ ಹೇಳ್ತೀಯ ಅಂತ
She'll take a second.
ಪಾಸ್ ಓವರ್ ಫಸ್ಟ್ಗೆ ಕರೀತಾರ ಅಥವಾ ಆಮೇಲೆ? ಇಲ್ಲ, ಸಿಂಪಲ್ ಮುಗಿಯುತ್ತೆ ಬೇಗ. ಡಿಕ್ಟೇಷನ್ ಮಾಡ್ತಾರೆ ಮೋಸ್ಟ್ಲಿ.
ಹಾಕೊಳ್ಳಿ ಮಂಡೆಗೆ ಕಮಿಷನ್ ಬಂದಿರಲಿಲ್ಲ ಡಿಸ್ಪೋಸ್ ಆಗೋಗುತ್ತೆ ಎಂಟ್ರಿ ಮಾಡೋ ಹೋದೇನೆ ನಿಮ್ಮ ಲೈಸೆನ್ಸ್ ಸ್ಟಾಪ್ ಮಾಡಿದ್ರೆ ಇನ್ಕಮ್ ಕೇಸ್ ಮೇನ್ ಅಪೀಲ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಮಂಡೇ ಹಾಕಿ
ಕೆಳಗಡೆ ಕೊಟ್ಟಿಲ್ಲ ಎಕ್ಸ್ಪರ್ಟ್ ಕೊಟ್ಟಿಲ್ಲ ಎಕ್ಸ್ಪರ್ಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಲೀಕ್ ಬಂದು ತಗೊಂಡು ವಾಪಸ್ ಕಳಿಸ್ಬೇಕು ಅಷ್ಟೇ ಇರೋದು ಅದು ಬಿಟ್ರೆ ಇದಿಲ್ಲ 2 ನಿಮಿಷ ಕೆಲಸ ಸಾಕು 1 ನಿಮಿಷ ಕೆಲಸ ಇಲ್ಲ ಸಿಪಿಸಿ ವಾಪಸ್ ಕಳಿಸ್ಬೇಕು ಅಷ್ಟೇ ಮೇಡಮ್ 1 ನಿಮಿಷ 30 ಸೆಕೆಂಡ್ಸ್ ನಾನು ಅಗ್ರಿಮೆಂಟ್ ನಾನು ರೆಸ್ಪಾಂಡಿಂಗ್ ಇದ್ದೀನಿ ಮತ್ತೆ ನಾನು ಹೇಳ್ತೀನಿ ವಾಪಸ್ ಕಳಿಸ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ಅಷ್ಟೇ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೋದಲ್ಲ ಅದು ಮೇಡಮ್ ಲಿಸ್ಟ್ ಬರುತ್ತೆ ಅವ್ರು ಹೇಳ್ತಾರೆ ನೀವು ಕೆಂಪು ಪೆನ್ನಲ್ಲಿ ಹಾಕಿದ್ರೆ ಅಷ್ಟೇ ಬರುತ್ತೆ ಹೇಳಿದ್ರೆ ಬರಲ್ಲ ಅಂತ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಏನೋ
Serial number 21. ಅಲ್ಲ ಲಿಸ್ಟ್ ಇರುತ್ತಲ್ವ ಅದು ಬರ್ದಿರುತ್ತಲ್ವ ಅದಕ್ಕೆ
emergency is not getting leaked. This also is a- ಸ್ವಲ್ಪ ಹೇಳ್ತೀನಿ ನಾಳೆಗಾದ್ರು ತಗೊಳ್ಳಿ ಅಥವಾ ಮಂಡೆಗಾದ್ರು ತಗೊಳ್ಳಿ ಅಂತ ಮಾಡ್ತೀವಿ ಡಿಸ್ಪೋಸ್ ಆಗೋ ಕೇಸ್ ಹಾಂ ಓಕೆ ಕೆಲಸ ಹೇಳಿದ್ರಪ್ಪ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಹಾಂ ಮತ್ತೆ ಇವ್ರು ಹೇಳಿದ್ರಲ್ಲ ಕೇಳಿ ಅಂತ ಪರ್ಮಿಷನ್ ಕೇಳಿ ಫೋನ್ ಮಾಡಿದ್ದೀನಿ No, it is coming glitches. He did not type it. Glitch ಆಯ್ತು.
Continue the list.
It's appear for petition, my lord.
Yes.
The petitioner is the defendant number 6 of the trial court, my lord. He has filed the order 9 rule 7 application, my lord. Recall the set aside expert order, my lord. The trial court has dismissed the application. For the reason.
Let's see that order.
My lord.
Let's see the order.
Yes, my lord. Page number 15, 14, 15, my lord. Page number 14, number 6 of the order, my lord. There is a delay in 7 years, 9 months. There is a delay in 7 years, 9 months, 10 days, my lord. He is filing the recall application, expert has set aside order, my lord. If this application is not allowed, my lord, multiplicity of the proceedings is there, my lord. Yeah.
Apart from that, what is the reason?
My lord, now, my lord, the case was posted for
Why you have come to the court after 7 years, 9 months?
My lord, we are not see the summons, my lord, because he's working in coolie worker, my lord. He's another working in the Tamil Nadu state, my lord. He's border of the Karnataka border and Tamil Nadu, my lord. He's in the working.
What is the suit for?
Suit for partition, my lord. He has subsequent purchaser of the property. The suit is.
What is the finding with regard to this purchase?
My lord,
With regard to this sale, what is the finding in the suit?
My lord, the now suit is in the WS of the defendant number 7, my lord. Now, my lord. The evidence is not commenced, my lord.
After 7 years also?
Yes, my lord.
Notice to the respondents.
My lord, stay may be granted, my lord. Otherwise, the matter was.
I should actually dismiss it. I'm issuing notice, and you can't ask for stay in that.
Well,
it's notice to the respondents.
Respondent number 1, my lord. Other respondent, formal parties.
Who are the other respondents?
The defendant number, defendants, my lord.
Number, how they are read here?
The respondent number 229.
The memo is filed stating that notice to respondents 2 to 9 may be dispensed with. Their former parties as far as this application is concerned. Accordingly, memo is taken on record and notice is dispensed with. Notice to respondent number 1, petition is permitted to take on hands. Yes, in addition. Yes.
Petition in this case. There's a defendant's writ petition that a suit for permanent injunction gets filed by the plaintiff. An application for seeking temporary injunction, my lord, is filed. That court, my lord, hears, my lord, the plaintiff comes to the conclusion that the other side has to be heard and declines to grant, my lord, an order of injunction. My lord, I enter appearance. That court grants me time, my lord, to file my written statement and statement of objections. That matter stands at a particular point of time. After about month and a half, my lord, the plaintiff moves another application, my lord, only seeking, my lord, preponement of the hearing. My lord, does not file any application, my lord, afresh. My lord, the court, my lord, takes into consideration that application and, my lord, passes an order of injunction, which was not at all sought for.
No, first of all, that earlier application, when then an ad interim injunction is sought, the court has to consider it on the merits of it. There is
Correct.
a question of issuing notice.
Correct. Doesn't do so. Court doesn't do so, my lord. On the other hand, my lord, passes an order against me, my lord, without me filing statement of objections and, my lord, the written state.
Where is that order?
Please. I'll take, my lord, and my lord, kindly take, my lord, page 19. This is where the first day's order court says that, my lord, other side has to be heard. Peruse the material on account, there are no grounds to pass an ex parte TI order. Hence, it is
The
just.
present order.
Final order is the next page, my lord, page 20. Absolutely no allegations, no material, my lord, placed before the court.
He has filed a memo along with the hand sketch photographs of the suit property.
Correct.
And photographs of it is submitted. The defendants are attempting to put up construction.
It's all, my lord, false submission. There's no application, my lord, filed. What stood, my
I'll
lord?
ask the court to hear it on a particular day. Let it be advanced. We will not interfere with this order now.
My lord, please appreciate, my lord, this. My lord, what is sought by, my lord, the plaintiff himself before the court
My lord, I have filed, my lord, the IA1 that was filed. Please take, my lord, page 36.
Yes. Yes.
Please to grant an ad interim order of injunction against the defendants restraining them, their agents or anybody acting through them not to interfere with the suit shall properties pending disposal of the
Now,
suit.
this is what it is. Now,
Correct.
he has filed an IA. What is this IA? Let us see that.
This, no separate application. This is the only IA.
Application filed with the, filed by the land council, the petitioner.
That's only for
On the
advancement.
ground of urgency. What is that petition? Where
That is there.
Page number?
But I'll just keep. But page 47, it doesn't accompany, my lord, affidavit of a party. That's council, my lord, swears to it. But this is the application. Advance the above case from 14/8/2026 to 15/6/2026 to here on IA. Memorandum of facts, reiteration of, my lord, the earlier pleadings.
At page 37.
Please, no, page 47, I'm sorry. Annexure G, my lord, is the advance. Doesn't he not even supported
Was
by,
served by the time?
I was served as on that day.
When did you file your
Correct.
wakalat?
No, my lord, but my presence is noted on 2/6, my lord. Defendants files application to 148 CPC. Peruse the say, application 140 is Alba. For written statement and objections, 14/8/2026 is the
He is
date.
to advance the above case from 14/8/2026 to
Correct.
15/6/2026 to
Yes.
clear an IA.
Yes.
Earlier IA.
Earlier,
He asked for injunction.
Injunction.
Court has granted status quo.
correct. But my lord, the court, my lord, came to the,
Ad interim injunction is sought. It's for the court to decide it without whether notice to you is not at all required.
no, my lord, quite I understand. But court grants me time to file statement and objections. But at least 1 day's opportunity ought to have been given, having notified. But only takes into consideration the statements of the plaintiff. But court doesn't even, my lord,
Only when
hear.
an ad interim injunction is granted, that is what the court will look into.
Correct. My lord, what?
In fact, in cases where the courts are granting these kind of orders, I'm saying that no, notwithstanding the fact whether summons are served on them or not, you have to pass an order. And if the plaintiff is agreed, he'll question. You can't issue suit summons without consulting the application.
Correct.
Either you have to grant it or dismiss it.
But
Now, in this case, in your court has issued notice. Now, the matter is again, they have sought for that, this application is filed saying that to consider my earlier application in the
Correct.
interest, in the light of this, what is happening?
The court at least would have granted me, Lord, a day's time to file my objections, my lord.
What
have-
I'm saying is, I'll ask the court to hear you
Well,
immediately. Whatever, whenever you say, I'll ask the court to hear you.
Please.
In with regard to your objections, will consider it for this.
whatever is not sought for is granted. Lords will see, my lord.
They sought for injunction, court has granted status.
Not to, no, it doesn't stop at that. No, that's where I am aggrieved. Lord, kindly permit me to read further, my lord. Page 20, I read to my lords. Hence, both the parties are directed to maintain status quo with regard to the nature and physical features of the suit shall property as existing as on today. Fair enough, my lord. Further, defendants are further restrained from putting up any further construction, further obstructing the alleged existing use of the road by the plaintiff. But such a prayer was not there before the court. That's where, my lord, that's where, my lord, 227 has to be invoked. Such a prayer not being there.
Counsel for the petitioner submits that. The plaintiff has filed an IA seeking injunction. And in that, the summons were issued to the defendants. And after the defendants entered appearance, the petitioner, the plaintiff has advanced the matter. And the court, without giving an opportunity to the defendant, grants an order of status quo and also directed the defendant from putting up any further construction, from obstructing the existing use of the road by the plaintiff until the next date of hearing. It's coming up on
14/8, my lord. A month late.
That's the whole problem now. Now again, I grant an order here. And I'll do one thing. I'll say this as far as this order that the defendants restrained from putting up any further construction is there, that should not be given effect to, and the court shall hear your objection.
Sir,
So that, for the sake of, because no notices are not served, I'll keep it pending here.
Correct.
But for all practical purposes, the trial court will go ahead.
but
What did you write? Next date of hearing, when counsel submits that, when there was no prayer in the injunction in the IA itself, the court ought not to have granted this relief. Apart from that, when the petitioner has entered appearance and without any, without considering, without any notice to the petitioner, without taking the objections of the petitioner, without recording any of the submissions, you were not even present.
I was present, we pleaded, but court, my lord, straight away passed the order.
It is submitted that the submissions of the respondent defendant are also not considered. Next para, this court has perused the order impugned. As far as granting the order of status quo is concerned, the IA is filed seeking injunction. Initially, court has issued notice, and at the time of passing an ad interim injunction, generally the court do not require required to issue suit summons. The court has to pass orders on the merits of the matter. If the placing on the material, if the plaintiff is entitled, it will grant injunction, or else dismiss it. Then the plaintiff will avail the appropriate remedy available to him. In this case, as far as the status quo, order of status quo that is granted by the court, only till the next date of hearing, this court do not find any reasons to interfere. However, the order with regard to directing the defendant from from putting up any further the defendant from obstructing the alleged existing use of the road by the plaintiff until the next date of hearing is concerned, this order, even this prayer is not there in the IA that is filed seeking injunction. In that view of the matter, as far as the order, so as far as this portion is concerned, is state the trial court shall consider the object. You have already filed.
No, I'm yet to file, my lord, I'm immediately before.
Petitioner shall file his objections within a period of 1 week from today, and by the next date of hearing, the trial court shall consider the objections and then pass appropriate orders, notice to the respondents.
Grateful.
Yes. The petition is permitted to take out hand summons, or else the stay granted by 30th, or else the stay granted by this course transvocated. Yes.
Please. Before let a petitioner. In this case, let the petitioners are the owners of 1 acre of land in survey number 421.
What is the suit for?
Let suit for permanent injunction. Will kindly see at page.
And what is the IA?
IA for temporary injunction. I purchased this land in the year 76.
No, we'll go to the facts later. Then what happened?
I filed an application before the court and sought for temporary injunction. As the other side defendants are making an illegal interference, they are dumping waste in my land, and they have no manner of right. 76 to till this day RTC stands in my name.
What happened to the injunction application?
Injunction application not considered, simply notice has been issued.
Then I'll ask the court to decide it. Where is that order?
At page 67, annexure R1. The next page is the 68 is the operative portion.
3/8/2026. Yes.
I have made out a prima facie case before the trial court.
The court.
I have produced all the RTC.
Let the court consider without notice to the respondent.
Yes. Yes.
The petition is agreed with the order dated. What is this order dated? 8/7/2026, whereby the court has the principal civil judge and JMFC Enekal in OS number 472 of 2026 has failed to consider an application that is filed by the petitioner seeking ad interim injunction and issued suit summons returnable by 3/8/2026. It is submitted that the same order like the others. In the light of the same, this court is passing the following order. The trial court is directed to consider the application of the petitioner within a period of 1 week from the date of receipt of the copy of the order, notwithstanding the fact that the suit summons are served on the defendants. Petitioner can advance the matter, make a request.
Much, please.
Please, my lady, I beg my lady's indulgence to appear virtually in this matter.
Yes.
So I am the defendant appellant in this matter. The plaintiff initially secured an ex parte injunction on the basis of a certain user date of December 2022 in a trademark suit, which gets vacated by this honorable court after we prefer an appeal. After I file a written statement showing a user date of 2017, along with invoices at least from January 2022, the plaintiff moves an application for amendment of the plaint, now taking it back to December 2022 or rather 2016, only to go before me. And in their entire suit proceeding, their registration proceeding before the trademark registry, they have taken the categorical position that their user date is only from December 2022. So in considering the 617 application of the plaintiff, the trial court has not looked at the fact that this is not a mere change of figure, it alters the entire suit altogether, because the date of priority of use is the central contention in this matter because it's a suit for passing off. Therefore, my lady, this 617 application and the manner in which it has been allowed by the trial court is in the teeth of a Supreme Court judgment.
Let us see the affidavit that's filed in support of the IA. There is a.
Please, my lady. If my lady could come to page number 76.
Yes.
Please, my lady. This is their 679. So, my lady, if you kindly come to page number 76, this is the affidavit filed along with the 617 application. Kindly come to para number. My lady could come to page number 79, para 10 onwards, where the amendment is made. Please note that when they set up the case before the trial court, at no point of time did they actually say that there is a predecessor in interest called Sathwik, who actually coined the mark in 2016. That entire history, the existence of that entity or their user was not even referred to. The plaintiff takes the categorical position that the mark was actually coined by the plaintiff and not a predecessor in interest. This story comes about for the very first time in 617 after we file a written statement showing user since 2017. So the very purpose of this amendment application was to only antedate its user, and therefore the documents filed along with it ought to have been considered. The inconsistency in the position of the plaintiff ought to have been considered. The fact that this is not just a mere addition of additional particulars, but a change of the suit itself. And therefore, if my lords could kindly come to para number 8 at page number 78 at the bottom of it, my lady would find this is the story that is sought to be weaved. Para number 8 at the bottom of page number 78.
Yes.
May I read this for the court's benefit? I state that upon perusal of the written statement, the applicant undertook a comprehensive review of its historical commercial records. So a party which comes to court seeking an interim injunction did not put its best foot forward, chooses to go through its records only after I file my written statement. Please see, including archived accounting data and invoices maintained from the period when the plaintiff's business was carried on as a sole proprietorship under the name Sathwik International, which was subsequently continued as a private limited company. During the structured archival review, invoices evidencing sale of date bites as part of Happy gift assortments dating back to 2016 was retrieved. The existence of this business as a sole proprietorship from 2016 was not even whispered in the plaint. Can I just show one judgment of the Supreme Court, LIC versus Sanjeev Builders, which is squarely on the point. Unfortunately, the trial court has considered a division bench judgment of the Delhi High Court as opposed to being guided by the Supreme Court's law on the subject. Can I just request the instructing counsel to hand over a copy of the judgment file lady to consider?
No, please come to the impugned order.
Please, my lady. And my lady could come to page number 47 at Annexure C. That's where the impugned order starts. The reasoning of the trial court starts at page number 59 as part of paragraph 5. And specifically, my lady could take a look at page number 61, which is a continuation of para 6.3 that spills over from the previous page. Reliance has been placed on the division bench judgment of the Delhi High Court in superon. And therefore it says that the provision therefore casts a mandate on the court to compulsorily allow all such amendments as may be necessary for the purpose of determining real questions in controversy. That is the test that has been applied. Please see para 6.4. At para 59 of the said judgment, it is held that all that was required to see, therefore, was whether the amendment sought by the plaintiff respondent was necessary for the purpose of determining the real questions in controversy. This is the widest possible analysis or interpretation of the test. Could my lady kindly come to the reasoning further? I'll just show it. After this, only submissions. Para 11.
No, earlier his case was he was doing the business from 2022.
December 22.
No, he says it is from 2016.
2016 without even mentioning the proprietor ever in the plaint. He suddenly invents an entity called Satvik International, which apparently was the predecessor in interest. Would you not discuss that as the plaint in the first place? Can I just request my lady to kindly come to page number 66, which contains the reasoning, the finding there, just for a moment, just so that my lady sees.
I have read that order.
I'm grateful. So it is as telegraphic as it gets. So LIC versus Sanjeev Builders. Can I request my lady to kindly come to page number 35 of this judgment? This was delivered in 2022 as part of para number 71.4.1 at the bottom of page number 35, where the court is taking a holistic analysis of the interplay between Order 2 Rule 2 and Order 6 Rule 17.
Yes.
By the amendment, a time-barred claim is sought to be introduced, in which case the fact that the claim would be time-barred becomes relevant for consideration. So, my lady, kindly see that para 71.2 discusses all the considerations under 617. Please see, the amendment changes the nature of the suit. The prayer for the amendment is mala fide, or by the amendment, the other side loses a valid defense. These are the considerations. Please come to para 71.5. In dealing with a prayer for amendment of pleadings, the court should avoid a hyper-technical approach and is ordinarily required to be liberal, where the opposite party can be compensated by costs. Now, my lady could kindly come to para 71.10, where the amendment changes the nature of the suit or the cause of action so as to set up an entirely new case foreign to the case set up in the in the plaint. The amendment must be disallowed, where, however, the amendment sought is only with respect to the relief in the plaint and is predicated on facts which are already pleaded in the plaint. Ordinarily, the amendment is.
This is a pre-trial amendment.
Please, my lady, it is. My point is, if I may say so with the deepest of respect, even if issues have not been framed, the fact is a party has now set up an entirely new case, which is irrelevant to whether or not this is pre-trial or post-trial, because until I stepped into the picture, you were not wiser, and suddenly you want to go back to 2016, introduce a new entity.
Somebody takes up a claim saying that he is using it from the year 2016. It is for him to prove. What is the prejudice to you now?
My lady, the submission that is being...
He has every right to prove his case.
I completely
now, what
agree
is the prejudice to the defendant is the question.
My lady, if I may say so, it prejudiced the defendant because I have set up a case of 2017, and that's the only reason he's pushed it back. He's never even brought up this picture even before, and the reason, I'll just show one thing.
He has pushed it back to 2006 or 17.
Right.
No, ultimately, burden lies on him. It is burden lies on him to prove it with substantive material. Otherwise, that plea goes. So why
Can I just make one submission? One submission. Yes. My lady can consider this. When the Supreme Court says that the malefides of the amendment and the timing must be considered, just one aspect. Please see that this very plaintiff, when prosecuting his trademark application before the trademark registry, took the position of 2022 before entering the suit. So there is a document which is on record prior to the amendment where he has consistently taken a position of 2022. I can understand if this position was taken in a solitary fashion as far as the plaintiff is concerned. He has taken this position across the board. Therefore, the nature of the amendment, the malefides behind the amendment has not even been dealt with, which is why I just wanted to show that registration document just for a moment. Kindly take a look at that document, and after that I won't push the envelope further beyond this. Kindly come, please, my lady.
Without any basis, like without you entering in, before the appearance of the defendant, he files a suit contrary to his earlier for the FAMA and all. He'll say that from 2016 16 or 17, he's using it. Then in that
Right.
case, what will happen? Ultimately, he has to prove, you have to have your own defense.
My
So
lady is
even
right.
at this stage also, it stands on the same footing.
Which is why I wanted to dislodge this argument with one effort. Can I request my lady to come to page number 88, document number 4?
Yes.
Huh? So this document is just being physically handed over for my lady to see, just so that my lady knows why I'm making this point. I completely bow down to the.
All these documents are part of the trial court?
Yes.
Yes, they are. They are. No fresh documents. This is part of the trial court record.
Yes.
Can I just play this argument out for my lady's consumption? My lady is 100% right when my lady says, if he had set up a case for 2016, he just wants to go back to 2016 after I've entered the fray, I can still understand it. The document I'm showing my lady is to show 2016 as a date is entered into for the very first time, contrary to his own position before the trademark registry. Therefore, the malefidance of the amendment becomes relevant. Kindly take a look at the document just for a moment at page number 88. This is his trademark application. In this trademark application, page number 88, could my lady see the user detail mentioned there? Page number 88, document number 4.
88 in the first volume.
I would assume so, my lady. Can I request the instructing counsel to assist the court?
It's page 488 in this.
488, my apologies. Now I'm looking at the bibliography, not page number 488. I'm looking at the bibliography of the registration. In the documents filed along with the plaint, document number 4, page number 88. This was the document filed along with the plaint by the plaintiff before the trial court. This is the 4th document, my lady. And this document, which is filed along with the plaint, is the bibliography which clearly shows, please, yes. Please see page number 88. So which is why I wanted to show that when the sword of the litigation was not hanging, he has taken a categorical position with respect to the user date. Can I request my lady?
The plain documents.
No, you have just now you have passed on 2 sets. In which set it is?
This is the set.
This is another set.
My apologies for the inconvenience caused to the court. Can I request my lady to see the user detail which is mentioned perhaps in the 7th or the 8th entry there, 31st of December 2022. So this is a position that he's taken before the registry for such a long time. When he filed this application, my lady could see date of the application is 26th of March 2025, well before the institution of the suit. This is the date taken. The trial court should have at least considered why is it that before the suit was filed, he took a clear position knowing what his user detail was, and only after I filed my written statement, he changes the position. In fact, in the interim injunction which was originally granted, which was vacated by the Chief Justice of this Honorable Court, the order records his user of December 2022. This detail ought to have been presented to him. He should have explained this detail. This 617 could not have been allowed for the asking like this. That is the limited submission. So my lady would be 100% right. Please.
Stage of order 6 rule 17, we are conducting a mini trial, whether he'll be able to succeed to prove it, whether there are any other basis for.
Please. I'll just take 30 seconds, and I'm just saying that 617 is not granted for the matter of asking when on the face of it the conduct is glaring, and therefore it's not a question of mini trial.
That order 6 rule 17, let's see.
Please,
where are your objections to that?
I'll just show my objections, Mary.
Yes.
None of those objections have been dealt with in the 2 peremptory and telegraphic paragraphs of the impugned order.
Let's see that.
My objections would be at page number 87 as part of Annexure E. May I tender my apologies at the outset for sounding pushy. I'm just trying to compensate for my absence of physical hearing. My sincere apologies for this. My lady could come. Para number 2. May I just read this for the court's benefit?
Yes.
Firstly, the proposed amendments fundamentally challenge the nature of the case originally pleaded by the plaintiff. In the original plaint, the plaintiff unequivocally pleaded that the mark was conceived and adopted in December 2022. The plaintiff now seeks to amend the plaint to claim that the mark was conceived and adopted in September 2016 through its alleged predecessor. This is not a mere clarification or elaboration of an existing pleading, but amounts to a complete shift and a departure from the plaintiff's claim. And I'll explain one reason. In a suit for passing off, prior use is the entire case. That's the foundation of the case. And therefore, this is not just a shifting of the date, it's a shifting of the goalpost. Such an amendment clearly changes the nature of the suit and introduces an entirely new case, which is inconsistent with the case originally pleaded by the plaintiff. Second, the proposed amendments are clearly malafide and have been sought only after the plaintiff had the benefit of the written statement. The defendant had categorically pleaded that it adopted the mark prior to the plaintiff. So my lady sees this. Then my lady, the reference with respect to the trademark application as well. I'll just show this. Kindly come to para number 3 for a moment. My lady would see in para number 3, we have clearly said that it's not as if December 2022 appears in one solitary paragraph in the plaint. Throughout the plaint, this is the running train of thought. There is continuity of thought there. He doesn't even speak of Satvik International as a predecessor or sole proprietorship or invoices to that effect. 6 years is the difference between the case set up originally and now that is sought to be antedated. Therefore, my lady, my humble submission would be, at least there should have been some application of mine. Otherwise, this kind of allowance of...
Just now you have drawn the attention of the court to that particular document at page 30, document number 4.
4, please, my lady.
So, with respect to that document, where are your objections in this?
I'm just opening. Yes, my lady.
Yes.
I'll just open this. Yes. The reference to the trademark application. I get what my lady is saying. Just a minute. Let me just open that portion. That reference to the trademark document is not specifically to be found in the objections, but that argument has been taken, my lady, and the document was specifically there. I'm so grateful. My lady could kindly come to, so sorry, not this. So as far as the trademark document is concerned, that doesn't find a reference, my lady, but this was before the court as part of the trial court record. The argument has been taken. The only thing is we have not made a reference to the trademark document, but it's a part of the record that should have been considered. I concede that point, but the only thing is it's not a new document. There's no new argument being presented. In substance, the argument has been spelled out clearly in the objections. That should have at least received some application of mind.
I'll pass order. Heard, reserved.
I'm so grateful. Deeply obliged for the patient hearing, my lady. Grateful.
33, Ajit PB for petitioner.
For the petitioner's minutes.
Yes.
Impugning the order of the notice mailers issued by the KEB mailers, BESCOM mailers, where BESCOM has issued the notice mailers stating that mailers that there are certain deviations in the construction and internal communication has been issued by the BBMP. Therefore, mailers they have to disconnect the.
Where is that list? List BESCOM. Mr. B.S. Karthikeyan is directed to take notice on behalf of respondent 1 and 2. This is matter tomorrow. So papers on.
Please,
Registry is directed to print the name of the
respond number 2 is BBMP. It is a Greater Bangalore.
Yeah.
Respond number
BBMP.
2, Pavan mailers.
Mr. Pawan is directed to take notice. First that Karthikeyan, print both the names, serve the papers on both the councils. List this matter tomorrow in the first list. Both the matters, 33 and 34.
Please.
Yes.
Cell number 35. Cell number 35.
That's suit for specific performance of sale agreement mailers filed by respondent mailers. The same was decreed mailers. Then mailers respondent filed execution.
For the defendant.
I am for the defendant in the suit mailers. Then mailers respondent filed execution petition mailers and filed application for appointment of court commissioner. Mailers court commissioner was appointed. Mailers draft sale deed was produced. Mailers as per decree mailers, the schedule is mentioned as 31 gundas. As per draft sale deed mailers, without seeking modification of decree mailers, they are mentioned 27.08 gundas. Accordingly, mailers, without given opportunity to JDR mailers, draft sale deed was approved and sale deed was registered. Now, mailers, the DHR mailers filed application for seeking possession. Application is allowed. Now, I have
They're not present at that time.
not our present mailers, council is present, but they are not served copy. As per Order 21 Rule 34, my lords, mandatory to give an opportunity to
When this
JDR.
happened?
Let's kindly come to my order sheet, my lords. Page 70, man, 75, my lords, 74. I've produced typed copy, my lords.
What is?
On 10/4/2026, my lords,
Hmm.
IA under order 26 to 19 filed by the
For the draft sale deed.
draft for appointment of court commissioner and draft sale deed, my lords. Then, my lords, the DHR, my lords, filed memo with RTC of draft sale deed. Then column. Then, my lords, the DHR heard the council and perused the record. The total extent available in survey number 111/5 is 27.8 guntas, and RR is filed. I support of the same. The said memo is accepted for draft sale deed. Then, my lords, they are produced draft sale deed.
So what are you doing on when this order is passed on 28/4/2026?
My lords, at that time, my lords, the council for JDR, my lords, present, but they are not observed, my lords. Meanwhile, my lords,
Now you are questioning this order.
now, my lords, I was challenging the order of the appointment of challenging the order of possession warrant, my lords. Possession warrant is issued,
Why
my
it
lords.
is bad?
Now, my lords, decree is, my lords, for 31 guntas. My lords, as per decree, my lords, the schedule.
No, you should have questioned this order dated 28/4/2026. That is the basis for this order.
Now, my lords, they are filed application for seeking police protection, my lords.
No, when you are supposed to question an order, you keep quiet so that the further proceedings will go on. When a matter
That
comes up at that
subsequently,
stage,
my lords, we have challenged the appeal, we have challenged the judgment and decree before the district court, my lords.
how many years delay?
No, no, my lords, it's just 3 months delay, my lords. 3 months, my lords. Meanwhile, my lords, the respondent, the petitioner, my lords, she was residing in the said premises, my lords. As per schedule, my lords, 31 guntas, they are mentioned schedule, entire 31 guntas, my lords. But the sale deed executed in respect of 27.8 guntas. Including my 3.5 guntas also, my lords, they are executed sale deed.
So you have no problem if they take position of 27.8 guntas.
No, my lords, that has to be rectified by.
That means it shows that you want to, like this way or that way, you want to delay the proceeding.
Let's before, my lords.
Now you are,
My lords, as per Supreme Court.
No, forget about Supreme Court. We'll go to Supreme Court later. No, according to you, you have questioned that judgment and decree. After that, you filed the execution. You filed an appeal at a later point of time. No orders are passed in the appeal.
Oh, my lords, last week, my lords, we filed appeal.
No, they have to execute the decree. Your only objection is so and so guntas is the original land. It says 27.08 guntas. Total extent is 27.08 guntas. What is the extent of that agreement?
31 guntas, my lords.
27 point?
31 guntas is total extent, my lords, which is decreed. Now, my lords, bypassing the decree, my lords, the sale deed is executed in respect of 27.8 guntas.
Come to the judgment and decree.
And one more thing, my lords, kindly issues, my lords, page 17, my lords. One issues.
No, we will not be deciding the legality of the judgment and
Not
decree.
that, my lords.
I just wanted to see what is the extent of land that is mentioned.
My lords, extent of land, my lords, the page number 38, my lords. Land bearing survey number 111/4 measuring 16 guntas and another bearing survey number 111/5 measuring 31 guntas.
So total how much? 31 plus 6.
31 plus 16, my lords, so 46 guntas, my lords. Sale deed, my lords, are produced at sale deed.
Draft sale deed.
Let's I have produced the sale deed itself, my lords.
What is the sale deed prepared after this order dated 20 in the month of April?
Sale deed is, my lords, annexure F, page 50, my lords.
28/4/2026. After this order, where is that document? 28/4/2026.
My lords, I have
For
not
draft
produced.
sale deed, where is the draft sale deed?
I have
And
not
what
read.
is the difference
Same extent, my lords. In the draft sale deed, my lords, they have produced 27 point, they have mentioned 27.8 guntas, which is clearly mentioned in the order sheet also, my lords. In the order, my lords, heard the council and perused the records, the total extent available in survey number 111/5 is 27.8 guntas. Accordingly, my lords, the draft sale deed was produced. Before that, my lords, they have to seek a modification of decree, my lords. Without modifying the decree, my lords, how can?
What is the original extent? That I'm not able to.
31 guntas, my lords.
27.31 guntas.
31 guntas, item number 115/5, 111/5, my lords.
The draft sale deed, you see. This is smarter. When
And-
do you want?
My lords,
I'm not convinced. Unless until you don't file the documents, what
but
are
the same is mentioned in the order itself, my lords. As per order, my lords, they are mentioned, draft sale deed, my lords, they are mentioned 27.8 guntas. Original decree is in respect of 31 guntas.
So according to you, less than that extent cannot be without.
My lords, as per schedule, my lords, they are not reduced. They are mentioned schedule entire 31 guntas, my lords.
Yes,
Now, my lords, if police protection is,
whatever is, there is a judgment and decree which is staring at you, which is not
my
suspended.
lords,
by
this,
the-
this is clear violation of,
No violation.
my lords,
Notice the
order
response.
20, order 21 rule 34, my lords,
It all be there.
they are not given opportunity, my lords.
What opportunity?
My lords, relevant judgment, my lords, Supreme Court has clearly held, my lords.
I'm not convinced. I'm not
Kindly,
granting-
kindly go through this
not
judgment.
granting any interim order. Take notice. Notice to the respondents.
Let's, if my lords permit, I will furnish the draft sale deed tomorrow, my lords.
Even after it is produced, it's all on technical grounds, you're coming before the court. Unless and until you obtain a stay of this execution, we will not stop.
Until, my lords, lords, notice has been issued, my lords, matter is listed 21st, my lords.
Petition is permitted to take.
Till that time, till such time, my lords,
Yes.
Cell number 36 urgent, 37, please read it off.
Yes.
Beg my lordships. Defendants are before this court. Written statement. I have come on record notes virtually in the end of 2025. Does your lordships go to page 25 for a
What is
moment?
IA?
Just permit me to file the written statement.
What is the delay?
It's around 1 year.
1 year.
1 year. 1 year, 2
Court is this?
City civil court. But the problem, my lords, is we have around 43 respondents, if your lordships have a look at it. And the suit notes is considerably old. I have.
Have you not filed the written statement for a
Notice
period of
this,
1 year?
I have explained, notice the problem is, this is pertaining to a urban land bearing an agricultural status. And these were Toti Inam lands, notice the Karnataka Village Officers Abolition Act governs them. Notice the history predates notice prior to 1900, to the 1908 Act. Now, notice half of these lands have been acquired for the formation of Hebbal flyover. And notice a couple of portions
Take
have.
out notice, once they come, we'll take.
Now, notice the case is at the stage of arguments. If
No, you don't file, you're a defendant, don't file the written statement, and why should we stay
Quite
the
right, Mr.
suit?
Could your lordship just see only 25 for one moment? I have extracted a table of the order sheet. I will not trouble your lordship beyond that. Now, my lords, I have come, my lords,
Why
only.
should we stay the suit of the plaintiff for you not filing the written statement? Tell me one good reason.
My lords, I have stated that I was not able to get the necessary documents. If your lordship sees the.
No, I'm not dismissing your writ petition.
I know, my lords. but
Once the respondents come, then
Now,
I'll
the
pass
whole
order.
problem is where are
There
the,
is no reason to stay their suit.
not their suit, but may I just point out, Mr. Or yes, I understand what your lordships are saying. Not let the arguments go on. It's at the stage of final arguments now.
You are waiting till the final argument.
Not, I have come only very late in the day at the course of
1 year back.
1 year back. Not when the defense cross-examination was going on.
Take out hand summons.
No,
That's also the petition is permitted to take out hand summons.
There are only
And
3 or
shall
4
file a memo.
contesting defendants. So to the contesting defendants and the plaintiff, may I take?
Whoever it is, you tell to whomsoever you want to take.
May
I'll
I
order.
request that I may take hand summons vis-a-vis the plaintiff is concerned, who is contesting against?
You can tell the court now you have to file a memo.
Please, not.
Who are the parties necessary and to whom the dispensation
Very,
can
very
be?
good. So I'll do that. I'll do that. In the interregnum, my lords, may I only request this. Let not the court post the matter for judgment.
No interregnum. I will take it up immediately on Wednesday, Thursday.
Your lordship was
notice
saying
they
the
will
next
come.
Wednesday. I shall be okay with it. I shall be okay with it.
So
Can
to
I-
whom it should be dispensed with?
Not, sir. I'll give a list so that.
Yes, so and so.
I shall give a list.
The notice to the petition is permitted to take out hand summons. If the memo is filed by 23rd of July, list this matter on 24th.
I'm grateful.
Yes, next.
Number 38, Keshav Kumar.
Petitioner in this case. Execution court's order on IA number 1, my lords. Ex parte judgment has been passed against me. What's happened is, my lords, I'm a trader of silk sarees. The plaintiff is a supplier to me. There is some delay in payment, it's a running account. 2 cases has been filed. One is 8 of 2024 and 9 of 24. Ignorance is that he thought it's only 1 case, 2 copies have come. We have appeared for 1 case. We did not appear for another case. The same advocates have filed, same plaintiff, my lords. The other case is gone for ex parte judgment. I suffered. Now, in the judgment, my lords, the interestingly is that though it's a running account outstanding, they've claimed for 47 lakh rupees is outstanding, but they have calculated 18% interest on a flat outstanding and claimed 90 lakh rupees.
What is impugn order?
Impugn orders, my lords, I had sought for stay. And of the miscellaneous that I filed before the court for recalling the ex parte judgment and decree. That impugn order, the judgment, ex parte judgment is pending in criminal miscellaneous petition. In the meantime, I also placed in before the execution court a stay for till the disposal of miscellaneous petition, my lords. Now, I had also filed a writ petition here. By virtue of writ petition, there is a stay. I was told to deposit an amount. I deposited more than the outstanding amount of 62 lakh rupees. All these things have been observed, and in the trial court, by virtue of the writ petition disposal, directed me to go and get the disposal of the application for stay. Stay is granted by the execution court, but with the condition that decretal amount fully in required to be deposited before 18th. That's what I'm agreed before the Honorable Court. The outstanding is 47 lakh rupees in odd. Now I paid 62 lakh rupees. The trial court wants me to deposit another 28 lakh rupees, which is the claim amount, which is an interest which is calculated and computed by the plaintiff without any agreement between me and the
What has happened to your execution or the miscellaneous?
even miscellaneous pending consideration, my lords. Even there is a stay.
Miscellaneous-
Trial is going on. Evidence is supposed to, as recorded, cross-examination is a stage.
If miscellaneous is state, where is the question of another order in execution?
It's not stayed, my lords. The application is still pending consideration. Even in that miscellaneous petition also, application is not disposed of. The trial court is in hurriedly proceeding to impose condition after condition. That's why I'm agreed, my lords. There is a good case in hand because only 40.
What was the impugned order?
Please.
There's so many orders. I'm
Please.
not able to understand which is impugned.
Impugn is annexure, my lords. The relevant portion, may I just take your lordship to para 6,
Page number,
17, my lords. Annexure is an impugn order. The JDR is a partnership firm. 17, page 17.
yes.
Para 6. Before which there is a case reference of 2 different cases, that is in para 5. But I don't want to trouble your lordship. I'll just take your lordship to the para 6. The JDR is a partnership firm, and it appears that the said firm is carrying on business.
I don't understand why this executing court should do all this exercise when your miscellaneous is pending
Absolutely, my
and
lord.
when your stay petition is pending.
That's exactly what I'm agreed by, my lords. The actual,
We'll say that this court, the trial court, the executing court has no business to grant this stay first.
my lords, but that is because of the writ petition before this directed me to directed the trial court to hear my application, my lords.
Where is that order?
The trial court,
In that case, your miscellaneous is not required. In the light of the order passed in the writ petition.
Writ petition just directed the trial court to dispose of the injunction application for stay of the proceedings of execution. The execution is stayed, but the condition that full decretal.
What I'm saying.
That's
when
right,
you
my
have
lord.
filed a miscellaneous.
Correct, my lords.
Staying the execution is before the miscellaneous court.
Absolutely, my lords.
Unless and until you obtain a stay, they will go ahead with the execution.
Absolutely.
Now, this court asked the executing court to decide your application, then your miscellaneous application need not be decided, your stay application. Because already executing court is granting this.
To the extent, yes, my lords. I agree, my lords. Not necessarily. Because the miscellaneous is now in trial. I've already gone to the box and then reduced evidence. They're on the cross-examination grounds. My only grievance is that it's a commercial court. I agree there's a requirement for me to commercially show my bona fides by paying the money. But the decretal amount is the question that I'm challenging. That is where the grievances comes, my lord. 18% flatly what claimed. If your lordship just see the pleading, I'll be able to satisfy what is the difficulty that I'm facing, my lords. Your lordship just peruse the judgment and decree para 16 minutes or even little bit better for 8 for the consideration, page 22 minutes.
Yes.
The trial judge holds that it is a running account by virtue of this observation. Para 8, that in pursuance of the goods received by the defendant who acknowledged the same with intention of clearing his liability towards the plaintiff, the defendant has.
The court must have looked at the amount as on the date of filing of the execution.
Absolutely.
You're referring to something which is on the date of filing of the suit.
No. The admitted fact is only 47 lakh rupees is outstanding. But the computation that the plaintiff stands before the court and says 90 lakh rupees is the claim in the prayer, not 47 lakh rupees, my lords. The court is blindly given the order 90 lakh rupees plus 18% till the from the institution of suit till realization.
No, I'm not convinced with this order itself, which is in your favor, half of it. Except for the stay, except for this amount.
Please.
The other is in your favor. I'm not convinced about both.
In turn, I'm suffering because it's a.
What is the business of the executing court to do all this? Your miscellaneous is pending.
Please,
You have to seek for the stay there.
I did. The difficulty was this, my lord.
That order is not passed.
No, my lords. What happened is I filed my miscellaneous. I filed the application. That the execution court was extremely in a hurry to pass the attachments.
It would pass.
It will, madam. I will not come in a way. That's the reason I came before this.
Executing court, no. Whatever is the condition imposed, you have to
What I
comply
did, my
with
lords,
that.
was this. In execution court, periodically I paid money to an extent of over 30 lakh rupees. The execution court was not satisfied. It wanted the full decretal amount. The dispute was only that about the only amount 47 lakh rupees was outstanding. And even today there is a running account which is going on, is what I was trying to say. But it was not stopping there. That's the reason I came before the writ petition, stayed with the condition, paid 25 lakh rupees. That amounted to 62 lakh rupees, above the outstanding amount. Now, as of today, my lords, 62 lakh rupees is already there. 25 lakh rupees is deposited before the bank. The rest amount is gone.
Any orders and not pass any orders in this. I will tell the miscellaneous court
Please.
to decide your IA. That is sufficient.
No, 18th is an order, impugn order saying that condition that I'm supposed to remit the decretal amount.
15th of which day?
This month, the day after. Day after tomorrow, minutes. I'm not here to waste time of the court's, my lords. I'm there to stand before the court. I'm standing before the court. The only requirement is that the judgment, if it is revived, because the running account, they have not calculated as per my dues is concerned, because periodically the invoices have been.
Set aside the entire order.
Let's.
Set aside the entire order of the executing court.
Set aside other than stay is granted.
No.
Condition, that is supreme.
I will set aside the executing court's order and I'll give you liberty to go before the.
Then execution court will not stop saying that you remit the entire amount. That's the difficulty.
Somehow I do not want to be party of this by saying that by reducing that amount. It is like this court is validating the order of the court.
My only request is this, my lords. Let the miscellaneous court hear my matter and then thereafter the execution court, let it be free, my lords. The only requirement is about the condition because the amount is already there. Except the decretal amount which is in my opinion erroneous of the trial judge. 47 lakh rupees admitted there is outstanding, my lords, but interest computation is the error, my lords.
No, you have invited this order from the executing court by coming to this court and telling the court to dispose of my petition before the executing court. You have filed a writ petition seeking that prayer. That's how the executing court has passed this order. Otherwise, it would have said, go before the miscellaneous court and there you deal with your stay application.
Nan first madidadu, miscellaneous was first filed. I filed the application before that court, which didn't consider at all. And it gave a long date to miscellaneous. I requested for clubbing both together and hearing the matter. It did not do. It was independently given.
Ask the other side to come on 17th and take it up here.
Please, my lords, please.
This is matter on 17th. Petition is permitted to take out handsome.
My lords, I'm sorry.
Respondent. And shall file.
My lords, I'm not.
Tomorrow is sir. It's on Monday.
Please, till such time, let me not precipitate the order, my lords.
The executing court is not is directed.
Highly please.
The respondent is directed not to precipitate the matter till Monday. List it in the first list.
I'll serve by hand, my lords.
Put hand summons and file a memo and by file a memo. But you list it on Tuesday. You shall file a memo by Monday and list the matter on Tuesday.
I'll serve by hand, my lords, to the council. Highly obliged.
Till number 39. Devraj HP.
Petitioner, that order which annexure E challenging, that permitting the third respondent come on record as a third respondent in the proceedings initiated.
Your lordship had yesterday fallen from your lordship that order of division bench is staring at my face. I'll let him to distinguish it. May I pass on this memo of citations?
You are a complainant.
I'm the complainant. I'm an affected party also, my lords. They are my neighbors, and that, my lords, is a crucial.
What is the ratio laid down in that judgment is the presence of the complainant is not at all necessary.
I'll distinguish that, my lords. Can I just show the circumstances?
None, there is no end to that litigation. For the authorities, even everybody, yes.
No, my lords, the issue is in that judgment, my lords, which your lordship, your lordships will find that judgment at page 44 of the memo.
Yes.
Mohammed Rafiq versus Commissioner. My lords, two factors which are important, my lords, in this judgment.
Read the particular paragraph.
If I may just give one background to this judgment. My lords, prior to this judgment, there were two judgments of this, the division bench of this honorable court itself, stating that impleading applications of the complainants can be allowed. And those two judgments were not considered in this judgment, my lords.
Is it a division bench or a single?
Division bench. Two judgments of the division bench. And
the latest judgment will provide.
I'll show. Thereafter, my lords, subsequent to this judgment of Justice B.V. Nagaratna, in a different case, presided again by Justice B.V. Nagaratna, it was brought to their attention that there were two judgments prior to the judgment which fell from your lordship yesterday. There, my lords, Justice B.V. Nagaratna would clearly observe, yes, there are conflicting judgments, and she would allow the impleading applications filed by the petitioners. Can I just show the second judgment, my lords, where she would observe that there are conflicting judgments by the division bench of this honorable court?
Yes.
At page 73, para 12.
Yes.
We have perused the judgments of the coordinate bench of this court. We have been referred to, which have been referred to by the respective parties. While in the case of Mohammed Rafiq, which was passed by Justice B.V. Nagaratna, coordinate bench of this court did not permit impleadment and the application seeking impleadment was dismissed by allowing the appeal. In the case of so and so.
Reading paragraph number?
12, my lords. 12. While in the case of Santesh Goreddy, another coordinate bench permitted the impleadment. Next, my lords, para 13. In the said circumstances, despite there being contrary judgments passed by the two division benches of this court referred to supra, there being an order of the Honorable Supreme Court permitting such parties who are complainants to participate in the proceedings before tribunals, we think it just and proper to follow the order of the Supreme Court dated so and so without entering into the correctness or otherwise of the judgments.
That in the para 14, that only intervener, not an employer that is as
in the facts of those cases,
that para 14 may kindly be. In the circumstances, the impugned orders of the land single judge is modified to the extent of permitting the first respondent herein participate in the appellate proceedings initiated before the tribunal as an intervener in such the three appeals not a party to the party respondent.
That was the facts of the case. I'll distinguish that as well. Subsequent to this judgment, there's another judgment of the coordinate bench which considers all the division bench judgments and allows impleading as parties, Manoj. That your lordship will find at page 25. And this is the judgment which the impugned order has relied upon.
25.
Page number 25, my lords, in the case of Shiv Prasad Navda. This, my lord, comes after all the aforesaid division bench judgments. It refers to the previous division bench judgments. It refers to several other judgments of the coordinate bench of this court. And, my lords, the issue at page 28, your lordships will find the issue with regard to whether, para 4 at page 28. The issue with regard to whether a complainant is entitled to be a party to the proceeding instituted pursuant to a complaint registered by the complainant.
Which paragraph you are?
Para 4, my lords, page 28. 28. Registered, the issue with regard to 28, my lords.
Running page.
My lords, the ink page, 28. Internal page 4.
Given the running page numbers also.
Yes, ma'am.
What is the number?
28.
20.
28. 28.
Yes.
28, para 4, your lordship gets it, my lords. From here, my lords, the operative portion starts. The issue with regard to whether a complainant is entitled to be a party to the proceeding instituted pursuant to a complaint registered by the complainant, albeit the proceedings between the owner of the property and the BBMP need not detain this court for long so and so. As the judgments of the apex court, division bench, and the coordinate benches of this court in plethora of cases have considered the issue and ordered that the complainant at whose instance the entire proceedings have emerged against an owner of the property is entitled to be a party of the party. Entitled to be a party to the proceedings before the tribunal. Manoj, there are 4 judgments which this judgment refers to. Manoj.
No.
But,
Intervener, party, that the clarification or distinction is made in the judgment.
no, Manoj. Here, Manoj, because Manoj, all the previous judgments hold that I can be involved as a party. Only one judgment which was passed by Justice Nagratna holds that I cannot be, which was again subsequently diluted by Justice Nagratna.
Yes. Heard, result. Yes, next.
If you're also reserving it, may file my objection.
Not expired. That's the only judgment. If you want to give your written arguments, you can give.
Right.
Orti Punit C for petitioner.
Give it within, give it by Monday.
Right.
Yes.
The defendant's writ petition as against the concurrent findings, my lord, by the trial court, my lord, in respect of 39 rule 1 and 2 application is concerned. My lord,
Appellate court's order.
please, my lord.
Come to the appellate court's order.
My lord, to the appellate court's order is concerned, please, my lord, it commences from page 83. My lord, from point number para 17, from para 17 to, my lord, para 23, the trial appellate court discusses, please, my lord, only the principles of the, my lord, of 43 rule 1R is concerned. My lord, from para 24 to, my lord, para 28, my lord, is the 4 paragraphs where the appellate court, please, my lord, has only discussed the arguments advanced by the plaintiffs and the defendants. At para number 29, please, my lord, it only extracts the relief which is being sought by the plaintiff in the prayer is concerned. Your lordship may kindly peruse. And thereafter, please, my lord, the trial court holds that there is no order of the impugned order passed by the trial court does not.
After that extraction of the prayer, what is?
Please, my lord, para 29. Please, my lord. The above said prayer clearly goes to show that the plaintiff was seeking injunction with regard to both the properties and their case is that when they try to put up construction over the suit properties, the defendant tried to interfere with their possession and not allowing them to construct the house. Therefore, looking from any angle, the order passed by the trial court does not suffer from any illegality or perverseness. Though there is no order of restraining the defendants from putting up construction over the plain scheduled property, and the recent filing of the IES by the defendants before the trial court goes to show that they have already filed IES restraining the plaintiff from putting up construction over the scheduled property. Hence, the question of considering the appeal at this stage does not arise is the finding of the appellate court.
Yes. What is that finding?
My lords, your lordship may kindly see the trial court order, my lords.
No, we'll not go to that yet.
My lords.
Is before this court agreed by appellate court's order.
Please.
What is the consideration by the appellate court?
Lords, appellate court has considered, my learned friend did not read those paragraphs. From paragraph 25 onwards.
Let's read.
24, ma'am.
Yes.
24.
Yes.
During the course of arguments, the counsel for the appellants argued that now by taking advantage of the order of injunction, the plaintiffs are putting up construction in the road which is used by the appellants to reach their property and also produce the photo show that the plaintiffs with the help of the JCB trying to close the road.
Before my learned
Para 25.
May I intervene and tell one fact, lords. The plaintiff is basing the claim on the basis of partition deed as well as the.
That's
Lords,
all.
I'll go.
I am on the point.
Yes.
What was the consideration?
My lords,
given
the
by
first
the
appellate
court?
court has considered.
If the appellate court considers it, we will look at it.
Lords, I just-
If it is not considered, we'll ask it to consider.
My lords, I'll just say one thing, my lords. Yeah, I'll read this.
And
My
one
lords,
point,
one
my lord,
second, one
one
second.
one para page, my lord, 90. My lord, the appellate court was at page 28. The last 4 lines, please, my lord, page 90, your lordship, internal page 17. Internal page 17, my lord, from last 4 lines. But when the defendant himself, your lordship got it, please, my lord. But when the defendant himself claims to be the owner of property based on the said partition deed, the question of he denying the ownership of the plaintiff number 2 of the Schedule B property does not arise. It is not my case, please, my lord, that there was a partition deed in my lord. That is not the contention urged by the defendants before the trial court. In fact, there is no partition. It was an oral partition. This partition deed, my lord, is in respect of the plaintiffs.
My lords, defendant is not denying my title at all. He only says in this property there is a road. Therefore, both the courts have held that there is not even a single piece of paper to show that there is road in the property of the plaintiff. My lord, plaintiff sued for permanent injunction. Suit as the trial court has granted temporary injunction. First appellate court confirms that order. Plaintiff bases his claim on the basis of a partition deed as well as a registered sale deed. There are 2 plaintiffs who are wife and husband. Plaintiff number 1 is the wife, plaintiff number 2 is the husband. So item number 2 property has been purchased under registered sale deed. Item number 1 property fell to the share of the husband under a partition deed. They are not disputing these documents at all. They say that in this property there is a road. If they say that there is a road in this property, they will have to establish. Now, in this light, if your lordship sees the finding of the first appellate court, it will make it clear. Your lordship may kindly take page para 25 of the first appellate court finding.
Yes.
From the materials available on record, it appears that the plaintiff respondent have produced the unregistered Panchayat Palparikat dated 15/3/1985, which goes to show that the present plaintiff number 2 was allotted suit schedule A property and a sale deed dated 15/12/2015 produced before the court goes to show that the present plaintiff number 1 purchased B schedule property based on which their names came to be mutated in MR so and so. The plaintiff have also produced the license issued by the concerned authority in favor of the plaintiffs for the construction of the house, which discloses that the said permission was granted in respect of suit item number 2 is concerned. According to the plaintiff before the trial court, their house is in dilapidated condition and it is difficult for them to reside in the said house as they decide to construct the new house. The plaintiff have also produced the photocopies which clearly goes to show the position of the house in old one and also in spite of lodging complaint, the defendants have not obeying the same. On the other hand, the order passed by the ADLR in DDLR so and so goes to show that the said appeal was preferred by the present respondent against the appellants and others wherein the ISA PODs have been challenged. Said appeals came to be allowed and ISA POD was cancelled. The ADLR were directed to conduct fresh POD in respect of survey number 136 with respect to position. As argued by the parties, it appears that there is no dispute with regard to the possession of the plaintiff or the suit properties. Your lordship may kindly mark this. As argued by the parties, it appears that there is no dispute with regard to possession of the plaintiff or the suit property. But the contention of the appellant defendants is that plaintiff are putting up construction by encroaching the road. But in support of the said contention, no material documents are produced by the defendants appellants. As argued by the counsel for the appellant, the ISA POD have been cancelled. Therefore, until and unless there is fresh survey or ISA POD is conducted, the question of causing interference to the road does not arise. During the course of the arguments, the counsel for appellants argued that the plaintiffs taking advantage of the order of the trial court with regard to interference is concerned are trying to construct the house on the property belonging to defendants. But the perusal of construction permission as produced by respondent, it is with respect to suit item number 1. According to averments of the plaintiff, suit item number 1 fallen to share of plaintiff number 2. ಅದು suit item number 2 ಆಗಬೇಕು ಸರ್. It should be it is
item number 1 only.
Number 2
it is item number 1 only.
Even the e-khata produced by the plaintiffs before the trial court clearly goes to show that plaintiff number 1 is in possession of item number 2 property. Though the counsel for appellants contend that there is no documents to show that one Lokesh acquired the Schedule B property under partition. Therefore, the plaintiff number 2 cannot be permitted to construct house in this said property. But when the defendant himself claims to be owner of the property based on the partition deed, the question of he denying the ownership of plaintiff number 2 or Schedule B property does not arise. Even in the IA number 1 filed by the plaintiff, they have sought relief.
What is the meaning of this sentence?
But there is this doesn't make the reading is the defendants have not categorically denied the partition deed. There was a partition between the forefathers of these parties. In that partition, he has got some properties. Therefore, when he has got some properties under that partition, he cannot deny this partition. That is what it means.
So you've made an analysis on what the
No, that's
court
because
wants to say.
because I have taken instruction, this is what it is. No, that's ultimately, my lord, at the end of the day, they should show what is their right. They concede that we are the owners. They concede that we are.
The court also should discuss it in a manner known to
I
law.
clearly understand, my lords.
So what is wrong with the order? What is the finding of the trial court? On what basis it has come before the court? Whether it can
Now-
be considered, nothing.
That is the reason, my lords. That is the reason I told your lordship the background. Without background, my lords, it is difficult. Now, if your lordship
With the
seeks,
background also it is difficult.
now if your lordship takes the trial court order, my lords, it is
So anyway, that is not in question here.
no, my lord, both.
That is true.
Both.
Because he has a right of.
Because
appeal
he is
there.
concurrent findings of the trial court as well as the first appellate
The
court. That
appellate
is,
court decided. I'll set aside this order and remand it
Please,
back.
please.
Please come. Agreed with the order passed in MA number 52 of 2025 by the additional senior civil judge and JMSC Kunigal dated 1st July 2026, whereby the court has affirmed the orders passed by the trial court in IA number 1, notice number 141 of 2025 dated 4th August 2025. But the principal civil judge and JMFC Kunigal, the defendant is before this court. The respondent herein has filed a suit for injunction.
yes.
Had filed a suit for injunction. And in that, the defendant has filed the plaintiff has filed an IA seeking interim injunction.
Page 22, my lord.
That seeking an interim injunction from interfering with the peaceful portion and enjoyment of the suit scheduled for A and B properties of the plaintiff till disposal of the suit. That came to be allowed by the trial court. While granting injunction, the court has observed that the existence of the prima facie case alone does not entitle the applicant for a temporary injunction. The second condition for granting interim injunction is that the balance of convenience must be in favor of the applicant. The court observed that the plaintiff have also filed joint undertaking affidavit by stating that in case of establishment of road over the A and B scheduled properties found illegal in the later stage, when they are ready to demolish the constructed house at their own cost. So on perusal of the rival contentions and position of either parties at this stage, the defendants have not placed any documents to show that their alleged right regarding use of said road, and even though they have admitted purchase of B scheduled property by the plaintiff number 1 and A scheduled property was allotted to her husband as per partition. And the court observes that the plaintiffs have shown prima facie case that they are in possession of the suit scheduled properties based on the sale deed and parikat along with revenue records, and they are entitled for injunction. The defendant has carried this in appeal, but the appellate court has dismissed the appeal by order impugned. Then counsel appearing for the petitioner submits that except at paragraph number end of paragraph number 29, the court has discussed, the court has observed that how the trial court was, it observed that the trial court was right in granting injunction. But in the entire order, there is no discussion about the contention that are raised and how the order passed by the trial court. Trial court is correct. In the light of the submissions made by the defendant were not at all discussed. Next paragraph. Then counsel appearing for the respondent, plaintiff submits that the court has rightly considered the contentions of the respective parties. He submits that at paragraph number 25, 26, and 27, from
25
paragraph 25 to 29, there is a discussion about the entitlement of the plaintiff for injunction and how the defendant could not make out a case. It is submitted that it is a well-considered order passed by the trial court, passed by the appellate court. And both the courts have concurrently held against the petitioner. And the petitioner is not entitled for any relief. It's for having other counsels on either side. Peruse the material on record. This court has perused the order of the appellate court and has rightly argued by the learned counsel for the petitioner, except except discussing about what are the ingredients for grant of injunction and also about the contentions of respective parties. The court on the face of it, the court has failed to consider the case of the defendant and how the appellate court had confirmed the order of the trial court. In that view of the matter, this court deems it appropriate to set aside the order impugned dated so and so, so and so. Remand the matter back to the trial court. The trial court, appellate court, and the appellate court shall consider the same in accordance with law within a period of, how much time it takes?
Lord, only 2 courts are there in Kunigal. It may take some time, Lord. Pendency of the cases.
Within a period of 8 weeks from the day.
Month, my lords, because order 41 rule 1 hour order. Not much to be discussed.
Within a period of 4 weeks, as expeditiously as possible, but not later than 8 weeks.
Please, ma'am.
Not to be prejudiced by the observation made.
Because I have not observed anything. Not observed anything. I only said.
Not to be influenced because your lordship.
Court has not expressed any opinion on the merits of the matter, and only any of the observations made by the court are only for the limited purpose of disposing of this petition. The court shall consider the applications in accordance with law.
Case number 41, Chidambara GS for petitioner, Ravi HK.
I appear for the petitioner.
Yes.
Yeah, please.
But this arises from a suit for specific performance. I am the plaintiff, I am the agreement holder, my lord. My agreement is executed in 2010. Lord, I have paid the major part of the consideration. Thereafter, my lord, I filed a suit in 2013. He is served, my lord, the defendant, vendor, my lord, he is served in the suit, but he chooses not to appear before the court. Thereafter, my lord, ex parte decree is also passed.
When was it?
2013. I'm sorry, 12/3/2014. 12/3/2014 is the decree, my lord. Thereafter, my lord, I file an execution petition. Lord, in the execution petition, he appears in person, my lord. Does not file any objections, does not do anything.
When he appears in the execution?
On 31/1/2015, he appears, my lord. It is recorded, the order sheet is there on record. Thereafter, my lord, under the execution, sale deed is executed in my favor on 20th July 2015. Possession is given on 17th August 2015. Thereafter, my lord, on 20th August 2015, he files, my lord.
Possession was given on?
17th August 2015. Sale deed is 20th July 2015. Thereafter, my lord, he files the application under order 9 rule 13, my lord, for setting aside the ex parte judgment.
When was that?
That was on 20th August 2015, after possession has been delivered to me. Lord, initially his application is rejected, but he files an appeal, and on 6/1/2020, my lord, the ex parte decree, my lord, is set aside. Now I'll have to show that to your lordship, but for the moment, just for narration of facts.
What is the impugned order now?
Now, my lord, the court has ordered under 144 to restore possession to him and set aside the sale deed, my lord, which was executed in my favor. So, my lord, these facts are required. And then if your lordship will kindly now see the MA order, my lord, at page 129.
This is impugned.
No, this is not the impugned order, my lord.
Where is impugned order?
The impugned order is at page 15. And the operative portion is at page 32, my lord. Defendant is entitled for cancellation of sale deed executed in favor plaintiff in respect of the suit properties.
Because the miscellaneous is allowed and the suit is restored.
Suit is restored. So my submission is twofold, my lord. One, my lord, it is not as if the decree, my lord, is set aside on merits, my lord. Lord, I'll show, my lord, I'll read 144 to your lordship. Secondly, my lord, even if my submission would be.
The judgment decree that is passed by the court. Now, if the ex parte order is set aside, means there is no decree in the eye of law as on today.
Correct. I concede to that. But the point is this, my lord. 144, my lord, it has been held is where when I take a benefit by a wrong order or an order which is set aside by a superior court or by the same court after further hearing the parties. Here, my lord, it is an order which is passed in his favor. That's why I wanted to take your lordship first to that order, because the court says, what is the problem if the suit is restored? It will be considered on merits. That is the exact words which are used in the thing.
No, forgetting.
There is
about
no
the-
finding.
No, forgetting about what the court said. You had your sale deed.
Yes.
Or whatever possession and all. It is consequent to the judgment.
Correct.
And
My
decree.
submission is.
When the decree itself is set aside,
Correct.
whatever the.
My
steps-
submission is that, my lord, if my suit is for dismiss for after trial, that is the stage when he can seek, my lord, under 144. If my lord, otherwise what happens in a specific performance suit? My lord? Now I have spent stamp duty, my lord. I have deposited the money in the court, and 10 years it has taken for him to, my lord, get the decree restored, set
things-
aside.
All these things you should have agitated in your, in that miscellaneous
CRP.
petition.
It has
when
been.
was, when it was allowed.
No, it was not allowed on the ground that, my lord, there was any, my lord, default in service of notice, my lord. If order 9.
Ultimately, fact remains his suit is.
No, that's why I'm request your lordship. I'm inviting your lordship to page
Because-
129.
No, even if I look at it also, it doesn't matter, whatever are the grounds that were recorded by the court, ultimately now the suit is restored.
Suit is
Whatever
restored, but the question arises.
The decree is set aside, whatever the steps that are taken.
No, that's why, my
consequent
lord,
to
then
the
will your lordship have section 144, my lord, which is extracted at page 22, my lord.
With your lordship's kind permission, may make one submission to save the time of this honorable court. But now the order as it made it very clear that writ petition is filed against the order passed under section 144 CPC. But this honorable court has already held saying that the order passed under 144 is a decree against which appeal lies and not the writ petition. That is the order of this honorable court. Kindly see. Therefore, my response submission is writ itself is not maintainable.
Yes.
It's a team decree under order 212. Same situation we have placed here.
Show me.
Sir, copy.
Section 2.
Some other day.
144, my lord, I saw section 22 definitely says it also shall be deemed to include the rejection of a plaint and determination of any question within section 144, but shall not include. So, my lord, your lordship may permit me to file a appeal.
The also the petition submits that. Against an order passed under section 144. Of CPC. The remedy available to the petitioner is to file a regular appeal, but not a writ petition. Hence, he may permitted to withdraw the writ petition with the liberty to file the appeal accordingly. The writ
Lord, your
petition
lordship may give me 30 days time, my lord, I will file it, but till such time, my lord, this order.
of direct, permitting the petition to withdraw the writ petition. And writ petition, the appropriate remedy shall be within a period of 1 month from the date of receipt of the copy of the order.
Lord, till such time, this order may not be executed. Because otherwise,
No,
sale
it
deed
is,
will be
no, it
successful.
is settled law. When the writ petition is not maintainable,
Correct.
the court can't pass.
Grateful.
order.
Cell number 42, VP Sukumar.
40.
Revision petition. Defendants 7 to 11. But the suit was barred by limitation. There is a relief. Kindly see page 36. Partition, they have said half share. Then thereafter declare that the illegal release deed.
Please come to your affidavit filed in support of the IA.
Yes, ma'am. I have said there is no cause of action. Court fee paid is insufficient. Suit is barred by limitation for adjudication of any purpose.
Where is that?
Page 25. I have specifically said that it's barred by limitation.
How?
But the release deed is sought for it being declared as
Paragraph is about
page
this.
36.
Page?
Page
No, no.
36, the relief claimed.
No, in your affidavit, which paragraph deals with this?
But in my affidavit, I have said at page 27, para 3,
Please read that.
I submit that the date of execution of the registered release deed 12/12/2013 by my father in favor of and in respect of the property, I have been in continuous possession and enjoyment of the same without any hindrance from anyone, knowing fully well of the said fact. Unnecessarily, the plaintiff has filed the above suit seeking relief as claimed therein. Apart from the same, there is no cause of action. Proper court fee is not paid by the plaintiff. Suit is barred by limitation, and suit filed by the plaintiff is liable to be dismissed.
Where is the plaint?
Beg your pardon?
Plaint.
Plaint is at page 32. Page 32. And in the plaint at para 7, this is what they have stated.
Declare that the plaintiff is absolutely entitled to half share.
That's one thing. Number 2,
Direct the scheduled property to be partitioned. Restrain defendants by permanent injunction.
yes, declare the illegal release deed
12/12/2013
is not binding on the plaintiff. Therefore, it's barred by limitation is what my
What about the other reliefs?
But the other reliefs are incidental insofar as it's concerned. The other relief that they sought is partition. But insofar as release is concerned, the total property is relinquished in favor of the plaintiff, in favor of the defendant. Therefore, the property is not available. Property,
What is the extent of the, what is the suit schedule?
the small property may not in the
17
schedule
guntas.
at page 35.
Yes.
17 guntas of land.
We'll hear the respondents,
In-
notice to the respondents.
Stay as sought.
Yes.
I appear for the petitioner. So in suit for specific performance. So in suit for specific performance, I'm the plaintiff before the trial court. During the course of cross-examination, the defendant counsel suggested about the financial capacity to purchase a property. So at the time of filing the suit, I was unable to secure the documents. Subsequently, I filed an application under 7 Rule 14A, seeking permission of the court to produce the bank statement as well as my retirement reliever to show my financial capacity.
It is of the year 2004.
2004, it was a decreed ex parte, my lord. Thereafter, the
Present stage.
for final arguments. Now, under 2012, it's an ex parte.
Why, after, at the time of arguments, why you want to place this on record?
I'll
What
bring
is
to
the
your
purpose?
lordship's kind notice. The suit was a decreed ex parte, my lord. Thereafter, in the 2012, the respondent filed miscellaneous petition. Only in 2024, miscellaneous petition was allowed. And on 2024, the original case was restored before the court. Subsequently, the LRs of the deceased defendant came on record. During the course of cross-examination, there was a suggestion about my financial capacity. So to prove
Out of that, now you want to place all this. Can you read it? Read the order of the court.
your lordship will kindly ink
Come
page.
to para 8.
It is not in dispute that the suit is of 2004. The plaintiff has already led his evidence and was examined as PW1. The defendant has examined DW1 and his cross-examination is completed. Thereafter, the matter was posted for final arguments and by order on 31/2026, the evidence was treated as closed. At the stage, the plaintiff has filed the present application. The application therefore filed at the belated stage. Under Order 7 Rule 14(1) of CPC, the plaintiff is required to produce documents on which she sues or relies at the time of presentation of the plaint. Sub-Rule 3 provides that document not produced along with the plaint shall not be received in the evidence without the leave of the court. The grant of such leave is discretionary and the party must satisfy the court that the due diligence the document could not be produced earlier. In the present case, the plaintiff has stated that when these documents came into his possession, why they were not produced along with the plaint, why
There
they were
is your
not.
affidavit. Affidavit.
para 3, my lord. I submit the DW1 as cross-examined in full, and during the course of cross-examination, my counsel assured some documents to establish the transaction in respect of the shoot shield property and attempted to confront through the DW1. Despite the knowledge of reality, the DW1 intentionally denied the said documents for the sake of denial. Moreover, the said documents are the part and parcel of the transaction that has taken place between me and the defendant. As these documents are very much necessary to establish the transaction, hence the same needs to be marked in my evidence. So because during only the course of cross-examination, my lord, the suggestion was put for regarding the final stance. That's the reason I was to produce.
Yes, dismissed.
Say number 44,
I sought for a interview.
Dismissed.
44, K. Rampart.
Petitioner, my lord, suit for partition, my lord, I had filed an application seeking rejection of the plaint on the ground that, my lord, the plaintiffs who, my lord, seek that they are the co-partners in respect of the ancestral property, my lord. The plaint averments itself disclosed that the scheduled properties was partitioned in the year 1999. My lord, in view of the bar under section 6 subclause 5 of the Hindu Succession Act, my lord, I sought rejection of the plaint which came to be rejected, my lord. Now I'm
Yes,
before you.
please come to the order.
My lord,
Please come to the order.
please, my lord. My lord, page number 21, my lord, wherein the reasons are there, para number 8. On let me read. On
Court
consider.
says you have not placed anything to show that this is barred under section 6.
My lord, admittedly, my lord, the pleadings itself disclose the compromise. If my lordship may go through the plaint, my lord.
Where is it?
My lord, plaint starts at page 26, my lord. Relevant portion at page 30, my lord. Relevant para 9A, my lord. I may read the para. The plaintiff submits that the plaintiff came to know the recitals of the written statement. The defendant one alleged in the written statement that he is absolute owner of the Schedule A property by virtue of compromise deed in compromise decree in OS 648.
Then counsel for the petitioner submits that when an application is filed under order 7 to 11, seeking rejection of the plaint, the suit is barred under section 6 of the Hindu Succession Act. The court, without even considering the pleadings in the plaint, in the plaint, just observing that nothing is brought to show that the suit is not maintainable under section 6 of the Hindu Succession Act. We submitted that there is no consideration by the court. Considering the same, there shall be stay of all further proceedings. Notice to the respondents. Petition is permitted to take hand summons, say, by 30th, if the memo is not filed, stays granted by this court, stands vacated. Next.
Cell number 45, K. Shivakumar.
The suit was filed for injunction, and in this said application, we filed our written statement, invoked 7 Rule 11 and 151 CPC. We brought to the notice of the court that the very suit itself is not maintainable, and brought to the notice of the court also on our application saying that there is already an alienation pertaining to the property. The entire extent of the property is not in possession of the plaintiff. The court rejects our application under 7 Rule 11. But the application seeking rejection is at page 27.
No, it is your case that the property is alienated.
In our possession, by virtue of a registered sale deed executed.
Basing on the plaint averments, how the plaint has to be rejected.
The plaint averments, as it could be noticed, what they contend is that they are having a rental agreement in respect.
So is it a case that it came up on the last occasion?
It came up, my lords wanted that
You said
whether
that
151
when
can be invoked.
The 151, then
Yes,
the law is
there's a
different.
judgment of the Supreme Court
Take that.
where 151 also can be looked into.
No,
Inherent
no.
powers of the court.
No, not that. You said generally order 7 Rule 11 written statement shouldn't be looked into. But when you file an application along with 151, then written statement has to be looked into. That is
Yes,
what is your submission.
that's my submission
Where is
also.
that? Where is the finding
But
of the trial court?
judgment, Beg your pardon?
Where the finding of the Supreme Court on that particular
That
aspect?
the Supreme Court in 2006, 3 SEC has come to some conclusions in regard to this. But kindly look at
So now in every application under order 7 rule
inherent
11,
powers.
no, order 7 rule 11.
Yes.
If they include 151, then the written statement can be looked into.
Not only that, 16 rule 6 also comes to the play. But the suit will have to be looked into whether there is a suppression of material fact.
No.
Not only that,
I remember this.
if it is
Now,
vexatious.
you are saying that defendant has filed the written statement stating that the properties were sold.
Yes.
Then I've asked you, that is not the case of the plaintiff. Then how under order 7 rule 11, the
Not,
court can reject it?
plaintiff
Your
has-
submission was.
Plaintiff
if
has also invoked 151 CPC, enabling the court to look into the truth of the matters which have been pleaded in the written statement.
That is what, now you have to convince the court
Yes.
that along with order 7 rule 11, if it is filed under 151.
Yes.
What cannot be done under order 7 rule 11 can be done under 151.
If I bring it to the notice of the court, please look into the written statement.
Please, the Supreme Court, where did the Supreme Court say?
But kindly go to para 10 of the judgment. The aforesaid findings clearly indicate that
Para number?
para 11, para 10.
Yes.
The aforesaid findings clearly indicate that order of the permanent stay of suit was made by the division bench not because the plaintiff is liable to be rejected on the ground. It falls within the parameters of order 7 to 11 of the code, or that the suit is liable to be stayed in exercise of power under section 10 of the code. Court has passed an order under 6 rule 16 of the code which has not been complied. The division bench in fact has exercised jurisdiction for stay of the suit as the plaintiffs did not disclose the forum selection clause where the Court of Calcutta had no jurisdiction, so and so. We'll go to para 11. Under 7 to 11 of the code, court has jurisdiction to reject the plaint where it does not disclose a cause of action, where the relief claimed is undervalued, valuation is not corrected within the time as fixed by the court, where sufficient court fee is paid in addition to the court fee not supplied with the period given to the court, where the suit appears from the statement in the plaint to be barred by any law. Rejection of the plaint in the exercise of powers under 7 to 11 of the code would be considered and the principles laid down. But this what a frivolous case, but I'll skip there a little more. This court has held that where plaint discloses no cause of action, it is obligatory upon the court to reject the plaint as a whole under 7 to 11 of the code, but the rule does not justify the rejection on a particular portion of the plaint. Therefore, High Court therein could not act under 7 to 11A of the code for striking down certain paragraphs of the High Court, could act under 6 rule 16 to strike out paragraphs in absence of anything to show averments in those paragraphs are unnecessary, frivolous, vexatious. That's what in ITC. But then go a little down below. This court has held that trial court can exercise power under 7 to 11 of the code at any stage the suit before registering the plaint or issuing summons to the defendant at any time before conclusion of the trial, and for the said purpose, averments in the plaint are germane. Pleas taken by the defendant in the written statement would be wholly irrelevant at the stage Poppet's case was followed. Therefore, court cannot compartmentalize, dissect, segregation, or inversion the language of the various paragraphs of the plaint. In such a course is adopted, it would run counter to the cardinal canon interpretations according to the pleadings has to be read as a whole to ascertain the true import. It's not permissible to cull out sentence or passage, read it out to the context of isolation, although it is a substance or not merely the form that has to be looked into. Pleadings has to be construed as it stands without addition or subtraction of the words, change its apparent grammatical sense. The intention of the party concerned is to gather primarily from the tenor terms of the pleadings taken as a whole. At the same time, it should be borne in mind.
I'm asking you about 151, not all that. This is all settled law.
Of course, this is settled down. What I may say, the application, if filed under section 151, but court can go into that aspect of the matter.
How can it be?
To find out whether that aspect can be.
The present writ petition is filed.
Yes.
The CRP is filed, agreed with orders passed in I number 2, whereby the court passed in I number 2 in notice number 948 of 2025 by the Principal Civil Judge and JMFC Anikal, dated 18th March 2026. The suit is filed seeking injunction restraining the defendants from disturbing the peaceful possession, enjoyment, and occupation of the plaintiff's scheduled property, or from dispersing the plaintiff from the scheduled property, either by the defendant or by the henchman. In the said suit, IA number, the present IA is filed, that's IA number 2, and order 7 to 11 to reject the plaint, along with the, in the, in support, in the affidavit filed in support of the IA, it is stated that
I have stated insofar as unregistered rental agreement. I have also stated
there is a page number.
Page 29, para 3, para 5. I have stated that they are strangers to the petitioners.
It is stated that the plaintiffs are strangers to the defendant.
I also said that there is
How the defendant,
documents to show that they are in possession of the property
and
by.
it is the case of the defendant that they are in possession of the property. And there is no cause of action for the plaintiff to file the suit, and the suit has to be rejected. That came to be dismissed by order impugned, wherein the court has observed that the plaintiff in the plaint stated that defendant number 1 is the owner of the property. Defendant number 2 is the SPA holder of the defendant number 1 in respect to the suit scheduled property. Defendant number 2 executed the lease agreement dated 30/2/2025 in favor of the plaintiff in respect of the suit scheduled property. On the strength of the said lease agreement, the plaintiff said to have been inducted into the scheduled property, and she is in possession of the same. And to protect her possession, she has filed the present suit for permanent injunction. Under these circumstances, the court cannot say that there is no cause of action and accordingly dismiss the petition. When counsel appearing for the petitioner submits that in the written statement, they have clearly stated that there is no relationship between the parties. They are in occupation of the property. And considering, and as said, there is no cause of action for the plaintiff to file the suit. And the court has to consider all these aspects. It is a contention of the learned counsel for the petitioner, defendant, that if an application is filed under order 7 to 11 read with 151 CPC, the court has to look at the written statement and pass orders. It is submitted that the court has failed to consider the contention that has raised in support of the written statement. Next, we are having other counsel for the petitioner. What was the material on record? The suit is filed for injunction. The plaintiff has made out a case stating that he is in possession of the property and seeking an injunction restraining the defendants and their men from interfering with the property. All the grounds that are stated by the defendant are matter of trial, and in fact that is the case of the defendant in the written statement. It is settled law that under an application is filed under order 7 to 11, court will look at the plaint and the documents filed along with the plaint, but the court will not look at the written statement or any other contentions raised in support of documents in support of the same. And the submission of the learned counsel that if an application is filed under 151, court has to look at the written statement in an application under order 7 to 11. If it is in that case, everybody can file an application under order 7 to 11 along with 151 CPC in the considered opinion of the court. That is not the settled law, and the submission of the petitioner has to be rejected. In the considered opinion of the court had rightly considered and held that the court cannot look at the amendments in the written statement for considering an application under order 7 to 11, and it rightly dismissed. This court finds no reason. Yes, next.
Till number 46, GB Dar.
My lord, kindly have it in Monday.
Then
Kindly have it on Monday.
This is matter. Monday it won't come. This is matter on 12th of August. Yes, 47.
till number 47, Nasim Officer,
Yes.
petitioner.
I may be permitted to appear with the petitioner's counsel. Lord, the revision petition by defendant number 7. Suit is one for partition and separate possession. May I permit it, maybe I may be permitted to pass on the theological plea.
Take that.
Lordship may kindly see As per the averments of the plaint, when Giriyappa is the propositus, he had a son by name Chikkasadanlappa. He had two daughters and one son, C. Muniyappa. Nagamma is the mother of plaintiffs 1 to 9. Admittedly, as per the Nanjamma, other daughter died issueless. Defendants 1 to 4, who are my vendors, they are the sons of Muniyappa, the brother of plaintiff's mother. Where admittedly, as per the averments of the plaint, there has been a registered partition in 2001 between Chikkasadanlappa and Muniyappa. That has been referred to in the partition in the plaint itself, which is saved under proviso to order section 6 of the Hindu Succession Act as amended. In this background, the application for rejection of plaint was. Yes, Milord.
So what is the, come to the prayer?
Milord, suit is for, kindly see the prayer, Milord. Milord, kindly go to page 33, Milord. In
Suit
page
for
33.
partition and separate portion.
Yes. Then second prayer, Milord.
To declare
Declare.
the partition date dated 31/2001.
No, this is the document which is
In the
sought to be
office
set
of the
aside.
sub-registrar is not binding on the share of the plaintiff.
Yes. Plaintiffs are the children of the daughter.
Children of
Daughter of the kindly see the genealogical tree. Nagamma's children are the plaintiffs. There is a, according to the plaintiffs.
Please come to the order.
Yes, madam. The court says because there is they have pleaded fraud. Fraud vitiates everything. So the application for rejection of plaint cannot be considered. That is one aspect of the matter. Second aspect of the matter is because in the plaint they have averred that their properties are belonging to they have a right in the properties. Plaint cannot be rejected. Kindly see the relevant paragraphs, madam.
Is it your case that the earlier partition was by playing fraud? Their case is that the earlier partition was
a
partition
fraudulent
deed
document.
was executed by then that has to be decided.
Well, my only submission is this. Ultimately, admittedly, there is a registered partition between the grandfather of the plaintiffs and his son, who is my vendor's father. So there was a registered partition of 2001. And now they plead, and the mother does not even file, she dies in 2021. And immediately after her death, the children file a suit. Mother never challenged the partition.
Then comes to the petitioner submits that when the petitioner has taken a plea that in the light of section 6 of the Hindu Succession Act, the suit is barred by limitation, the suit is barred. This aspect was not considered by the court. Considering the same, there shall be stay of all further proceedings, notice to the respondent, hand summons and memo shall be filed by 30th, or else a stay granted with this. We'll take up, we'll complete the 49.
Cell number 49. 49.
What I put 48.
48. Cell number 48. Sidramaya.
Challenging the order passed on IA filed by defendant number 3 for rejection of plaint. Page number 27 may kindly peruse me that the schedule in the plaint. It is a suit for declaration. Page number 27.
Yes.
It is a suit for declaration for survey number 23/2 measuring 1 acre 4 guntas. Page number 23 may kindly peruse at page number, the para number 3 of the plaint.
No, what is it is on what ground? You can tell the court.
My lord, for two reasons I have filed this IF for rejection of plaint. One is the plaintiff themselves have pleaded in the plaint. There is a series of transactions in between the defendants for survey number 23/2. In para number 3 of the plaint says that plaintiff themselves has partitioned the property for survey number 23/1. From 1963, there are continuous sale deeds, there are survey maps and survey sketches. Now they want to declare that they are the owner of survey number 23/2 instead of 23/1. Even their partition deed says that they are the owner for survey number 23/1. Defendant sale deed right from the year 1963. There are 4 transactions, even according to the pleadings of the plaint.
Come to the order.
Para number 23 may kindly peruse. They themselves have pleaded. They have entered into a para number 3 of the plaint. They themselves have entered into a partition for survey number 23/1 in the year 2002. My lord, para number 6 may kindly peruse, my lord. After several years, they want to declare that they are the owner of survey number 23 instead of survey number 23/1. Para number 6 also may kindly be seen, my lord. There are 4 transactions.
Then counsel for the petitioner submits that there are several contentions raised by the petitioner, how the suit is, how the plaint has to be rejected. And counsel has drawn the attention of the court to the order. And in the entire order, the court has failed to consider any of the grounds raised by the plaintiff, raised by the defendant. That's of the matter. Stay.
49.
That notice to R4 to R10 may kindly be dispensed.
4 to 10 dispense with give the
I'll file memo.
notice to 1 to 3. Yes, 49.
Case number 49, Sidramaya VP.
Appearing for petition, my.
I appeal for the respondent.
My lord, this is arises from SC 1740 of 2019, a suit for eviction of the property.
Interim order by this court.
My lord, interim order of stay has been granted by this honorable court. That
Stayed, your lordship.
records also needs to be secured, my lord.
No, but how can there be an interim, what is the order of the court?
My lord, eviction of the petition from the possession of the property.
That's the only order.
That is the only one.
Let's see.
My lord, page number 28.
It's order that the defendant shall vacate and hand over the vacant portion within 2 months from the date of decree.
Yes.
There shall be a
Records also
separate
needs to be
inquiry
secured, my lord.
which are rent damages.
Yes.
This is when is this order passed?
My lord, it was passed on 4/4/2026. Records needs to be secured, my lord.
My lord, he is not depositing the rent. In fact,
No, we
the
have
order
paid up
is
to date
very
rent.
clear. Yes,
We have paid up to
I
date
don't know,
rent.
my lord. He has to serve the copy. As long as the matter was pending before the small causes court, he was serving the memo. But
Yeah,
now
rent
OAS is pending, there is no problem for him to serve a copy. Even there, he doesn't come, she doesn't come lead evidence anywhere. She doesn't come here, she doesn't come there. As I submitted last time before your lordship, she has taken the court for granted. There is a direction matter. She doesn't pay heed to
My lord,
it.
I am furnishing the
Applications
details
after
regarding
applications.
deposit of rent.
Registry is directed to call for the trial court record. List this matter at 2:30 on 12th of August.
That I am furnishing document regarding deposit of rent.
12th of August. It is a contention of the land counsel for the respondent that the petition is not paying the rents. It is for the land counsel for the petitioner submits that they have paid the rent up to date.
I am
The
furnishing
document
copy
shall be
regarding deposit.
Counsel for the respondent and also shall be filed before this court. The
Yes.
order earlier granted is extended. Call the. Which one? Not taken.
Case number 6. 50.
By order dated 26/11/2024.
For the respondent, my lords.
CRP number 733 of 2024 is disposed of by this court, directing the trial court to dispose of the matter expeditiously. Within a period of 1 year from the date of order. Now the letter is addressed by the learned judge seeking extension of time. Seeking an extension of another 3 months' time, considering the reasons stated. Another 3 months' time is granted for disposing of the suit as per the earlier order passed by the court. It is made clear that no further time will be granted. Next matter also.
Next matter, maintainability.
51.
Case number 51, Tajia Tabasam.
My lords, with respect to maintainability of the CRP and compliance.
Huh?
Maintainability and compliance, office objections for first time. I'd like to submit on maintainability. My lords,
Impugned order.
the impugned order is order on IA number 7 with respect to the court fee being insufficiently valued.
How can you file a CRP against that? You have to file a writ petition.
My lords, I'm not specifically challenging that half of the order.
What
but
is that? Whatever you're challenging, why it should be a CRP? The office objection with regard to the maintainability is upheld. Petition shall file a writ petition. And the writ petition, the CRP is dismissed as withdrawn, giving liberty to the petitioner to file a writ petition within a period of 2 weeks from the date of receipt of the copy of the order. The office shall return all the documents by keeping yes.
Till
52.
230,
50, next month also.
till number 52. Till number 52.
Appeared for my petition, will have to pray for 2 weeks time to comply with the office objections.
Maintainability.
I mean, I also, on the same day, will submit after complying with LAD.
Listed after 4 weeks. Yes, 53.
Till number 53. Non-compliance of
Appearing for the petition, my lords, I kindly seek 2 weeks time, my lords.
Yes, this is matter after 2 weeks. Yes, 54.
Till number 54. Ravi HK.
But in this case, against the common order on 3 AS blood, writ petition is common, writ petition is filed.
Oh,
But
what are
separate
those?
court fee is paid.
No, what are those IAs?
IAS were to bring them on record as legal representatives and also an application for conditional delay. Right? All the applications are dismissed.
Set aside abatement.
All the applications filed them.
The office objection with regard to the maintainability is overruled. This is
And
matter
notice
for-
may be ordered, well, say.
Notice to respondents.
One is
Emergent
deputy
notice.
commissioner, maybe that, one is deputy commissioner, I'll take notice.
One
Be
ACA
directed to
takes
serve
notice.
copy.
For the other respondent.
1 to 4, 1 to 4.
Tahsildar.
3.
One is deputy commissioner, others I'll have to, I don't have the.
Also you appear.
Tahsildar you can take,
Please.
Allah.
Yes.
I do not have the copies, I'll take.
Respondent 1 and
Lord, 1 to 3, he can take note.
1 to 3. 4 is.
Sorry, 1 to 4 Tahsildar.
1 to 4. Yes.
Other respondents, emergent notice.
What the
Emergent
other
notice, emergent notice in respect of other respondents.
View that. View the file.
They're private.
1 to 4. What is this Basveshwara Devaru represented by Tehsildar?
Tahsildar.
Tahsildar.
It's a temple.
1, 2, 3, 4.
Yes,
AGA takes notice.
yes,
5 to
10.
5 to 10.
Emergent.
Emergent notice. Yes,
Blood,
miss.
may I request for interim order, blood?
Without hearing, I will not grant interim
Yes.
order.
No interim orders or hand summons.
Yes.
56.
Can I take hand summons?
Well,
blood?
55.
Summons.
Oh, hand
In
summons.
addition, hand summons also permitted.
Right.
Yes, 55.
55.
My lord, for respondent, my lord.
You appear?
Yes, my lord.
So
But
and so submits that he has instructions to file wakalat
yes,
on
my lord.
behalf of.
Yes, my lord. Kindly adjourn the matter for 2 weeks. She is not in a stage.
You are appearing for whom? Which
Respondent,
respondent?
my lord. We are going to undertake that matter.
How many
There's only one
respondents?
respondent, my lord.
So and so counsel submits that he has instructions to file wakalat on behalf of the respondent.
Adjourn the matter for 2 weeks, my lord.
Lord, the
have
matter
interim order?
before the trial court, it's on 21st, my lord.
You have an interim order?
No, there is no interim order.
This is matter on 20th, on Monday? Yes,
Till
57,
number 56.
56. List after service of notice.
Interim order may be extended.
Interim order earlier granted is extended. Yes, 57.
57.
I appear for the.
Tomorrow minutes. Tomorrow minutes.
Yes, tomorrow in the first list. Yes, next. Please.
Till number 58. Till number 58.
For the petition, order 1, rule 10.
Non-compliance of office objections. Office objections
It has
have
been done,
complied
it has been done, it has been done.
within a week. List after complaints of office objections. Yes, 59 notice,
59.
notice.
Till number 60.
Yes. Which one?
Serial number 60. My lord, the interim order is granted.
It
Now
will
I-
be, all these matters will be there in the list tomorrow.
Please,
Yes,
as your
six-
lordship.
60
May I request
tomorrow.
for Monday, my lord?
Huh?
Monday or Tuesday, my lord. Tuesday, my
Wednesday,
lord.
Wednesday.
Please.
Wednesday, 60, 61.
I appear for the response.
61.
Look at it, interim order, wherever it is there. 61.
61.
My lord,
Ajay
execution
Kumar.
proceedings have been stayed.
In which case?
61. I appear for the respondent.
Again, number 2 of 25 is filed seeking
For the
early hearing.
petition.
This is matter on 30th of July.
Interim order.
Till number
Interim order earlier granted is extended. 62.
62. Manu K.
This matter, this matter on,
My lord, I am appearing for the petitioner in this matter, my lord. 62.
yes, yes.
Ma-
Where is the respondent?
Vinay Swami C. Chandranatha Riga.
List this matter. Not tomorrow. List this matter on 23rd.
Lords,
In the-
may I
in the
request for
first list?
interim order may be extended, my lords.
Interim order earlier granted is extended. Yes, 63.
Till number 63. Mahesh Kiran Shetty.
Petitioners in this case, your lords. The matter may be kept tomorrow, your lords. The senior is on his legs, your lords.
It's a writ petition of 2025. What is the urgency?
Your lords, it's a
Rectification of office objection for, that's what it is listed for.
Yes.
Office objection shall be complied with within a week. Is 64?
Serial number 64.
Ma'am, in the suit for partition, I'm seeking a stay. In the suit for partition, the defendants filed a written statement along with an
The
agreement.
2025 writ petition, now I will not grant stay.
No, ma'am, it is actually, after this court issued notice, they move an amendment application which alters the basis of this writ petition. Can it please be
That you have to
taken?
question that.
I have filed objections there, ma'am. This concerns a forged document being produced in court.
Stay, just like the stay will
Ma'am,
not be granted.
page number 79.
Matter tomorrow, let it be in the list. Is 65?
Serial number 65. Serial number 65. Vivekananda N.
My lords,
Give
they
some
have
other
filed
date.
application for
They have
vacating.
filed the application.
This is
my
the
lords. Can you
matter.
have it tomorrow, my lords? There is
Tomorrow not
urgency in the
possible.
matter, my
List it
lords.
on 29th of July in the first list.
Serial
Great.
number 66.
All matters which are adjourned from the first list should come in the first list. Interim order earlier granted is extended. 66.
66. Yes, Vidya.
Lordship, appear for respondent.
This also, interim order extend. I'll list it on 28th July in the first list for vacating the interim order.
Serial number 67.
Appear for
Jagan Mohan.
respondent 5 to 6.
Yeah, this also the same thing.
My lord, in this case, already final decree has been drawn in the year 2015. Unnecessarily they obtained the same, my lord, I'm not able to take the.
No, they have obtained, now I have to vacate it.
Yes, ma'am.
Yes.
Tomorrow, my lord.
Oh.
My lord, in view of.
No, please understand, every day 40, 50 new matters are coming up. How
In this
can I,
case-
all vacate, 6,000 vacate petitions, how can I hear?
My
So you
lord,
have
in
to, you have to accommodate the court.
Yes, ma'am.
Yes,
My lord,
60,
on behalf of sisters, my lord, my brothers are not allowing to us.
yes, 68.
For the petitioner, your lordship.
When it is.
My lords, I appeal for the respondent. my lord.
date
The
may fix on
urgency
Monday, your
is
lordship.
that, my lord, tomorrow, my lord, the Supreme Court has granted my lord, the order.
Yes,
the-
so I remember that
Please,
every
my
time
lord.
we
I
don't have to
cannot
repeat
execute
it.
the order of that status.
Is this
quo, my
matter
lord.
on Monday in the first list?
Great.
No, let it be tomorrow. Let it be there.
Tell
in
us,
the
maybe
list.
listed on Monday, your
You
lordship.
can't ask her every time, court will not accommodate you. It's tomorrow.
Grateful, my lords.
69.
My lords appear for the respondent in the matter, my lords.
It's appear for the petitioner in this matter, my lords. Let's see if the matter may be taken up tomorrow, my lords.
This in the first list tomorrow.
My lords, our objections are ready. I may be permitted to file the same in the registry, my lords.
Yes, 70.
70. 48%. Maitra.
I'm the GPA.
I 2 and 3 for
I've
permission to
given
allow
to-
GP of the petitioner in the court proceedings and office note. I'll hear it tomorrow. List this matter tomorrow.
So actually,
Is
madam,
this final hearing?
this case is,
Huh?
this case is, last week, I have withdrawn this case on 8/6. 8/6, because yes, the respondent number 1 has filed a petition, filed a memo before the DRT on 8/4 that the account has been closed. And the payment, basing on that, I have given the appeal. In appeal, I have given the appeal.
Earlier also you appeared.
Yes.
You are a GPA holder.
In
We'll
both the
see.
cases, I have appeared, madam.
We'll see tomorrow. Yes, 71.
Final hearing.
Responding none other than my industry. She should take over the handle.
Let it be in the list. In the first, yes.
230 mood.
Yes.
Serial number 1. Chinmay G. White Ward.
Electricity
For
matter.
petitioner.
It has been disconnected day before yesterday pursuant to a letter at Annexure A, page 13.
VV
No
Patil.
final order has been passed. My lord. I was asked to get an NOC
Yes,
from
yes.
BBMP.
Any final order passed on the show?
No final order.
Then why did you disconnect the power?
We have been issued a notice to him. They have to file an.
Correct. He has not given. You have to file a pass a file.
They have been not filed an objection regarding to the show cause notice.
So if they don't file, you will disconnect. Then counsel for the petitioner submits that. The respondents have disconnected the power supply without following the due procedure, without passing any order. Then counsel appearing for the respondent.
BB Patil.
Huh?
BB Patil, 1 and 2.
Mr. So submits that. When a show cause notice is issued, they have not filed their, they have not filed their reply to the show cause notice, since they have disconnected. And the petition, the respondents, without even passing an order, not have disconnected the power supply. In that view of the matter, there shall be a direction to the respondent to forthwith restore the power supply. They shall file their objections if any, when
Next week.
is this matter on 4th August in first list? Yes,
Cell number
Obliged. May I
2.
request for hand delivery of the order, my lord, because last time.
he's there, he will inform.
Yes, my lord, what had happened last time, my lord, they had communicated. There, they asked for.
5 o'clock, you move the court and you say.
I'm
that
obliged.
Hand delivery should be done.
I'm obliged.
Yes, next.
Number 2.
Much obliged. Lords, in the FDP proceedings, my lords,
Huh?
in the FDP proceedings, my lords,
Not
respondents were placed ex parte.
When is, where is the impugned order?
Impugned order is in page number. Page number 82, my lords. The respondents were placed ex parte. On the very next date of hearing, they have come up with the application under section 2 of Partition Act. And on the next date of hearing, that application came to be allowed and it is ordered for auction tomorrow, my lords. Only,
You were set ex parte.
my lords,
When you were set ex parte,
my lords, just before the application was,
is a date for that?
my lords, on 4/12/2025, I was placed ex parte, my lords.
Then what were you doing from 4?
My lords, the notice was not served to me, my lords, in person. It was not served to me. Only when the,
Will come to your house and serve the.
no, my lords, only when the court commissioner auction notice was served to me very recently, my lords.
Who are you? You are not a party?
I'm the party, my lords.
You are a party to the suit or not?
Suit, I'm the party to the suit also, my lords.
Oh.
I am also the shareholder. Respondents has 3 shares and petitioner has 1 share, my lords.
Oh.
We are ready to buy the share of the petitioner. We have also filed affidavit before the trial court stating that we are ready to buy the share of the petitioner. Either by way of land, he wants 300 square feet will be registered in.
You filed the application.
My lords, 2 days back, my lords. But that application was not considered and is posted for tomorrow for hearing, my lords. Tomorrow is only the auction, my lords. Their only intention is to auction the property and the dignity of the family has to be.
No, your intention is to stall the proceedings.
No, my lords, I'm ready to settle them.
Had you been ready, you would have contested it without without saying that so nobody has come and given me notice at my home.
My lords, the settlement talks were going on, my lords.
All between the family members and you.
We are ready to settle the share of the petition.
Do go before the court and do
Yes,
it.
my lords, tomorrow auction is there, my lords. The entire dignity of the family will be lost, my lords. 40 years they are staying in the same.
Be bothered about the dignity of the family when the matter is coming up before.
Lords, since 40 years they are staying, my lords. We are ready to settle either by way of land or by way of money, my lords. Tomorrow the auction, very recently I got the notice from the.
Recently, what did you say in your petition? When did you come to know? How did you come to know?
2/7/2026, the court commissioner served the notice to me, auction notice to me.
File this petition.
3/7, I advanced the case and I filed the wakalat.
Filed the petition on 15/7/2020.
Yesterday, my lords. I advanced the case on.
What are you doing from 2/7 to now?
I filed the recall application before the trial court also, my
When?
lords. Recall application was filed.
File the recall application. Keep quiet, just like that, come to the High Court, file
No, my
some
lords.
petition a day
On
before.
14/7/2026, I filed the.
2 to 14, what are you doing?
My lords, I filed wakalat and there was no talks, settlement talks were going on, my lords. That's what I.
Do not want to stall any of the court.
My lords, at least the auction will maybe at least postpone, my lords.
Why should it be?
I'll settle the share of the petitioner. Whatever share value he asks, I'll settle for that, my lords. Because only my intention is that the dignity of the family should not be lost by auctioning the property. That's all, my lords.
This has become a very, this is a
I have,
practice here.
my lords, before the trial court also, I have undertaken to whatever the share value he is fixed. I'm ready to share, my lord.
To the court just one day before, nice, waiting for the, so that the court will have no other option but to stall the proceedings.
No, my lords, not like that, my lords, but very.
Whatever the submission that you are making or wrong, I'll impose exemplary cost.
Definitely, my lords. Yes, my lords. I agree, my lords.
And for granting the stay also, I'll grant the stay on cost of rupees 10,000. Otherwise, I'll not grant.
Kindly nominal cost may be.
No, 10,000 you pay, I grant cost.
Yes,
I mean, I'll grant the stay.
I'm ready to pay.
Then counsel for the petitioner submits that. Tomorrow is the auction. Is one of the sharer and he's ready to pay he's ready to buy the share, but the property is put to auction. He was set ex parte and he has already filed an application to set aside the ex parte order and that is pending consultation. It is a submission that if the court proceeds with the execution, that would cause a lot of hardship to the petitioner, considering the fact that the petitioner rights are involved. This court deems it appropriate to stay the auction. However, considering the lapses on the part of the petitioner, the stay is granted on the condition that the petitioner shall pay 10,000 rupees to the respondent defendants. Respondent, you are the
I am the respondent in the trial.
freeholder. Yes.
The petitioners, my lords.
May I seek my lord's indulgence, my lord? Second list, 13th matter.
Now, all that the court officer will give.
Lord, I seek indulgence, my lord. It has to get listed with another connected matter, my lord. I leave the number with the court.
Give her. She will. I have
Yes.
instructed her what to do. She will, whatever you ask, she will consider and
Yes.
will
Your Lordship,
accordingly ask.
Your Lordship, list 2, serial number 22, Your Lordship.
Notice and hand summons.
My lord, serial
Your
number
Lordship.
48. My lord, serial number 48, my lord.
Madam, list number 2 ನಲ್ಲಿ
ಚೀಟಿ ಕೊಡ್ರಿ ನೀವು.
ಇಂಪ್ರಿಮೌಂಟ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಸರ್.
Court officer. Court officer. Court officer.
Court officer, one request in serial list 2, serial number 21.
Court officer.
Court officer.
ಮೇಡಮ್ ಮೈಕಲ್
Court
ಕೇಳಿಸ್ತಾ
officer.
ಇಲ್ಲ, ಮ್ಯೂಟ್ ಆಗಿದೆ.
ಮೇಡಮ್ ಕೇಳಿಸ್ತಿಲ್ಲ, ನಾವು ಮಾತಾಡ್ತಿರೋದು ಕೇಳಿಸ್ತಿದೆ ಮೇಡಮ್. Court officer.
Court officer.
Court officer, please
ನಾಳೆ
respond.
ಅದು 22 ಲಿಸ್ಟ್ 1 ಬರುತ್ತೆ ಅವತ್ತು ಬನ್ನಿ. ಅಲೋ ಸರ್.
Serial number list 2, serial number 22. ಇದು ಎರಡನೇ ಸರಿ ಲಿಸ್ಟ್ ಆಗ್ತಿದೆ ಸ್ವಾಮಿ. ಇದು ನಾಳೆ ಅಥವಾ ಏನಾದ್ರು ಮಾಡ್ಬೋದಾ ಅಂತ ಇದು.
ಅದೇ ಸರ್ ನಾನು ಹೇಳಿದ್ನಲ್ಲ ನಿಮ್ಗೆ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಇತ್ತು ಅಂದ್ರೆ ಯು ರೈಟ್ ಆಲ್ ದ ಡೀಟೇಲ್ಸ್ ಹೌ ಮೆನಿ ಟೈಮ್ಸ್ ಇಟ್ ಈಸ್ ಲಿಸ್ಟೆಡ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್ ಅಂಡ್ ನಾಟ್ ರೀಚ್ಡ್ ವಾಟ್ ಈಸ್ ಯುವರ್ ಅರ್ಜೆನ್ಸಿ ಎವ್ರಿಥಿಂಗ್ ಯು ರೈಟ್ ಇಟ್ ಇನ್ ದ ಮೆಮೋ ಅಂಡ್ ಹ್ಯಾಂಡ್ ಇಟ್ ಓವರ್ ಟು ಮೀ ಟುಮಾರೋ at 10:30. I will place before the lordship. Then date will be assigned. Madam urgent note madam note bit ಕೊಡ್ತಾರೆ dates ಆ dates post ಮಾಡ್ತೀನಿ. Now today I will assign the dates as per the instructions. Today I will be assigning all for all matters dates. If you are having extension, you should advance it.
Madam, entry order extension. Serial number 14, list 2.
Interim order ಎಲ್ಲೆಲ್ಲಿ today ವರೆಗೂ existence ಅಲ್ಲಿ ಇದೆ. If it is in existence till today, such matters interim order will be extended.
Okay. Serial number 29, madam. Serial number 29 ಒಂದು ಲಾಸ್ಟ್ ಟೈಮ್ 9ನೇ ತಾರೀಕಿಗೆ ಇತ್ತು. ಅದು ಮೇಡಮ್ ರಜಾ ಇದ್ರು ಅಂತ ಹೇಳಿ ಅದು ಬೇರೆ ಕೋರ್ಟಿಗೆ ಹೋಗಿದ್ರು. ಅಲ್ಲಿ ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿಲ್ಲ ಮೇಡಮ್. ಅದನ್ನ ದಯವಿಟ್ಟು ನಾಳೆ ಹಾಕೊಳ್ಳಿ ಮೇಡಮ್.
ಅಲ್ಲ ಇವ್ರೆ ನೀವು ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ ಅಂತ ಅಂದ್ರೆ ನಾವೇನ್ ಸರ್ BM Arun sir, I will place it your matter tomorrow. So you when the matter is listed morning 10:30 you gave a memo. What is your urgency stating that?
ತಿರ್ಗಾ ಮೆಮೊ ಕೊಡ್ಬೇಕಾ?
ಬೆಳಗ್ಗೆ ಕೊಡ್ಬೇಕು. ಇವತ್ತು ಕೊಟ್ಟಿದ್ರಾ ನೀವು ಮೆಮೊ ಸರ್?
ನಿನ್ನೆ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅದಕ್ಕೆ ಹಾಕಿದ್ದು ನೀವು.
ಅಲ್ಲ ಮಾರ್ನಿಂಗ್ ಇಟ್ ಈಸ್ ಲಿಸ್ಟೆಡ್ ಇನ್ ದ ಲಿಸ್ಟ್ ಅಲ್ವಾ?
ಹೌದು.
ನಿನ್ನೆ ಕೊಟ್ಟಿದ್ರಿ. ನಿನ್ನೆ ಕೊಟ್ಟಿರೋ ಮೆಮೋನ ನಾವು ಅದನ್ನ ಚೇಂಬರ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ. ಅದು ಯಾಕೆ ಅಂತಂದ್ರೆ ಡೇಟ್ ಅಸೈನ್ ಮಾಡ್ಬಿಟ್ಟಿದೀವಿ. ಬಿಕಾಸ್ ಇನ್ ದ ಎಂಡ್ ಯು ಕೇಮ್ ಅಂಡ್ ಸಬ್ಮಿಟೆಡ್ ಆಫ್ಟರ್ ಇಸ್ ಲಾರ್ಡ್ಶಿಪ್ ರೈಸಸ್. ಟುಮಾರೋ ಮಾರ್ನಿಂಗ್ ಬೆಳಗ್ಗೆನೆ 10:00 ನೀವೇನಿದೆ ಅರ್ಜೆನ್ಸಿ ಲಿಸ್ಟೆಡ್ ಇನ್ ಲಿಸ್ಟ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಇನ್ ಸೀರಿಯಲ್ ನಮ್ಗೆ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ಕೊಡಿ. ನೀವು ಅದನ್ನೆಲ್ಲ ಡೀಟೇಲ್ಸ್ ಫುಲ್ ಬರಿಬೇಕು.
Okay.
I will repeat it tomorrow.
Okay.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 29 ಒಂದು ದಯವಿಟ್ಟು ಮೇಡಮ್. ಅದು ಮೇಡಮ್ ಅವತ್ತು ರಜೆ ಇದ್ರು ಅಂತ ಹೇಳಿ ಬೇರೆ ಕೋರ್ಟಿಗೆ ಕೊಟ್ಟಿದ್ರು. ಅಲ್ಲಿ ಏನು ಆರ್ಡರ್ಸ್ ಮಾಡ್ಲಿಲ್ಲ ಮೇಡಮ್. ಅರ್ಜೆಂಟ್ ಅಂತ ಬರೆದಿದ್ದಾರೆ. ದಯವಿಟ್ಟು ಅದರಲ್ಲಿ ಇಂಟ್ರಿ ಆರ್ಡರ್ಸ್ ಕಂಟಿನ್ಯೂ ಆಗಿಲ್ಲ ಮೇಡಮ್.
ನೋಡಿ ನೀವು ಫಸ್ಟ್ ಫಿಸಿಕಲಿ ಯು ವೆರಿಫೈ ದ ಆರ್ಡರ್ ಶೀಟ್ಸ್ ಬಿಕಾಸ್ ಇಟ್ ಈಸ್ ನಾಟ್ ಅಪ್ಲೋಡೆಡ್. ಬೇರೆ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿರ್ತಾರೆ. ಇಟ್ ಸ್ಪ್ಲಿಟ್ ಅಲ್ಲಿ ಬ್ರೇಕಪ್ ಆಗೋಗ್ಬಿಟ್ಟಿದ್ರೆ ಅವ್ರ ಕೋರ್ಟಲ್ಲೂ ಮಾಡಿರಲ್ಲ, ನಮ್ಮ ಕೋರ್ಟಲ್ಲೂ ಮಾಡಿರಲ್ಲ. ನಮ್ಮ ಕೋರ್ಟಲ್ಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿ ಅವತ್ತೊಂದು ದಿನ ಬ್ರೇಕಪ್ ಆಗಿತ್ತು ಅಂತ ಅಂದ್ರೆ ನೀವು ಸಬ್ಮಿಟ್ ಮಾಡಿ. ನಾನು ಮೇಡಮ್ ಹತ್ರ ಹೇಳ್ಬಿಟ್ಟು ಇನ್ನು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿಸ್ತೀನಿ. ಬಟ್ ನೌ ಇಟ್ ಈಸ್ ನಾಟ್ ಪಾಸಿಬಲ್ ಟುಡೇ ಬಿಕಾಸ್ ಇಟ್ ಈಸ್ ಆಲ್ರೆಡಿ ಅದು ಇದಾಗ್ಬಿಟ್ಟಿದೆ, ಬ್ರೇಕಪ್ ಆಗಿದೆ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್. ಹ್ಯಾವ್ ಯು ವೆರಿಫೈಡ್ ಯುವರ್ ಆರ್ಡರ್ ಶೀಟ್ ಸರ್?
Serial number 14 list 2 madam. Entry order extension.
ದಯವಿಟ್ಟು ನಾಳೆ ಅಥವಾ ಮಂಡೇ ಹಾಕೊಳ್ಳಿ ಮೇಡಮ್. ನಾನು ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀನಿ ದಯವಿಟ್ಟು. ಅದು ಲಾಸ್ಟ್ 10 ಟೈಮ್ಸ್ ಬಂದಿದೆ, ರೀಚ್ ಆಗಿದೆ.
ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ತೀನಿ ಕೇಳಿ ನೀವು. I will assign the dates as per the instruction of the lordship. Whatever the urgency it is there, you write a memo on 10:30 you hand it over. We will place it before the lordship and madam will only give the dates for such matters.
Madam, list 2 serial number 14 entry order may be extended.
ಇವ್ರು ಹೇಳ್ತಾ ಇದ್ದೀನಲ್ವಾ ನಿಮ್ಗೆ ಎಷ್ಟು ಸತಿ ಹೇಳ್ಬೇಕು ಇವ್ರೆ. ಇಂಟ್ರಿ ಮಾಡ್ರು ಟಿಲ್ ಟುಡೇ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ಅಲ್ಲಿ ಇರೋದೆಲ್ಲಾನು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಲ್ವಾ. Till today, if the interim order is in existence, such matters IO will be extended.
Madam, party in person may make one submission. Madam, serial number 14 last time other side nam intimation ಮಾಡ್ದಿರನೆ ಡೇಟ್ ತಗೊಂಡ್ರು. ಸೊ ಈ ಸರಿ ಏನಾದ್ರೂ ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್.
ನೀವು ಮೆಮೋನಲ್ಲಿ ನಿಮ್ ಡೀಟೇಲ್ಸ್ ಎಲ್ಲ
ಮಾಡಿದ್ವಿ ಮೇಡಮ್. ಮೆಮೋ
madam, matter did not reach. That's why date was assigned. Let him not make false submissions.
It is not a false submission. It is recorded in the live stream. I will show you. Court officer has told me that you have taken a date. Please, I will put it in a writing. You can make your objection. I will put it in the next memo. I will make a submission in a memo.
Now what you want in that?
Madam, what has happened last time interim order ಕೋರ್ಟ್ ಗೆ ಫಾಲ್ಸ್ ಸಪ್ರೆಷನ್ ಆಫ್ ಮೆಟೀರಿಯಲ್ ಮಾಡಿ ತಗೊಂಡಿದ್ದಾರೆ. ಐ ವಿಲ್ ಮೇಕ್ ಎ ಮೆಮೋ. ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್. ಇಟ್ ಈಸ್ ನಾಟ್ ಲಿಸ್ಟಿಂಗ್ ಅಟ್ ಆಲ್ ಫ್ರಮ್ ಲಾಸ್ಟ್ 4 months.
Sir, it is getting listed.
That's what I am telling, sir. As per the instructions of the lordship, I will assign the dates today. I can't hold the matters. Morning, whatever the urgency. Morning, whatever the urgency is there for you, you write it in detail and hand it over the memo. I will place them same before the lordship.
Okay, madam. Thank you, madam.